您现在说话啊，我听到了，听得到，还挺清楚的。嗯，好的。嗯，哎，我这里是调我的机器就行了，是吧？我这里要切频道，那观众呢？啊，我用这个机器切就行了，是吧？哦，我这里不用管它，是吧？啊，王老师，我现在在中文频道了。啊，能听到，能听到，很清楚。好的。好好好，谢谢王老师。嗯嗯，哦哦，那挺好的。嗯嗯嗯。哦，哦，声音的，还麻烦你们了。嗯嗯好，谢谢。嗯，拜拜。
今天的会议即将开始，请各位来宾入座，并将手机调制成静音。Today's conference is about to start. Please take your seats and put your mobile phone on silent. 尊敬的各位领导、各位来宾、女士们、先生们，大家早上好！欢迎大家来到由中国南海研究院、华阳海洋研究中心、浙江大学海洋法律与治理研究中心共同主办的南海的历史与法律学术研讨会。此次会议正式开始。Distinguished leaders, guests, ladies and gentlemen, good morning. Welcome to the workshop on history and law of the South China Sea, co-organized by the National Institute for South China Sea Studies, Huayang Center for Maritime Cooperation and Ocean Governance, Zhejiang University Center for Ocean Law and Governance. Today's conference is officially start now. 首先，请中国南海研究院院长王胜先生致辞。First, let's welcome Mr. Wang Sheng, President of National Institute for South China Sea Studies. 然后我就 Thank you, Mr. Wang. 谢谢王院长。接下来有请华阳海洋研究中心理事长、中国南海研究院学术委员会主席吴世存理事长致主旨演讲。Next, let's welcome Dr. Wu Shicun, Chairman of Huayang Center for Maritime Cooperation and Ocean Governance, Chairman of the Academic Committee of National Institute for South China Sea Studies, to deliver keynote speech. Thank you, Dr. Wu. 谢谢吴理事长。 现在有请北京大学社科，现在有请北京大学人文社科系，不好意思，现在有请北京大学人文社会科学研究院荣誉访问教授安东尼·卡蒂主旨演讲。Now let's welcome Professor Anthony Cardi, Honorary Visiting Professor at the Institute of Humanities and Social Sciences at Peking University. 谢谢卡蒂教授。Thank you, Professor Cardi. 现在是合影及茶歇时间，请大家移步至大堂。我们的议题一将于10:10正式开始。It's time for group photo and coffee break. Please move to lobby. We will resume at 10:10 with the discussion of panel 1. Now we will start with the first panel of the day, Sovereignty over Nanhai Zhudao. First, let's welcome the moderator of this panel, Ms. Teresa Chen Yuehua, arbitrator of the International Center for Settlement of Investment Disputes. Ms. Chen, please. Now we will have the second panel of the day, the political and legal implications of archival records. First, let's welcome the moderator of this panel, Professor Shen Guchao, Deputy Director of the Collaborative Innovation Center of South China Sea Studies at Nanjing University. Professor Shen, please. It's time for a coffee break. Please take a short rest. We will resume at 4 p.m. with the discussion of the third panel. Now we will start with the third panel of the day, re-evaluation of the South China Sea Arbitration Award. First, let's welcome the moderator of this panel, Ambassador Yi Xianliang, former ambassador of China to Norway. Ambassador Yi, please.
Hello，Hello，Hello，Hello，Hello，Hello，Hello，Hello，Hello，Hello，Hello，Hello，Hello，
哇，这网是不是有点太差了？红了都。
那个蒋老师在调，应该是啊。蒋老师，您再说两句，您那个声音有点小。我现在在中文频道。哦，可以了，可以了，比刚才声音好多了。不，现在可以了。然后您那个，嗯，哦，好的。哎，好了，英文频道。嗯，可以的，可以的，可以。您现在听我声音还小吗？哦，好的，好好，谢谢。好，拜拜。哦，讲。
领导、各位来宾、女士们、先生们，大家早上好！欢迎大家来到由中国南海研究院、华阳海洋研究中心、浙江大学海洋法律与治理研究中心共同主办的南海的历史与法律学术研讨会。Distinguished leaders, guests, ladies and gentlemen, good morning. Welcome to the workshop on History and Law of South China Sea, co-organized by the National Institute for South China Sea Studies, Huayang Center for Maritime Cooperation and Ocean Governance, Zhejiang University Center for Ocean Law and Governance. Now the conference officially open. 首先，有请中国南海研究院院长王胜先生致欢迎词。First, please welcome Mr. Wang Sheng, President of the National Institute for South China Sea Studies, to deliver welcome remarks.
各位喂，有声音吗？啊，好的，谢谢。各位专家学者、各位领导、各位同事、各位新老朋友，大家早上好。首先呢，我代表中国南海研究院，感谢大家应邀出席本次南海的历史与法律学术研讨会。我呢今天用中文发言啊，这个给大家准备了同传的耳机啊，所以大家呢，我因为在座有很多这个境外来的学者啊，所以呢，为了方便大家能够这个更好的进行分享和交流，我们给大家准备了同传的耳机啊。回顾南海历史，作为最早发现、命名和开发利用并持续和平管辖南海诸岛的国家，中国对南海诸岛拥有无可争辩的主权。早在2000多年前的秦汉时代，中国人民就开始在南海航行。在长期的伸展实践中，中国人民发现并开发利用南海诸岛。根陆部等各种文献以及考古文物鲜明记录了上述历史。历代中国政府不仅将南海诸岛汇入版图，而且实施了天文测绘、军事巡航等主权行为，这些都是中国历代地方志、官方地图及其政府组织编写的官方文献等可以佐证的。南海作为国际航道，其历史不仅延续在中国人民的耕海牧渔生产活动之中，也留存于世界各国人士对南海的见闻之中。近代以来，西方国家的航海文献、地图、海图以及国家档案等众多资料中，记载了中国开发利用管辖南海诸岛的悠久历史。英国国际法学者安东尼·卡蒂教授去年出版了一本关于南海历史与档案的著作《南海的历史与主权》。安东尼教授通过查阅大量英国、法国和美国19世纪末以来有关南海诸岛所有权问题的国家档案，发现中国对南海诸岛的主权主张有充分的历史和法理依据，西方国家也认可这一事实。然而，尽管中国在南海的主权和历史权利不容否定，但是 近年来，部分南海争端国和域外国家为了达到全面否定中国在南海的主权和海洋权益主张的目的，采取歪曲历史事实、片面选择性的解读国际法，以及故意掩盖事实真相等手法，在多边国际场合以及国际舆论场上推介自己的主张，讲述他们所谓的南海故事。在刚刚结束的第21届香格里拉对话会上，菲律宾总统马科斯声称，联合国海洋法公约和南海仲裁案均承认菲律宾的合法权利，是菲律宾南海政策的基石。本月14号，菲律宾又单方面向联合国大陆架界限委员会提出了涉南海外大陆架划界的申请，其范围可能涉及中国南沙群岛和中国主张管辖的海域，严重侵犯了中国的海洋权益。2013年1月，菲律宾阿基诺三世政府单方面就中菲有关南海争端提起强制仲裁程序，而所谓南海仲裁案的仲裁庭错误适用法律，罔顾事实，越权管辖所做出的有失公正的裁决，对地区国家通过和平谈判解决争议的努力，对中国和东盟国家推动南海各方行为宣言框架下的海上合作，对正在进行的南海行为准则磋商等地区共识所产生的负面影响不容低估。纵观全球海洋争端的解决，我们深知，要妥善解决南海争端，强加于任何争端一方的解决方法都是行不通的。当事国间的磋商谈判才是切实可行的正道。中国南海研究院作为研究南海问题的智库，未来将继续加强涉南海历史、法律、安全和政策研究。我们将继续深入挖掘和展示中国对南海诸岛主权的历史依据和法理研究，为南海地区的和平、稳定与发展贡献我们智库的力量。本次研讨会以南海的历史与法律为主题，为大家提供了一个广泛交流的平台，为今后在座的各位专家学者进行长期的交流与合作奠定了一个良好的基础。我十分期待在今天的这个会议上能够听到各位专家学者的真知灼见，也希望各位呢都有满满的收获。我在这里呢也预祝本次南海历史与法律研讨会取得圆满成功。我在这呢还要给大家说明一下呢，因为我今天下午呢要去北京出席一个重要的会议，所以下午呢就不能和大家一起呢这个来听会。但是呢，我们研究院的其他的班子成员还有许多研究人员呢会和大家一起呢参加下午的研讨。我的发言就到这，谢谢大家。
谢谢王院长 ，Thank you, President Wang。现在有请华阳海洋研究中心理事长、中南海研究院学术委员会主席吴世存理事长致主旨演讲。Now welcome Dr. Wu Shicun, Chairman of the Huayang Center for Maritime Cooperation and Ocean Governance, and Chairman of the Academic Committee at the National Institute for South China Sea Studies, to deliver keynote speech.
好，谢谢志雪。好，尊敬的郑若华大律师、卡蒂教授、女士们、先生们、朋友们，大家早上好。我也代表主办单位之一，欢迎大家出席本次规模不大，但是 确实是一次重要的学术研讨会。我想围绕本次会议的主题提出一些我认为是值得思考和研究的问题，也供后面的3个专题讨论参考。进入21世纪以来，南海争议逐步演变成为一个全球性的热点问题。这一方面表现为部分声索国此起彼伏、难以遏制的海上单边行动，以及少数域外国家无事生非、别有用心的强行介入南海争议和在南海问题上选边站。另一方面，国际舆论、学术界也开始出现刻意歪曲南海历史和恶意抹黑中国南海权利和主张的一些奇谈怪论。这些著作、报告或论文，或是断章取义地利用中国学者既有的南海历史研究成果，或是以偏概全，否定中国在南海享有的历史性权利，或是通过第三方机制裁定南海断续线没有法律依据，进而否定中国对断续线内的资源的开发利用权利，甚至把中国在南海的正当维权行为描述为海洋帝国的扩张。这个典型的例子，那就是在2020年7月13号，当时的美国国务卿蓬佩奥发表的国务卿声明，当时正是仲裁裁决出炉4周年的时候，他其中提到中国谋求在南海建立一个海洋帝国。这些谬论和偏见和伪南海历史，即鉴于美国国务院发表的海洋界限报告等官方文件，具有代表性的2014年的美国国务院的143号文件，再一个就是2022年的150号海洋界限文件，同时也体现在菲律宾南海仲裁案的所谓裁决之中，但更多的带有系统性和颠覆性的言论和观点，这是散见于一些所谓南海问题学者的中英文著作之中。近年来，一些西方学者违背历史事实的研究成果和声索国的伪造史料和地图，因为西方出版社和台湾繁体汉语出版机构的加持与放大，在国际上形成了较为广泛的学术和舆论的负面影响。其负面影响不仅在于对支撑中国南海诸岛主权和海洋权益的历史证据进行全面的诋毁和选择性的歪曲，这些所谓的研究成果又反过来被一些声索国别有用心的用来援引为其本国的非法的南海主张辩护和背书。如果我们还原南海历史真相，就不难发现，这些所谓经过学术逻辑论证的言论和观点，只是部分南海声索国以及美国等国际上一些国家为达到全面否定中国南海权利主张历史及法律基础的目的，为实现自身在南海的地缘政治利益或合法化其单方面非法主张及行动而刻意杜撰的南海历史和虚假认知。我们还应该看到，随着一些南海声索国与域外势力在南海研究的历史与法律问题上的合作日益紧密，中国在南海问题上面临的人质战、舆论战、法律战日益严峻。回顾我国的南海历史研究，老一辈学者的辛勤耕耘，虽然留下了大量的史料和研究成果，但是也难免存在一些局限和遗憾。这些局限和遗憾，我把它归纳在以下几个方面。第一， 研究的视角和方法创新不足，没有能够与国际南海研究的前沿领域对标或者接轨，特别是忽视了南海历史学和南海问题的基础性研究，以及南海国际话语体系的构建。第二个方面是史料的挖掘不够充分和全面，尤其是对近代西方航海文献和海图、近现代西方国家档案等第三方史料的挖掘利用，存在拓展和提升的空间。卡迪教授的研究成果就证明了这一点。另外，我记得在2012年，昨天晚上刘晓明省长和曾若华大律师和卡迪教授共进晚餐的时候提到，就是很多史料我们应该挖掘。他其中卡迪教授提到了日本的史料，这使我想起2012年我到日本去进行学术交流的时候，日本共同社的一位研究南海问题学者，他就告诉我，他说他查到的日本的官方档案解释了为什么1952年日本和台湾当局当时中华民国根据1951年的旧金山合约签了一个日华合约。那么在日华合约，因为旧金山合约里面没有提日本放弃西沙群岛、南沙群岛的权利主张及名誉，但是没有提由谁来接收。那么1952年的日华合约仍然没有提交还给中国，所以当时日本官方研判，他认为共产党的中国迟早要统一台湾，所以今天在这个日华合约里面明确了把西沙群岛和南沙群岛交给台湾，那就如同交给共产党的中国。所以日本官方也有大量的史料，所以我讲史料的挖掘还有很大的挖掘的空间。第三是国际上故意扭曲或带有误导性的涉南海历史研究，未能及时有理有据和持之有恒地进行消毒和批驳。第四是历史研究与法律研究没有能够进行有效的融合与创新，有时甚至相互割裂，甚至相互矛盾。南海叙事构建和话语权建设是当前及今后中国有效维护南海权益的不可或缺的组成部分。从历史和法律视角还原南海问题产生的背景，记录某些周边国家侵占中国南沙群岛的历史真相，以及美国南海政策演变。美国曾经中立过，但现在美国的南海政策是全面选边站，也就是无论哪一个国家只要在南海与中国对抗，侵犯中国的权利，美国就会支持谁，这就是美国在南海问题上选边站，不再中立。同时对近年来西方舆论和学术战略界不断炒作的所谓中国改变南海现状、中国不遵守联合国海洋法公约、南海断续性和西沙群岛沿海地形是过度的海洋伸缩等叙事进行有说服力的回应，并且聚焦战后国际条约对西沙、南沙主权归属中国的秩序安排，南海仲裁裁决的谬误和瑕疵，为南海认知史陷阱、海洋法公约至上论、历史性权利已经为公约所取代等宏大叙事。有一种学术观点比较流行，认为中国加入联合国海洋法公约以后就放弃了在南海的历史性权利。其实这一观点是不正确的。我们看一下国际仲裁庭在1998年厄立特里亚和也门的裁决案当中就可以发现这一点。当时的仲裁庭就认定厄立特里亚和也门在红海的南部海域的许多世纪以来的捕鱼和航行活动创设了某种历史性权利， 它没有这2个国家，任何一个国家都没有正式通知或者公开声明享有这种权利，但是仲裁庭仍然裁定这2个国家在红海的南部享有历史性权利。所以从这个意义上讲，历史性权利它是一项远古的权利，它源于延安国在漫长的历史演进过程当中对海域的开发与利用。历史性权利的取得不是基于公开宣告或正式通知，而是历史上不断累积的资源开发和管理行为。最后呢，我希望我们以本次会议为契机，进行南海历史集体记忆的重塑和南海问题国际认知的构建。我想这应该是当代中国历史学研究者和国际法学者的共同使命。谢谢大家。
谢谢吴理事长 ，Thank you, Dr. Wu。在进行下一环节之前，温馨提示：本次会议将全程 YouTube 直播。Before the next speaker, here's a warm reminder: this conference is live streaming through YouTube. 现在有请北京大学人文社会科学研究院荣誉访问教授安东尼·卡蒂致主旨演讲。Now let's welcome Professor Anthony Cardi, Honorary Visiting Professor at the Institute of Humanities and Social Sciences at Peking University. Welcome.
So, good morning, all of you. It is a great honor for me to be making a presentation today, and I will try to keep to the time. And the objective of my paper, which is within the rubric of this session, International Law and History, is to outline some of the main features of this little book, The History and Sovereignty of the South China Sea Islands, and then to draw some concluding theoretical observations. And I hope to be able to finish them before 10 to 10. Obviously, the features which I will highlight are being rather simplified in order to clarify the issues. And at the same time, they will be boring for many of you who have already read the book. The first point I want to make is that the main characteristic of the history of the South China Seas between 1900 and 1979 is the intervention of outside powers, France and Britain, in the region. Britain had been there since the so-called First Opium War, resulting in the 1842 Treaty of Nanjing, followed by the treaties of 1858 and 60, giving it sovereignty over Hong Kong Island and Kowloon. The French were in competition with the English and intervened in the Kingdom of Annam in 1874, setting up a protectorate agreement, which they claimed gave them exclusive representation of Vietnam, or Kingdom of Annam as it then was, abroad. This was in competition with Britain. In 1900, the United States comes on the scene, suppressing Philippine independence movements, and took over from Spain. It was also envious of Britain. The records show that both France and the United States are competing with Britain, which was there first. The Japanese were hovering in the vicinity and trying to find a way to move into the region. They were to be a driving force against both the British and the Chinese. The French and the Chinese. Now, point number 2, pressure from the Japanese encouraged the Chinese in 1909 to send a naval delegation to the Shisha Islands, the Paracel Islands, and to claim them for China. There are different interpretations of this action. The Chinese were aware of Western views about how to acquire or claim territory, and so they showed a very clear intention to assert sovereignty over the Shisha. However, at the same time, they considered the Shisha were already Chinese, and they were merely undertaking an expedition to what was already their territory. These different interpretations of Chinese conduct were to prove complicated in relations with France in the 1930s, when the French purported to annex the Seychelles. Point number 3. In the period 1909 to 1930, both the French and the British acquiesced in the Chinese claim to the Seychelles. After the collapse of the Qing dynasty in 1911, it may be said that the Chinese central government actions in the South China Seas became more sporadic. However, the legal opinions given in the 1920s to 1931 in France are categorical that France had acquiesced in the so-called Chinese claim of 1909, and when the French do purport to annex the Shisha in 1931, the British express alarm and disapproval and intervene diplomatically to have assurances from France that they will not interfere with Chinese sovereignty. The French assure the British that they will follow their legal advice. Point number 4. The French expert legal advice given by Jules Bastevin, a future judge of the International Court of Justice for France, to Aristide Briand, France's most distinguished foreign minister and diplomat of the interwar period, is that the Shisha Paracel Islands are Chinese. Can he follow the reasoning of the Permanent Court of Arbitration judgment of Max Huber in the Islands of Palmas case between the Netherlands and the United States, that effective occupation was the key to ownership and not merely declarations and annexations, and that China had satisfied this criteria much better than the Kingdom of Annam, which did have a possible claim, but it lapsed in the early 19th century. In addition, the legal opinion said France had actually already acquiesced in the Chinese sovereignty of action of 1909. However, point number 5, and this is where it becomes hot and controversial. The historical record, that's to say, of the French archives, is quite clear that at this stage, Briand, the French foreign minister, made a careful calculation. He agreed with the legal opinion, saying it was what he had thought when he asked an earlier opinion in 1921. However, after considering how the French minister in Peking or Nanjing thought Chinese national opinion might affect French interests, he decided in any case to go ahead to annex the Shisha Islands and see what happened. If the Chinese kicked up a fuss, he would offer arbitration. If relations threatened to break down completely, he would just hand back the Shisha to China. British diplomatic papers indicate a concern that France was exploiting the internal difficulties that China had by this action, which was actually in bad faith as far as Britain was concerned, because France did not follow its legal advice. Point number 6. There followed through the 1930s a long diplomatic legal correspondence between France and China, while each country occupied a part of the Shisha. Wellington coup for China placed the Chinese claim on the fact that the Shisha were a homeland for Chinese fishermen from Henan and Guangdong, while the French legal advisors dismissed this type of argument as purely private activity and not sovereign activity. They kept warning their government that its claim to the Shisha would fail in any international arbitration. After 1945, the French government offered the Chinese arbitration because they did not want the dispute to get in the way of China supporting them, or at least not opposing them in their struggle to hold on to Vietnam against Ho Chi Minh. However, the Chinese refused this offer, and France continued to occupy until they handed over their part of the Shisha Islands to South Vietnam in 1956, when they had been defeated in the war with North Vietnam. Point number 7. The story of the Nansha Islands is longer and more complicated. There are substantial British and American records which showed continued and intense use of the islands as a base for fishing, but also for junk trading in rice and the gathering of turtle eggs and other products. The visits of Chinese fishermen from Hainan and Guangdong were regular and for long periods, even though they were not continuous. And the visits were exclusively, according to the British and French records and American records, they were exclusively by Chinese fishermen to the islands themselves. This raises the question, according to modern court cases on territorial title, International Court of Justice cases, whether such activity is private or whether it is sufficient to establish the state's title to territory. The issue is already discussed, this issue of whether activities of citizens or fishermen is adequate to ground a claim of a state, the state of which they are citizens. This issue is discussed already in the late 19th century by the law officers of the British Crown, and they decide that permission given to British subjects by the Crown implies a British claim to title without the necessity of any formal annexation. Certain British citizens were given such permission with respect to a number of the Nansha Islands, but when a crisis over the Nansha arose in the 1930s, British law officers' opinions were sought, and they said the activities of the British had been too scant. A later comment in 1974 was that they applied too strong a test of effective activity, that it would not satisfy the island of Palmas arbitration, but it could possibly satisfy another arbitration, the Clipperton Island arbitration, which said that with extremely remote and difficult islands, not much state activity would be required to claim ownership. It is worth noting that the French jurisconsults Balsevan had applied the test of ownership of the Shisha Islands, the former case, the Island of Palmas case, which is regarded as the standard case for the law of territory, the so-called law of territory in international law and in all international law textbooks and in general elementary introductory courses in international law. The very remote territory still required the level of activity set out in the Island of Palmas case, which is fairly substantial. Anyway, at the time of asking the law officer's opinion, the British decided formally neither, and this is very important with the very complicated Nansha Island case, the British decided formally neither to renounce their own claim publicly, nor to acknowledge the claim that the French had made or were making to the Nansha Islands. Now, point number 9, it is all fairly complicated, I'm afraid. It's about 250 pages of dusty old documents. Now, point number 9, it is the French conduct in relation to the Nansha Island, which was itself from the very start very confused, and which led to the greatest confusion in this more vital group of islands, the Nansha Islands. As seen already, there were exhaustive British and American accounts of Chinese activity by fishermen in this area. In the 1920s, there were numerous requests by French citizens for permission to explore and take natural resources from the Nansha. The French authorities responded that as far as they could see, the islands were res nullius, belonging to nobody, but they were not sure about this fact, and their citizens would venture there at their own risk. However, by 1933, the French find that the French government in Paris finds that initiatives have been taken by naval officers from Indochina under the permission and instruction of the governor of Indochina, without consultation with Paris, to claim the Nansha Islands. The foreign minister asked the Ministry of the Marine in Paris to comment. The Ministry of the Marine in Paris said they were not interested in these islands and were not going to devote any resources to them. This really infuriated the foreign ministry. However, the foreign ministry thought they had to proceed to recommend annexation because the French presence on the island, the Nansha Islands, had already come to the attention of the British. Paris was informed of protests coming from Guangdong province, Hainan, and from Hainan, but decided to dig in and issue an edict, a public annexation note in the official journal in Paris that the Nansha Islands were attached to the province of Baria in Cochin, China. Point number 11. These developments with respect to the vital Nansha Islands are marked by uncertainties that were to plague discussion of the Nansha Islands. Firstly, having annexed this to Nansha to avoid embarrassment rather than with a clear goal or intention, the French consistently failed to make any effective occupation. Their lawyers were to say, international lawyers were to say, especially after 1945, that for this reason, the French claim to the Nansha Islands was never completed and therefore not legally defensible. At the same time, the French authorities insisted that their claim was on their own behalf, unlike the case of the Shisha Islands, where they purported to act as the protectorate for Annam. And for this reason, they did not in 1956 hand over their rights to the Nansha to the South Vietnam. Especially in 1956, the French protested their claims against China, Taiwan, and the Philippines, although they remained silent in their dealings with Vietnam. Point number 12, leaving out the Japanese seizures of both Nansha and Shisha in 1939, and it's already been pointed out by Dr. Wu, the Japanese archives I have not researched, and they are not available in English. I can read French, but Japanese. When it comes to the formal renunciation of sovereignty by Japan over the the Shisha and Nansha Islands at the San Francisco Peace Conference and Treaty. This conference was presided by warnings to Professor Truman from the Joint Chiefs of Staff of the United States Armed Forces that for strategic reasons, neither the South China Sea Islands nor Taiwan should come into Chinese Communist hands for strategic reasons. This marked the basic characteristic, very destabilizing, of the US to disregard at this time issues of territorial title. I must say, I wasted a lot of time in the State Department archives and in the archives of presidential libraries trying to find out American legal opinion, not realizing that they were not interested in the legal issue. It took a long time for that to dawn on me, that I was looking for something that I was never going to find. The United States, as is very well known, disregarded at the time issues of territorial title. China was excluded from the conference, and it was decided that territorial questions would not be dealt with. The priority was to restore Japanese sovereignty and conclude a military forces agreement with Japan. This whole procedure of the San Francisco Conference, and it's one of my most important points, was regarded by the State Department legal advisor, Adrian Fisher, as completely illegal. He regarded the whole San Francisco Conference and its treaty as an illegal document in violation of international law, primarily because it violated the Potsdam and Cairo declarations and it excluded China from the conference. Now, point number 13, in my view, remarkable dereliction of duty by the leading victor in the War of Japan is the second basic destabilizing factor in the region after the French annexations of 1931 and 33 of the Shisha and Nansha. It has been accentuated by evidence in 1956 that while they had never given weight to a Filipino claim to the Nansha Islands, the U.S. Undersecretary of State for East Asia, Murphy, said that the United States could very well have a strategic interest in encouraging the Filipinos in any case to pursue a claim. Normally, the main arena in which regional and even global territorial claims are resolved is not this law of territory through arbitration disputes between two countries at a bilateral level, but a peace conference of the powers concluding a conflict. Territorial questions are systematically interrelated and are not easily resolvable without a wider consensus on a whole range of disputes. That chance was thrown away in 1951 by the Americans. The final issue, number 14, is the flurry of legal advising that occurs in 1974 with the expulsion of Vietnam from part of the Shishas by China. This led to major reviews of the legal situation by both the British and French foreign ministries, both very unfavorable to Philippines and also, though less strongly, unfavorable to Vietnam. The British all considered all of the Shisha to be Chinese since 1909, and the de facto division, possession of the island between France and China had been merely a pragmatic arrangement between these two countries. They considered the only Philippine argument for ownership of the part of the Nansha Islands was contiguity, that's to say, geographical closeness to the Philippines, and this was not an acceptable legal argument. France might have had some claim to the Nanshas, but they had quietly abandoned it by 1971, denying at the same time that they had ever in the Nansha Islands acted on behalf of Vietnam. North Vietnam had anyway, according to the British, recognized the Chinese claim to the Nanshas in 1958 and were therefore stopped from making any claim to the Nanshas. The British affirmed that the Nanshas had never been res nullius, and given the French had abandoned their claim and the Chinese claim went back to the 19th century, for reasons I've already given, the British had always contested the Vietnamese claim by insisting on their own British claim. I'm going rather fast here, I'm afraid. Relatively speaking, the Chinese claim, both in terms of fishermen activity and state protests and declarations with respect to the Nansha Islands, was the strongest. And I set out all the British legal opinions here. It was a combination of activities of fishermen and regular protests of Chinese authorities, particularly regional authorities of Guangdong province and of Hainan province, to what was happening in the Nansha Islands. There's a final, point number 15, a final French report from 1974 to 79, which denies the legal force of the the Philippine attempt to distinguish the Nansha Islands as a whole from what they call the Kalayans. This attempt at a legal distinction, which is crucial to the Filipino claim to some part of the Nansha Islands, has, according to the French legal department, not been accepted by any other country in the region, and also rests as well on contiguity arguments, which international lawyers are agreed can have no force. Now, some concluding remarks. Number one, the British and French archives support very strongly that the Shisha Islands are Chinese, despite the opportunistic French attempt to annex them. Point number two, the British archives support the Chinese claim to the Nanshas, use primarily the evidence that the Chinese have treated the islands as part of their homeland for fishing, but also for economic activities and for possibilities of habitation. And they say it's quite clearly demonstrated that there has been regular and very substantial, if not continuous, habitation of these islands. And while not living there permanently, Chinese have come regularly for long periods. They also recognize consistent Chinese protests against French activity. The French archives do not directly support the Chinese claims to the Nanshas, although their records of investigations of the Nanshas affirm that only the activities of the Chinese fishermen and no other peoples of the region were present on the Nansha Islands. They also considered it impractical to try to introduce Vietnamese inhabitants to the Nanshas during their own imperial presence in Indochina. In addition, the French firmly rejected that any of their activities on the Nanshas were on behalf of Vietnam. They continued with their claim after the independence of Vietnam from France in 1956 through 1971 to 1974. They also provide legal advice refuting the distinction of the so-called Calayan Islands from the rest of the Nanshas. They claim to make up res nullius, and also the Filipino claim to take up a res nullius occupation on the withdrawal of Japan. And finally, this, well, I've already mentioned the claim of contiguity. Fourth point, and this is quite controversial. The United States comes out of this whole history rather darkly. In the 1930s, the Americans and then governors of Philippines rejected Philippine colonial pressure to take action in the Nanshas on the ground that they were definitely not included in the cession which Spain had made to them in 1898 or 1900. In the run-up to the San Francisco Conference, they set themselves on a legally nihilistic course, which excluded any consideration of legality of territorial title in favor of their own concept of strategic national interest. In this way, they betrayed the responsibility of the major power to have regard for the well-being of the whole area of East Asia that had suffered from Japanese aggression. They now ally with Japan and the Philippines in resisting China recovering its full rights in the Nansha by encouraging systematic military expansion. At the same time, they encouraged Vietnam's further militarization in its claim to both of the Shisha and the Nansha. This is contrary to Roosevelt's undertaking to Chiang Kai-shek that all territories taken from China by Japan would be unconditionally restored to China. In fact, he thought Okinawa, that's to say, the Ryukyu Islands, were part of China, and he wanted to restore them to China as well, but that's another story. Point number 5, part of the US strategic policy is to draw as many extra-regional powers as possible into naval exercises in the South China Sea, overtly directed against China. This includes, above all, Britain, its ethnically related partners, Australia, New Zealand, and France. Germany with Japan are also participating. If France and Britain could be convinced that their participation makes no sense, that could have a roll-on effect in reducing tension. So one of the main purposes of exploring these archives and having the work translated into French eventually is to try to persuade the British and the French governments that their support of the United States in the South China Sea is inconsistent with their own historical legal memory. The role of archives in international adjudication is not settled, but the assumption behind this exercise is not to prepare for adjudication. It is believed that impartial adjudication cannot be hoped for in international relations. The 2016 Special Tribunal on the Philippines against China shows that. That will be also a topic of discussion at this conference. Instead, the intention is to challenge the conscience and integrity of the British and French states by appealing to the evidence of their own internal records to challenge their own supposed neutral stance at the present time as to who has title to the South China Sea Islands. Going in even further, as the major powers in the region for most of the period between 1900 and 1970, they, along with China itself, and of course I'm not relying on any Chinese records, I don't speak Chinese, provide the most reliable professional legal historical evidence of the true international law position with respect to the ownership of the South China Sea Islands, Seychelles, and Nansha. So that's my contribution.
谢谢卡迪教授 ，Thank you, Professor Cardy。现在我们将进行合影与茶歇环节，请大家移步至大堂。我们的议题将于10:10正式开始。Now we will have a group photo and coffee break. Please move to the lobby. We will resume at 10:10 with the discussion of panel 1. Now we will start with the first panel of the day, Sovereignty over Nanhai Zhuda. First, let's welcome the moderator of this panel, Ms. Teresa Chen Yue-Wa, arbitrator of the International Center for Settlement of Investment Disputes. Ms. Chen, please.
Thank you. Thank you very much. Good morning, ladies and gentlemen. I have the honor of moderating this session, and if I may use this opportunity to just say a few words, may I congratulate the organizers for putting together this program, because I think it is a very, very much needed program. Restoring history and thereby restoring the truth, I think, is a very important thing for all lawyers and anyone in effect. And I think in doing this restoration of the history, the objective approach and the professional approach and the need to rely on evidence becomes extremely important. And I am extremely pleased that we have 3 sessions that we're hearing today. And of course, for the first session, we are looking at the sovereignty of the Nanhai Zhuda. So it will be a great honor for us to have the speakers here. Now, the way I'm going to organize this panel is that I would like to ask each of the speakers to speak about 10 minutes, so that we leave about 30 minutes for discussions with the floor. And of course, any supplementary comments the panelists may have amongst themselves on the discussions. So I think without further ado, I'm going to introduce the first speaker, Zhou Jian. 谢谢。周建他是外交部海洋法事务特别顾问。曾经担任还有的就是那个边界及海洋事务的代表，也是中国国际法学会的理事，武汉大学中国边界和海洋研究院的研究员，他现在当然也是华阳海洋研究中心的特聘研究员。那个周老师，谢谢。
谢谢。首先，这个祝贺这个就是这次会议的召开。那我觉得这次会议呢，议题都非常重要。今天呢，我想讲一讲呢，就是卡蒂先生最新出版的就是这个《南海的历史与主权》这本书，跟我们中国学者在现有研究方面，现有关于南海问题的研究，这两者之间的一些关系。卡蒂先生呢，这本书呢主要是通过查阅英法美3国的外交档案，对南海的历史、南海诸岛的领土主权争议问题呢，做了一个研究。在这本书呢，主要涉及的呢是南海那个诸岛的那个领土主权问题，也不涉及中国跟有关国家之间关于海洋管辖权的争议问题和海洋划界问题。本书的价值，我觉得最大的价值在于它所披露的一些史料。这些史料呢，对有些呢就是还是比较新的。这些史料呢，从那个就是在不同的历史时期呢，就多少就法英美3国在不同的历史时期呢，多少都卷入过南海领土争议。外交档案呢，记录了有关国家外交部门对这个历史事件的一些内部考虑、相关政策和法律立场，为我们研究南海问题呢提供了一个新的视角。有关档案呢涉及的年代呢比较长就从近代、现代和当代，它从总体上呢勾勒了不同历史时期呢南海的一些基本状况。这里边呢就是我们呢要读这本书的时候呢，需要把这本书提供的内容跟我们呢已经掌握的有关南海问题的史料呢结合起来，这样呢我们可以更好的了解南海那个领土争议的来龙去脉和有关争议的本质。涉及到近代呢，本书援引了英国和美国19世纪海盗测量文献的文献，这些文献揭示呢，近代以来，特别是西方殖民者到达南海之前和到达南海之初那些年代里边，中国人是西沙群岛
和南沙群岛的唯一主人。西方殖民者呢，把势力扩展到南海，对南海呢进行海洋调查的时候呢，发现呢，就是在南海有关岛礁上生活的只有中国人，并没有周边其他国家的人。那个时候呢，我想呢，这是一个历史条件决定的。当时周边国家其他人呢，他不需要跑到那么远来进行捕鱼作业，在周边捕鱼作业就完全够了。在这方面呢，就是卡提那个书呢，详细介绍了英国地理测绘学家 Horsburgh 在他1805年、1817年、1826年、1836年、1843年、1852年海盗测量报告中记录海南人在西沙群岛和南沙群岛上的生活情况。这些材料呢，结合中国自己掌握的史料，均表明中国人民一直将南海诸岛及其相关海域作为生产和生活的地方，在有关岛礁上生活并从事各种经济开发利用活动。中国人民是南海诸岛唯一的主人。然而，在一些国家试图挑战中国对南海诸岛的领土主权后，美国海盗测量报告开始篡改或者回避有关事实，不再提及南海诸岛早期只有中国渔民。而到了二战以后，西方南海问题的写作者抛开了历史文献，编造了一些新的说法，说什么南海诸岛除了中国渔民以外，越南、菲律宾、马来西亚的渔民也不时的造访。他们这些改变说法的时候呢，但是呢，他们拿不出任何历史的记载来支撑这个新的说法。事实上呢，中国对南海诸岛领土主权呢，在20世纪以前没有遭遇过任何实质性的挑战。对中国南沙群岛挑战呢，是世界历史呢进入20世纪以后才开始的。卡提的在这本书中呢，卡提先生在这本书中提及，首先英国呢曾一度觊觎中国的南沙群岛。19世纪70年代呢，婆罗洲的英国商人曾登上过南沙群岛和南威岛和安波沙洲，发现呢可以用于生产肥料和肥皂的鸟粪，因此呢，以中婆罗洲公司的名义呢，向英国殖民统治当局呢申请开采特许，但是英国政府认为，如果批准，就意味着英国对2个诸岛正式提出领土要求，因此呢，犹豫再三，没有付诸实施。第二呢，就是随后呢，到了20世纪以后呢，日本和法国呢也曾经觊觎中国的南海诸岛。法国殖民者呢是在发生日本侵略中国的东北的9·18事件以后呢，认为中国面临民族危机，顾不上南海，所以呢，他们呢有机可乘。法国呢通过政府公报宣布占领南海9小岛，这是这个所谓的9小岛事件。另外呢，法国第二介入呢，就是在日本入侵中国后，在中日武汉大会战的第2天，法国呢觉得有机可乘，知会了一下中国政府，说双方各自保留有关问题的立场，但是呢，他们为了印度支那的安全，所以呢，他们出兵呢侵占了中国的西沙群岛。这个情况呢，就是这个实际上呢，此前在20年代，法国的百里安政府，百里安大家都知道，开蒂教授也介绍了，就是他是曾经担任过法国总理兼外交部长，他跟美国凯洛格，美国国务卿凯洛格搞过一个非战公约，就是2战以后呢，审判战犯呢，就是根据这个非战公约来进行的，是一位很有名的国际法学，是一位学者，也是一个总理，很有名的总理。百里安呢，就是还有法国的法律顾问叫巴德旺，后来也是一个很有名的法学家，都认为呢，中国对西沙群岛主权的立场呢，他们是已经得到了确立，法国没法挑衅。但是呢，尽管如此， 法国呢，在30年代的时候呢，还是呢侵占了制造了九小岛事件。对于法国的侵占行为呢，实际上呢，中国呢就是以主权者的名义呢进行了坚决的斗争，维护南沙自己的主权。卡提先生的书呢，通过研究法国外交档案，展示了法国南海政策演变的一个轨迹。同时呢，也揭示了中国为捍卫领土主权同法国所进行的斗争，其中呢，既包括顾卫军和法国外交部在法律顾问通过外交照会进行的论战，也包括中国渔民，中国政府在南海通过发放国旗给渔民悬挂，在实地针对法国侵略者的一个斗争，这些呢，在法国的史料里边，法国的外交档案里边都有记录。涉及到九小岛事件呢，需要指出呢，中国政府除了外交声明保留权利之外，还采取了一系列措施。一个就是什么呢？调查中获知法国呢诱骗中国渔民悬挂法国国旗，以对抗日本侵扰渔船。然后呢，广东省政府委员会主席林应海呢，命令各县县长发布布告，明令禁止赴南沙作业的渔船悬挂外国国旗，并给渔民发放中国国旗，要求在船上悬挂。第二呢，在南沙群岛居住的中国渔民，实地也对法国的侵占行为进行了抵抗，砍倒了法国人登岛以后呢悬挂的一些法国旗帜，然后呢，挖掉了法国殖民主义者呢埋下的一些占领标志物。第三呢，很重要的一条就是，我们从国家层面由外交部、内政部、海军部等部门组成的水陆地图审查委员会，在组织对南海诸岛进行地理调查的基础上呢，专门审定了南海诸岛各岛礁沙的名称，并于1935年编印并公布。这个时候呢，公布明确将南海4组群岛，包括南沙群岛，当时呢成为团沙群岛，列为中国领土。这些呢，就是最后一条呢，就是卡提书中呢可能没有提及，但是呢，卡提书中呢，实际上从一个侧面印证了中国政府所采取的这些积极维护主权的一个行动。当中国的主权遭遇外部力量挑战时，我们是以主权者的名义来积极作为，有效的维护了领土主权。涉及到西沙群岛呢，就是卡提先生书呢提到了3件事情，我觉得很有意义，对中国证明中国对中国的领土主权很有意义。第一是早在20世纪20年代呢，法国内部包括总理兼外交大臣外交部长百里安和法律顾问巴德旺均已认定中国对西沙群岛的主权呢，在国际法上已经确立，法国无法撼动。但是法国呢，还是幻想呢是能够有条件的承认中国主权。他什么叫有条件呢？他就是说要中方承诺不割让给第三方。所谓不割让给第三方，就是原来帝国主义强加给中国的所谓势力范围条约。这里边呢涉及到长江流域，英国要求中国承诺不割让给第三方，涉及到云南、广西和海南岛，广州和海南岛，法国要求中国承诺不割让给第三方。但是呢，在当时的环境下呢，法国人已经觉得这样提出这个要求呢是不可能了。为什么呢？因为五四运动，中国人民已经觉醒了，法国心里想这样做，却又不敢轻举妄动，实际上就没有做。第二呢，就是这个卡提的书呢，完整的就是介绍了当年呢，就是顾卫军作为中国公使同法国外交部的交涉，以及呢，顾卫军作为中国公使呢，的应对。我认为呢，这个应对呢，总体上是得当的。针对法国代表越南提出历史主权的主张，顾卫军先生呢一针见血指出，这些岛屿是历史上只有海南居民居住，往来根本没有越南人来过。法国政府呢，就是 腐蚀安南的一些遗址，牵强附会啊，但是呢，顾维钧的交涉确实也有不当之处。不当之处是什么呢？就是援引中法界约关于北仑河口附近岛屿归属的规定呢，来认证西沙群岛和南沙群岛归属。这个呢，法国人呢认为呢，这肯定是不当的。这一点呢，被法国人抓住，认为有机可乘。啊，第三个事件呢，我觉得也很有意思，就是关于西沙沉船事件以及这个中英交涉。这个呢，就是沉船事件指的是什么呢？就是1898年西沙地区呢发生贝罗纳和那个渔野之晚那个沉船事故。中国渔民呢出售了沉船废铁之后呢，英国驻海口的领事馆呢就是提出交涉。法国人称呢，中国政府以帕拉塞尔群岛不是中华帝国一部分呢，而拒绝受理英方的理赔诉求。顾文钧在那个交涉中呢指出，这个说法没有文件记载，无案可查。但是呢，这个应对呢，总体上是正确的，但是呢，又是不充分的，因为没有具体提及无案可查。就是因为这一条，当时的法国政府、后来的南越西贡当局，以及呢1974年以后的越南政府，都一再拿来做文章，在他们的这个历次白皮书中，都拿这个来说事儿，并称当时中国政府拒绝承担责任，说明这些岛屿不是中国海南的组成部分，而是属于越南的。就此事件呢，卡提先生呢查阅了英国外交档案，澄清了相关事实。当时呢，英国驻北平公使馆1937年呢记录表明，驻北平公使馆当时就查阅了公使馆与清朝总理事务衙门的那个通信的档案。然后呢，在1937年5月24号至伦敦外交部门的信函中呢指出，现在我们查阅了就是1899年公使馆和总理衙门之间的通信往来，未发现有关中国否认对帕拉塞尔群岛拥有主权的记录，说明这条说法，中国否认对帕拉塞尔拥有主权的说法，完全是法国人编造的。由此可见，就是中国对那个西沙群岛主权这些呢，完全是他们编造的。这个编造的这个东西呢，不但法国人在用，南越西贡当局后来用了，越南政府后来越南政府也用了，这一点澄清，我觉得非常重要。总之呢，面对外部挑战，中国始终以主权者的名义积极维护对南海诸岛的领土主权。在二战中呢，废除中日之间的一切条约，战后呢，收复被日本侵占的一切中国领土。要提到的就是在那个二战期间呢，日本是侵占了中国的南沙群岛和西沙群岛，并且呢，把它命名为新南群岛，合在一起。包括那个，因此呢，我们在收复被日本侵占领土中呢，应该包括西沙群岛和南沙群岛。中国的主张呢，实际上得到了开罗宣言、波茨坦公告和日本投降书等国际法律文件的确认。不仅如此，我们不仅战后呢，我们也已经根据这些文件予以收回了。用永兴、太平等军舰收复西沙群岛、南沙群岛，驻军设防，并且呢，通过出版1947年南海断续线地图，公告世界中国对西沙和南沙的主权呢，在国际法上呢已经确立。这个确立呢，是中国政府在不断应对外部挑战的过程中，以主权者的名义，通过加强管辖，不断巩固主权而达到的。法国、日本、美国战后初期呢，实际上这个45年到60年代，都曾以不同的方式，我所谓不同的方式是什么呢？就是出版官方地图、出版物，还有外交照会等方式承认南沙群岛属于中国。其中，美国给中国的在应对外部挑战的过程中呢，不断巩固对南海诸岛主权。关于这点呢，卡提先生书呢披露了英国外交部法律官员1975年的一份内部研究报告，比较客观地评价了中国在维护南海诸岛主权的努力及其成功。这里边说到了， 就是卡提书里边，我现在援引一下。不管怎样，到了20世纪30年代，中国应该已经拥有了主权，或者是因为他们就是这个在1877年之前早就拥有主权了，或者是由于英国主张权力的自然密室，中国的主权呢重新复活。他们利用所有合适，说中国人利用所有的合适的机会，抗议法国1933年权力主张，抗议日本1939年的所作所为。1945年呢，日本放弃对这些岛屿控制后呢，中国派军舰前往太平岛，树立标示中国主权的石碑。又抗议1951年旧金山和会以及最近菲律宾的所作所为。中国人因此获得了主导权，中国轻而易举的占据了赢家的宝座。这是卡提先生书里面说的。关于第4呢，我想说一下呢，就下面呢，关于中国对南海做主权呢，我需要再补充3点观察。一是1974年以前，越南在政府声明、外交照会和公开出版的地图和教科书中，都曾公开明确的确认西沙群岛和南沙群岛是中国领土。越南受到国际法上禁止反言原则的约束。卡提先生书呢，引用英国外交档案呢，也指出了这点，就北越被视为已于1958年承认了中国的权利主张。实际上，基于越南政府这一承诺呢，中国政府在对西沙群岛和南沙群岛行使主权和管辖的过程中呢，对美国军机飞越西沙群岛领空，对越南北部进行轰炸提出警告，使越南呢对有关情况呢也做了报道，使越南这样呢，使越南这种对中国主权的承认呢，已经从对中国主权承认中，越南是获得利益的、受益的。从这个情况来说呢，就是适用这个禁止反言原则呢，就是排除了越南此后任何对南沙的全权主张可以。另外呢，最后呢，我想说一下呢，就是最后我想说一下呢，就是涉及到这个当前呢，就是中国在维护南海主权上呢，我们现在实际上呢面临着3大挑战。第一呢，一些国家呢想通过一些新的行动，扩大对南沙群岛的非法侵占，比如说菲律宾在坐滩军舰仁爱礁上所作所为。这个呢，这是一大挑战。第2大挑战呢，是越南呢近期呢不断在侵占岛礁上呢进行陆域摧田，想借此呢进一步巩固其非法侵占。第3大挑战呢，来自于南海仲裁案的有关仲裁裁决。南海仲裁案呢，明知自己没有资格，也没有管辖权审议领土主权和海洋管辖权问题，无视南沙群岛在国际法的整体的领土地位，把南沙群岛呢拆分成一个孤立的所谓海洋地形，否定南沙的群岛的整体领土地位。这个呢是我认为呢是这个，因此呢，正因为如此，我们说呢，仲裁案呢，南海仲裁案呢是实际上呢是违背现代国际法和现代海洋法的。仲裁案对南沙群岛有关争议的这方面呢，这个裁决本身呢是非法无效的。我的翻译完毕，谢谢大家。
谢谢周参赞刚才给我们对卡提教授的那本书做了一个非常重要而且非常精准的一个赘述。他刚才提到那个法国人也把我们中国的渔民当时在岛礁上面的生活的情况也记录下来，这也让我想起了他最后也提到那个仲裁案件，那让我想起当时我作为那个代表海南渔民的法庭自由出的那个法律的文件的时候呢，也看过我们的陆耕部，那个很明显就看到，当时我看到的是记在明代的时候的一些事情，他在那个岛礁上面的生活有多少人因为潮退潮涨，船什么时候开出去，打风了，那个他们又要带，大概从今年带多少天，都写得很清楚。所以这一些呢，作为一个那个律师来讲，这一些就是证据，而且对我们的历史的还原的一些非常重要的证据，而且这一些已经是民间了，不单是官方的一些证据。所以非常感谢周参赞的那个刚才的介绍。 下一位呢, the next speaker we would like to invite is Mr. Oi Ee Soon. He is the Principal Advisor of Pacific Research Center of Malaysia and the Senior Fellow of the Singapore Institute of International Affairs. I think two matters that's of worth mentioning in particular of interest from his CV. He started off as an aeronautical and mechanical engineer, and then moved on into international law and international affairs. And the second is that he is also a justice of peace, which is something that I have the honor of sharing with Mr. Oi. Mr. Oi, the floor is yours.
Thank you, Ms. Teresa, for your moderation. And I would also like to thank the National Institute for South China Sea Studies to invite me to share some of my thoughts on the issues concerning South China Sea. Well, this panel concerns the notion of sovereignty. I would like to set out with the proposition that the notion of sovereignty, at least in the modern sense, is intricately related to the concept and practice of nation states. Most commentators, in turn, would trace the notion of nation states through the Treaty of Westphalia in the aftermath of the 30 Years' War in the middle of the 17th century. Before that, most inhabitants of territories, at least in large parts of Europe, would swear their allegiance to the persons of the territorial rulers, be they kings, emperors, dukes, or bishops, to name but a few. The territories, the inhabitants, and the properties on those territories were in essence treated as the personal chattels of the rulers, sometimes to be traded or exchanged by these rulers at will. So when the ruler concerned died in battle or combat, for example, his or her personal sovereignty over the kingdom or empire or dukedom or bishopric was pretty much up for grabs by the victor or conqueror, together with the inhabitants and the properties on those territories. There were notable but rare exceptions, such as the cantons of Switzerland or the coastal cities of the Hanseatic League along the Baltic coast and North Sea, where self-rule by inhabitants were prevalent. But I would contend that even after the treaties of Westphalia were inked, the notions of the ruler's personal versus nation-state sovereignty over territories, inhabitants, and properties were still very blurred, or at least mixed. On the one hand, just a few years after the treaties of Westphalia, the French king Louis XIV famously quipped, "L'État c'est moi," or the state, it's me. But on the other hand, the year after the treaties of Westphalia were concluded, England executed its King Charles I in the name of the state, perhaps for the first time giving effect or precedence to the abstract notion of the sovereignty of a nation state over that of the ruler. But in other parts of Europe and indeed around the world, the state was most often still very much embodied in the person of the ruler. I will further contend that the modern notion of national sovereignty over territories, inhabitants, and properties may be more appropriately traced back to the Treaty of Versailles after the First World War, or more precisely to the 14 points evinced by Woodrow Wilson, the then President of the United States, and which became the basis for post-war negotiations at Versailles. In particular, Wilson's last point calls for the mutual guarantee of territorial integrity to great and small nations alike. This, together with his call for self-determination by the then colonized peoples, may be said to have laid the foundation of the modern formation of nation states and their associated claims to territorial sovereignty. This could be seen, for example, in the immediate triggers for the Second World War. It should be noted here that previously the trigger for the First World War was the assassination of the Crown Prince of Austria. But a quarter century later, with the notion of national sovereignty taking roots among nations new and old, when Nazi Germany successively invaded and annexed Austria, Czechoslovakia, and then Poland, the United Kingdom and France declared war on Nazi Germany. The Soviet Union joined the Second World War when Nazi Germany recklessly invaded its vast territories. And the United States also joined in the aftermath of the Japanese bombing of Pearl Harbor. Since the end of the Second World War, many territories around the world were decolonized and formed new nations of their own. Although many of their borders were previously rather arbitrarily drawn up by the former colonial masters, with serious implications for irredentism, for example, these nation states would still jealously and zealously guard such sometimes artificially constructed borders and defend what they consider to be their sovereign territories. I spend much time above laying out what I consider the evolving notion of sovereignty, territorial and otherwise, mainly to emphasize that the notion is, well, indeed an evolving and not necessarily a fixed one. The disputes or confrontations, depending on your point of view, over a large part of South China Sea have most often been framed in the context of contestations or territorial sovereignty that is held by respective claimant parties as sacrosanct, inviolable, or zero-sum in nature. Either I win or you lose, or vice versa, without a win-win scenario as a viable prospect or alternative. We saw in recent days, for example, renewed escalations in both frequency and intensity of encounters between the agents of some claimants in South China Sea, each viewing their actions as defending their respective territorial sovereignty. We can only hope that these happenings would not get out of control and trigger something that is even more unimaginable. These conflicting claims of territorial sovereignty on South China Sea are often premised upon historical narratives or effectivity or effective control. In recent years, it would appear that effectivity has been on the ascendance as a rationale for claiming territorial sovereignty. In the International Court of Justice case of Malaysia versus Indonesia over the sovereignty of the islands of Sipadan and Ligitan, which, by the way, is just off the coast of my home state of Sabah in East Malaysia, the ICJ awarded the islands to Malaysia for having more persuasively demonstrated effective control over these islands. In the later case of Malaysia versus Singapore, a similar effectivity rationale was employed by ICJ to award the disputed Pedra Branca to Singapore and Middle Rocks to Malaysia. But disputes involving territorial sovereignty do not necessarily have to be handled in such legalistic win-lose manner. A case in point was the resolution of the relocation issue related to Malaysian Railways Tanjong Pagar station near the southern shore of Singapore Island and the connecting railway line that thus cut through the middle of Singapore from north to south. There were at least disputes over claims of partial sovereignty over these land strips. The Malaysian side, we would think that the railway lines as well as the station land would belong to Malaysia, where Malaysia could exercise sovereignty over these strips of land. But in 2011, the two neighboring countries decided to settle the matter in the most amicable and yes, profitable manner. At that time, I worked in the Prime Minister's office of Malaysia. And I think both countries, we spent a lot of time trying to iron out a mutually beneficial solution. The railway station was moved to near the northernmost part of Singapore, and the railway tracks disused. And as part of the settlement, the two countries form a joint stock company to develop several of the priciest parcels of lands in Singapore, with the profits to be prorated between the two countries. So an otherwise nagging bilateral dispute was transformed into a most exemplary and, I might add, visionary model for countries to resolve their disputes, including those involving territorial sovereignty through productive win-win compromise. For South China Sea, one could come up with countless possibilities for fruitful collaborations, from exploration of natural resources to generation of renewable energy. In conclusion, while vigilant safeguarding of territorial sovereignty remains the mainstay of South China Sea claimants, they should realize that such acts are but the latest manifestation or emanation of the notion of sovereignty. And if they are willing to think and act a little bit out of the box, there's a vast ocean of many other plausible win-win situations that could produce real and tangible benefits for all, and that could turn seemingly unavoidable crises into beneficial opportunities. Thank you very much.
Thank you very much, Mr. O. I particularly welcome the remarks towards the end about the use of a negotiation and looking at interests in order to resolve the disputes between Malaysia and Singapore. And I certainly commend that insofar as South China Sea is concerned, that is an avenue that one may look at in order to resolve and focus conflicts, but more importantly, to focus on interests. If I may then now invite our next speaker, Liu Fuguo 教授。刘教授呢，他是台湾政治大学台湾安全研究中心的主任，他一直都有参与一些在那个南海研究院的一些活动，而且我知道已经参加了很多年，所以他在这一次在跟我们分享他的研究，我们非常高兴。刘教授，谢谢。
Thank you very much. Good morning. I am not a historian, but I have to say that listening to Professor Carty's presentation, it really amazed many of us. We obviously are studying so much about South China Sea. I would very much like to, perhaps based on Professor Carty's presentation, to develop something to connect with what I'm always doing. That is more on the strategic front. And I am hoping, since this is a really unprecedented dialogue between our historian and also those policy thinkers in this particular occasion, I think it would be very helpful for us to get to understanding such a critical point, because over the last almost 2 decades, people involved in South China Sea studies really focus so much about who is really owning the sovereignty in the South China Sea, But originally, almost 2 decades ago, there was only one story, which reflecting what Professor Carty's presentation and also the research finding. But thereafter, as you can imagine, Vietnamese, Filipinos, and also other countries in the region gradually came up with their version of history in the South China Sea. But of course, all in all, it reflects this politics in the region really changing so much, and probably also, as some of you mentioned, misguides or misled such a understanding in the South China Sea. So before I really move on, I don't have a long slides today, but I just want to reflect a few points before I go into my short presentation. The first one, historic evidence from Professor Carty's presentation. Obviously, it reminds us all the evidences would have to also cover all regional stakeholders. Just looking back before the end of World War II, it would not be so complicated to understand how many regional stakeholders were really playing in the region. Of course, Japanese during their colonial time overshadowed the entire East Asia. But of course, during the time, most of European colonial powers also played a significant role in the region. But I cannot think of beyond that specific players, how many, as some other regional claimers today suggested they have also significantly played their role in the islands and reef rocks in the South China Sea. So going through historic evidence, obviously this is a very critical finding. The second point I want to also mention, because for political reason, in between Taiwan and China, originally, Professor Carty also mentioned Republic of China developed early time and also still keeps most of critical documents and literatures in Taiwan. But for political reason, much of these important information has not been widely publicly shared by others. So that may be something that as a result leaves a certain ambiguous room for externals to interpret. So that may be something we should really recognize. But I think probably Professor Carty's research will be able to really push a little bit. And I'm hoping this will be one of the direction from our part. Taiwanese would also need to think further. And the critical point today regarding verification of a historic fact is it should follow historic practices and also the ways they were back in the ancient time or earlier time, rather than thinking of today's experience. So I have come across to learn in different conferences, listening to our friends from Western country. They always criticize taking the point, today's point, and thinking that they have not really learned the much as Professor Carty's gave in this clear historic evidence. So I do think probably this would be one of the contribution all of us can do together to strike a clear line, which if we are thinking the earlier time people lived around the islands and shop, they would have their own very primitive ways of living on those islands. So let me quickly run into my presentation. So basically, today, all the political statement made by related countries or players in the region, I can summarize this into a very easy point: power politics and also excessive maritime claims. Basically, reading through, there are a clear political statement by the U.S. government during the South China Sea arbitration case. That was the one back in 2014, and also the recent one, 2022, in which you can read they criticize and also they have come up with some questionable points addressing to China. But of course, with this complicated political situation, Taiwan also share almost the same part of South China Sea claim. But lately, many of you may not have heard what Taiwan's position in the South China Sea. I can tell everyone, our South China Sea policy and also insistence have not had any change at all since the early time. So when you most studied the South China Sea, especially 9-dash line, 11-dash line, or the U-shaped line, that was the beginning point of Republic of China's policy. But up to today, it is only the way how to interpret differently from different administration in Taiwan. But I can tell today the highlights in the international communities are very much on the 9-dash line, baselines, and also historic right. So China does not offer sufficient and evidences, documents to clarify its position, while Taiwan shies away from offering detailed documents. So it really leaves certain room for outsiders easily to interpret who really own or who should really claim sovereignty in the South China Sea. And this map is actually developed by the U.S. government on the version of limits in the sea. And this is the focus. U.S. government is challenging Chinese position. So the green line showed that was the original 1947 11-dash line by the then Republic of China in Nanjing, publicized this specific line. But thereafter, the red 9-dash line published by Beijing in 2009. And of course, they are comparing the differences and also come up with different legal arguments. And this is another very interesting map published by the U.S. government, again, limits in the sea, 150, in which the U.S. government already taking preemptive measures, thinking that China would be utilizing straight line to claim the South China Sea sovereignty, apart from the 9-dash line here. So this is the version. I was, when I saw this, when it was published back in 2022, surprisingly, even if the government in Beijing and also Taipei have never formally published such a island group baseline, but the U.S. are already taking this preemptive position to presume something illegally moving forward in the future. But I have to say another key point to elaborate. Probably as a result, then I can conclude my presentation today, leave interesting point to everyone. Based on historic finding, today it's all the more important because as you can imagine, the system and all the historic evidence remind us before UNCLOS really emerged in 1982, the regional regime regulating the South China Sea already existed for decades or even more than a century. So Professor Carty's research also reminds us, even right before UNCLOS, the regulation or activity already exists in the South China Sea. But I think if you study regional politics and also strategic analysis lately in the South China Sea, you would not, of course, you will not really leave such a room thinking that everything would have to base on UNCLOS as a legal base. So look around Vietnam, the Philippines, Malaysia, the US, and other countries criticizing China. They would always base on UNCLOS. So I wonder, this may be a clear room for all of us to study. So far, after all these, especially after 2016, not much research has really focused on the differences between UNCLOS and the earlier regional order. And probably this is something I consider useful for all of us to study the the room accommodated in between the old system, old regime in the South China Sea, combining with the UNCLOS. So if we are thinking of UNCLOS, there should not have any historic claim. And that is something looking into international political reality. Most of the countries just take favorable clauses which they consider argue against their counterpart. If they can really take advantage of current UNCLOS by suggesting, and they would normally leave this historic part. So I really I'd like to take this occasion to congratulate Professor Carty's contribution, and that would be setting a landmark for all of us to study further, because with this earlier history confirming Chinese people really staying around in the South China Sea, and we can really, based on this, consider how we are going to study and make this UNCLOS more accommodated, rather than confusing and also distorted real history here. So let me stop here. And once again, I'd like to thank the South China Sea Institute for South China Sea Studies for inviting me over to give this point. And I welcome the point and remarks later. Thank you so much.
Thank you very much, Professor Liu. Excellent presentation, and I think the map is so particularly interesting in looking at the cousin that develops. And I'm grateful. I think Professor Carty's book has already given us a new dynamic for further study. So I think it's a very good, excellent suggestion for further way forward. We will now move on to our next speaker, Yan Yan. Yan Yan 他是那个中国南海研究院海洋法律与政策研究所所长，也是南海战略态势感知项目副主任，香港大学的法学博士。他就是在南海研究院很多年的，所以我们期待你的发言，燕燕。
Thank you, Chair. Thank you, Madam Chen. Good morning, everyone. I'm very happy that we have our old friends and new friends gathering here back in HICO again, and especially welcome Professor Carty, my PhD supervisor, who guided me and helped me to survive my 6 years in Hong Kong U. Yes, so today Today, I'm going to talk a little bit about the sovereignty claims of the Philippines and the island regime of the UNCLOS and how they're affecting the current South China Sea situation. I will go through and review very quickly, briefly about Philippines maritime legal claims throughout the years, especially since 1961, and then to look at the arbitration ruling and the especially on the Article 121 of the island regime, and then to look at recent South China Sea actions, the Philippines unilateral actions, both in Scarborough Shoal and Second Thomas Shoal, and finally to seek the way forward. First of all, historically, the Philippines claims the northern east section of the Spratly Islands as the Kalayaan Island Group, the KIG, in addition to the Scarborough Shoal. Well, actually, since the year 1961, the Philippines started to define the baseline of the territorial sea through its maritime legislation for the first time. And back in the year 1961, the Philippines, for the first time, defined its baseline, territorial sea baseline, and claimed that the waters within the baseline is internal waters. And then 1973 Constitution confirmed again the internal water maritime claims in the South China Sea. And also 1978 was again confirmed the similar maritime claims and started to claim a 200 nautical miles of exclusive economic zone from this baseline. Then the 1978 Presidential Decree 1596 is the first time that the Philippines said that the island regime of the UNCLOS is can be applied to the Kalayaan Island Group, the KIG. Then the 2009 Act 9522 defined again the baseline, redefined and described the baselines of the Philippines, but it did not make clear of the waters, the legal status of the waters within the baseline. That is the development and involvement of Philippines maritime claims before the arbitration. And then after 2016, I think the Philippines is trying to incorporate the arbitration ruling into its maritime legislation, especially since the year 2018. Back then, the House passed the resolution of the House number 15, and also trying to add a more article in its constitution to make clear that its territory, and including these the island territories admitted by the International Court and a tribunal. Then after, in recent years, 2021, there is a clear proposal that from the House, from the House to suggest that to incorporate the ruling of the arbitration into its maritime domestic legislation. Then the most recent one, the 2014, I think is in May, that the Senate approved the amendment of the Maritime Zones Act in the third reading, and also this bill codified the status and regime of the waters inside the archipelagic baseline and redefined the extent of its territorial sea, including the contiguous zone. So these are the a brief introduction of Philippines maritime claims in the South China Sea, especially its maritime legislation. Then we better look at the 2016 arbitration award, especially its island regime of Article 121. Well, the award, the ruling of the award claims that no maritime features claimed by China within 200 nautical miles of Mischief Reef and Second Thomas Shoal constitutes a fully entitled island for the purpose of Article 121 of the convention. And also in terms of the Scarborough Shoal, it says that the Mischief Reef and Second Thomas Shoal are low tide elevations and as such are generate no entitlement to maritime zones of their own. Well, here I would like to mention about the Philippines maritime sovereignty claims of the Scarborough Shoal is that it claims the title to Scarborough Shoal passed from Spain to the United States back in the year 1891, along with all other Spanish maritime features surrounding this Philippine archipelago. So to look at this, well, for the past 8 years, there have been enormous research and foundings of this arbitral ruling. I think here in this conference and given this limited time, I would like to only address the most. I think it's the most fundamental one, which is about the flaw of this arbitral ruling, which is respect to the status of the features in South China Sea. Well, I think the tribunal erroneously addressed separately the status of the component features of the two island groups, the Spratly, the Nansha Qundao and Zhongsha Qundao, and the McCaskill Bank, and also this foundation makes it terribly wrong in fragmenting the territorial sovereignty issue and maritime delimitation issue as such. I think because this argument and founding runs against the fundamental nature of the maritime space, because what are maritime entitlements? Maritime entitlements are rights of sovereignty, of sovereign rights to the maritime resources and also of jurisdiction over these activities occurring in designated maritime zones. Therefore, what is the point of maritime entitlement if we don't know who is entitled to of these features? Therefore, I think that the dispute related to contested maritime features, therefore it goes beyond any interpretation and application of the UNCLOS, because the fundamental problem of the South China Sea dispute is still undetermined sovereignty over all these features. And after 2016 till now, for the past 8 years, I think the claimant states have done many actions. All the claimant states have done, to be fair, to have done actions in the South China Sea, and I think the tension goes high, especially in the past 2 years. But here I will only look at the Philippines. Philippines after the 2016, if we look at it has provocative actions and activities in Scarborough Offshore, in Second Thomas Shore, the resupply mission, which is the hotspot of the South China Sea in the past 2 years, especially this year. And very recently, there has been an incident in SC. And also, besides Scarborough Shore and Second Thomas Shore, I think the Philippines there's a report that they has been trying to occupy new uninhibited features, the Sandy Cay. So these are the recent developments in the past 2 years. But on the other hand, we do see that after this 8 years, I see that some scholars or some people in the Philippines started to realize what the arbitration ruling did bring to the Philippines. Well, there's some analysis and commentaries from the Philippine scholars realizing that, well, the previous KIG, the Calayan Island Group claim from the Philippine government had an area of 170 square kilometers, with nearly double the area of Luzon Island. However, after the arbitral ruling, the Philippines maritime claims has been reduced to an area less than 1% of that, or 8,000 square kilometers. This is a founding of the Philippine scholar, and I saw it on from the internet. I think this is shows that some people in the Philippines started to realize what the arbitration ruling did bring to the Philippines maritime claims. The way forward, well, fundamentally, as I already mentioned, the dispute that hasn't the fundamental problem of the dispute that hasn't been resolved is the underdetermined maritime sovereignty issue over the features. Therefore, the essence of the South China Sea dispute is still the dispute over territorial sovereignty of the features, and then and also the limitation of maritime space. It's actually not about the interpretation and application of the Article 121 of the UNCLOS. And I think for the sovereignty issue, I think the biggest problem, or the biggest thing that I would like to mention in this conference, is that we still need to bear in mind the Article 5 of the UNCLOS, which is the self-restraint and the promise of the claimant states and the signing signatures this commitment of not to occupy new uninhibited features in the South China Sea. And this is something that we need to bear in mind and not to create new sovereignty issues and new problems with these problems unresolved. And finally, the way forward is to find a solution to back to the track of negotiation and dialogue of China and the Philippines. I do think that the dialogue and communication mechanism is not working properly so far. The Coast Guard hotline is not working; it's stopped, and the BCM, the bilateral consultative mechanism, is not working. So I think it's better. It's time for China and the Philippines to back to the negotiation table, and we back to the right track of negotiating our real true dispute of sovereignty and maritime delimitation through peaceful means. And that's all. Thank you.
Thank you, Yan Yan, for covering a very large area within the 10 minutes that I've given her. Thank you very much. I think one of the fundamental problems, if I may say, a fundamental error of the arbitration award is the lack of jurisdiction. I think that is even more fundamental than the substantive errors that you have identified, ignoring the reservations and the treaty intentions. And I think that is a very important matter that we must all bear in mind in order to understand the context of the arbitration award. So if we may now move on to our last speaker, last but not the least, Mr. Xu Xiaodong. 他是华侨大学华侨华人与区域国别研究院副教授，也是中国南海研究院及南京大学的博士。他是在荷兰的莱顿大学历史学博士的一个毕业的，所以期待听你的发言。谢谢你。
谢谢主持人，谢谢中国南海研究院和华阳海洋研究中心的邀请。刚刚聆听了各位专家的汇报，也受益很多。今天我们的主题呢是这个南海这个诸岛的主权。刚刚各位学者都是从不同的角度予以了阐释。那我今天的汇报呢，主要想从另外一个角度探讨一下这个问题，就是为什么今天在国际学术界关于南海岛礁诸岛这个主权的一个形象或者一个认知会变成这样子？究竟是何种知识、何种研究塑造了它？所以想追溯一下关于南海诸岛历史主权以及历史依据的一个知识的来源。那么在开始陈列我的观点之前，我还想说3个简单的一个资料的一个呈现。第一个呢是这个比尔·海顿，也是一位这个大家可能比较熟知的这个英国的一位学者，所谓的学者。他在他2017年发表了这篇文章，叫 When Good Lawyers Write Bad History， 就提出了一些非常有意思的观点。但有些观点，如果我们从理论上层面来讲，我们会发现它有一定的合理性。比如说，他认为现在我们在这个国际法学家在撰写或者援引南海的这个所谓的这个历史依据或者关于南海历史的叙事当中呢，可能是援引的资料过于片面，他的观点过于片面，这一点我们可以在某种程度上适度的承认。但是另外一个层面呢，他又提出，因为他的整篇文章的论证的逻辑是对中国在南海诸岛历史主权的一个批驳，所以他认为，尤其是在上世纪70年代，陶成以及邱宏达等这个学者撰写的这样的一些关于中国在南海历史这个主权的一些文章，那么成为了今天的很多国际法学家一个援引的一个重要的文献来源。他认为这2位这个学者的研究呢，是基于一个非常狭隘的或者片面的这个中文的史料，也就是说没有对足够的史料进行一个多元化的分析。那这听上去也似乎很有道理，并且他在文章中也呼吁我们要尽可能的使用刚刚这个刘老师提到的希望这个台湾这方面的史料放开，能够去构建一个更加完整的这样的一个叙事。但是呢，在很多细节方面，我刚刚也指出了他的很多的研究，比如说中国从1933年到56年到74年，他认为对这个南海诸岛历史的一个叙事是在不断的累积既有的一个错误，那么这样的一个观点是过于武断的。那么另外一个层面来讲，即便他呼吁我们说要去给他的这个研究做一个多元化， 这个资料的多元化，分析视角的多元化，但是它本身这篇文章的构建却并没有遵循这样的一个路径。为什么呢？我们可以看它的一些其他的一些文献，其他的文献我们也是比较熟悉的，并且我查了一下在 Google Scholar 的引用，我们会发现它的引用的这种被引用的次数是非常高的。我们在座也有做这个图书情报学的这个专家，我们可以发现，在人文社科领域，它的一个文章的一个影响度，应该说这个引用的次数在短短几年内达到这样的一个级别是非常高，并且它的一个引用除了他本人以外，那么国外的学界也大量的引用，我们可以看到他的一个观点在整个西方学术界，特别是国际上的一个传播的一个程度。所以我们是否可以认为，那么以比尔海顿为代表的这样的一些所谓的这个历史学的一个研究者，他们的一个研究的成果对整个国际上关于中国主导南海这个主权的一个认知的一个塑造能够产生怎样的影响？所以这是我可能基于这样的一个历史的一个梳理可能提出的这2个问题。那么什么去构建了这样的一个对南海诸岛这个认知的一个塑造，以及对这个历史证据的塑造又是怎样子的？这是我提供的第一个的一个资料性的那么第2个呢，既然提到了这个他对中国的这个历史南海诸岛的主权跟历史依据的一个批评，那我们看一看越南方面他们提供了哪些。这是我从这个越南的这个3份白皮书75年、81年和88年的这个里面摘录出来的越南它的一些官方认可的认为可以支撑越南在南海的这个主权申诉的这个依据，其中大量是中文的资料包括这个大越史记等等。那么还有一些是外文的史料，因为他在白皮书里面也强调一个资料的一个多元化，还有一些是中国的史料，比如施大山的海外记事。因为这些资料核心的观点就是这么几个，一个提到了这个黄沙、长沙，第2个就是提到了这个黄沙队、北海队等这种越南官方的一些活动。那么另外一个呢是这一篇文章，这个是名古屋大学的一个客座教授 Alex Carvel 写的一篇文章，15年的，叫 A Survey of Western Sources in Vietnam South China Sea Narrative。这里他指出了这个越南，他试图用这个西方史料来给他的在南海的所谓这个历史证据提供支撑。所以这些资料涉及到这么几个内容，一个是法国传教士的记录这个西方关于地理这个南海地理的一个技术。那么其中一个非常重要的是1816年的这个加隆王插旗事件，认为他这个对这个是越南官方这个声索西沙的一个非常重要的事件此后呢还有一些比如说这个在西沙群岛的航海活动以法国的殖民活动，那么越南呢作为一个殖民继承这样的一个线索。所以近年来我们会发现这个越南的学者也在做同样的事情他们试图在国际上去发表这样的一些关于越南在南海的这个历史依据的英文的文章。但是我们可以看到，与比尔海顿相比，我找了2篇，这2篇文章也很有意思都是一个越南的学者写的，但是发表的期刊呢的 Journal of Middle East and North Africa Sciences， 目前它不是在这个 SSCI 这个核心期刊目录里面，它的流传度也不广，但是我们可以看到这个越南它在做这样的一个事情。所以我去翻查了一下这个它的一个文章的内容的引用，它的这个史料呢主要包括这样的一些内容，我给它列出来了。所以正如它上面一篇标题所示，它找的是德文、意大利文这个波西米亚文以及比利时的这样的一些档案资料，这些很多是一些游记，还有一些是教科书，其中提到的也大多都是关于越南在19世纪初的对西沙的一个描述，以及所谓的这个加隆王以及这个阮朝时期在这个西沙群岛在这个帕拉塞尔地区的一个活动，跟越南的这个官方的白皮书里面提到的这个历史的依据并无太大的区别所以这是越南的活动。那么菲律宾它的一个非常有特色的呢，还是从这个地图上面去寻找这样的一个主权的支撑。所以这个前大法官安东尼奥卡皮奥呢，就是编撰的这一本电子书里面，其实罗列了很多关于这个地图的一个资料。这里面很有意思，我就举一个例子，比如说他申索为什么这个菲律宾能够在南海主张这个 岛礁，他一个非常重要的认为当时的 island 英文的 island 这样的一个命名来自于这个菲律宾土著他的一个称呼叫做 Pulo， 所以他去大量的找了很多的这个西班牙的地图来证明他的这样的一个观点。所以但是我们在座各位都是很多是这个法理专家，当然知道这里面是没有足够的这样的一个法理支撑的依据，但是他都通过这样不断的一个重复，不断的像一个国际社会的宣介，能够去扩大他的一个影响力。所以他的地图中很多就是把这个给圈出来，认为这个地方命名了 Pulo， 所以他就认为是这个菲律宾的，就有很多这样的地图，从这个17世纪中期的他就认为这个另外呢，这样的图显示的呢，比如说他把红圈表示的那个岛或者这个岛礁，因为它的名字叫菲律宾的叫帕拉古瓦，他就认为是 Spratly 的这个名称，所以认为这就是菲律宾能够去主张南沙群岛的一个主权。所以好多是这样的一个历史依据出发不断的去罗列。所以菲律宾办过一个300年的这个地图展来专门陈述他这样的一个观点。所以我们可以看到不断的比如这张地图，这更加有意思。为什么呢？它是2方面的，一方面他就认为中国的领土只能到海南岛，就是上面一个红圈写的，然后同时呢下面一个因为画了这个帕拉古瓦，他就认为这个南沙群岛是这个菲律宾的。所以我们且不论这个地图的公信力如何，它是否权威，是否是官方的，但是这样一个武断的一个这样的一个论断呢是没有任何的这样的一个历史的跟法理的依据的。这张图是比较有意思的，也是著名的维德拉地图。维拉德地图是菲律宾向仲裁庭提交的这样一个地图，所以这张地图既认为就是菲律宾以此去伸索黄岩岛跟他们在南沙群岛的主权，同时批驳这个中国他们的我们中国的历史主权。同样这个地图也是基于一个非常没有坚实法理跟历史基础的这样的一个依据。所以通过大量的这样的一个地图的一个宣介呢，就成为了菲律宾他们在主张南海诸岛主权，尤其是南沙诸岛主权的一个所谓的一个历史的一个依据。所以我这里时间所限，我就不过多的去把这里展开。所以我们大致上可以看到是这样的一个逻辑线索所以这个大量的古地图。所以我想从最后呢，就是回到我想就是做一下这个几个总结。这个是他用地图来批驳中国，就认为中国在南海的很多这个主权缺乏依据的这样的一个内容。所以这里就不重复了，这个可能快速的跳过一下。那么，所以我为什么会列这个图呢？就是我们可以看到，刚刚提出了3个资料的显示，就是一方面，这个以比尔·海顿为代表的部分的这个学者在国际上的一个影响力；第2个呢，就是越南学者试图在国际化，但是他们并不成功。那么第3个呢，菲律宾呢，就是通过另外一种线索，对吧？不断的去办展览这种东西，向国际社会去展示。所以我就查阅了自上世纪70年代以来，在国际 SSCI 上发表的关于南海研究的这样的一个期刊的论文，我们会发现，在座很多老师都在这个图表里面，但有些大一点，有些小一点。大一点为什么呢？因为他们的也发表的比较多，所以我们可以看到，其实是整个是大量的呢是一些西方的研究，当然中国的也有，中国学者也有，但是我们后面进一步看大家看右边这张图，就是我对它的一个学科领域做了一个划分。我们可以看到，基本是涉及在区域研究、这个政府和法律、国际关系这样的一个研究领域。而南海主权它本身这样的一个历史的一个问题在哪里呢？我们看到其实是在这个地方，所以它是只占了很小的一部分。所以某种程度上而言，南海诸岛历史的问题，诸岛主权历史的问题，我们可以看到历史学家的参与是非常不够的。所以在某种程度上而言，这个安东尼·卡蒂教授的研究对于整个这个南海历史叙事的贡献是非常突出的所以这是一个非常有意思的这样一个景象。所以为什么会造成这样的一个情况呢？我又去分析一下刊登这些论文的一些主要的一个期刊。那么这些期刊我们可以看到我给它列了这个所有的这个 它的一个这个出版方，那么只有一个是来自中国的，就是这个 Journal of Chinese Political Science 中国政治学会的这一个期刊，其他都是西方的，所以这就导致西方学者自然很容易在上面发文章啊，这个不一定正确，但是我就是这么武断的认为了。然后呢，第二个什么呢？我们看这个期刊，它所关注的一些研究的领域，几乎全都是现实问题、法律跟政治问题、社会科学问题，很少有历史问题专门去探讨南海历史的问题。所以这就是一个非常大的一个局限。所以这里我就列了几点，我觉得可以思考的地方。第一点呢，就是正是因为这个当前依然国际学术界依然是以英文作为一个通行的一个学术语言，所以就导致了关于南海这个南海诸岛主权的认知和研究依然是受这个英文学术研究成果的影响，或者某种程度上而言是由英文学术成果去塑造的。那么第二点呢，正是因为这个语言的问题，那么西方学者他们发表了这么多的这个关于南海诸岛主权的历史的文章，但是这些西方的学者啊，他们的优势就在于能够在这种国际权威学术期刊上面发表，而给了很多非西方国家的学者他这样的一个机会，所以这是一种不对等、不平衡的。我们可以说，我们很多东方的学者没有办法发表，是我们自己能力问题，但某种程度上也是因为一个语言的问题，这是一个他们具有这样的一个天然的优势。那么第三点呢，对于很多南海域内国家而言，我们也可以看到，他们也在尝试去做这样的一个国际化，这个试图把他们关于南海的研究呢向国际社会推广。所以这个既包括他们这些学者不断的试图去融入国际学术圈，同时也包括他们试图不断的在国际期刊上面去发表他们的研究论文，并且也强调用西方的档案资料来给他们的研究这个提供这样的一个支撑。但是这样的一个问题在于，如果这些西方的刚刚谈到的像越南的这些学者过度的去依赖这个西方的史料，那么是否某种程度上忽略了对本地区史料的这样的一个充分的一个应用我们可以看到目前迄今为止，那么我们很多中文的史料在国际上其实被引用或者被使用的这种范围还是非常受局限的这是一个非常突出的问题。那么第四点呢，南海诸岛这个主权的研究，即便是历史的研究，它也受到这个政治的影响非常大。所以比尔海顿也指出所以很多它存在这种民族主义这种一厢情愿的思考，所以他们在这个史料的选择上面是片面的。所以我们可以看到大量的一些西方的学者非常武断的就认为中国在南海诸岛的这个主权是站不住脚的，即便他们没有充分的去理解中文的史料，但是他们就这么说了。所以他们是否能够真正的理解中国的这些历史、中国的史料吗？可能未必如此。那么来自越南、菲律宾以及其他一些域内国家的学者呢，我们可以看到他们的史料的选择也是非常主观和片面的。就刚刚这个越南学者的研究，为什么他们选择的资料大量的是意大利的、是德国的、是这个波西米亚、是比利时的？我们知道近代以来这些都不是在南海的主要殖民国家，南海主要殖民国家是英国、荷兰跟法国，为什么不从这里面找资料呢？是不是因为这里面的资料对他们的主权申诉不够有利，所以他们故意的片面的去选择这些呢？对吧？这是可以思考的。那么第三点呢，对于中国学者而言，在国际上关于南海历史以及南海诸岛主权历史的研究为何那么少？可能我觉得关于这个语言的壁垒，特别是语言资料、中文史料国际化的这样的一个壁垒，那么造成了一个非常大的一个障碍。所以他就没有办法非常全面的、综合的向国际社会去呈现这样的一个东西。所以我们在国内目前而言，比如说历史研究，我们可以看到中国史跟世界史是割裂的，但是南海诸岛历史的研究更多程度上是一个中国史的范围。所以如何把中国史研究能够向国际社会接轨，这是一个非常值得去思考跟探索的问题。那么第五点呢，就是与这个关于南海问题的研究，在自然科学、社会科学，我们可以看到大量的研究其实跟国际还是相对接轨的，但是历史的研究、人文的研究其实是相对受限的所以还没有获得一个足够的一个关注度。 可能这也是我们国内的学者在这一方面很突破的一个方向。所以怎么办呢？所以我个人提出一个非常重要的观点呢，其实也不一定重要，可能非常不重要的观点，就是我认为这个南海历史的研究需要 de-westernize 去西方中心主义和要强调一个多元化。这种多元化一是体现在这个史料的多元化，各种语言的这个类型的，包括对中文史料的翻译。第二个呢是一个理论跟方法的一个创新，所以我们需要更加多元化的一个分析的框架。今天我们上午这个议题呢，涉及到很多历史的议题，即便是安东尼卡利教授，他也是一个法律史专家，他不是一个非常一个纯粹的历史学家。所以历史学家如何在这个里面进行贡献，对吧？我觉得这个也是值得思考的。至少在这个分析框架上面，我们除了法理的框架以外，还应该有历史学的框架。所以在这个基础上，我们才能够去避免所谓的欧洲中心主义。所以我们要呼唤一种什么呢？就是当前的这种国际的学术界，由西方的这些研究所主导的，我们需要看到更多非西方的一个贡献，尤其是来自东方的贡献。所以我们希望什么？是 good historians write good history。然后呢，这个 good lawyers 可以 provide good narrative based on good history by good historians。所以我们可以看到，这个历史学家跟这个法律学家能够这种密切的合作，能够向国际社会提供一个更加客观的一个完整的叙事。所以这个吴院长这个主编的这个《南海历史与现实》这本书呢，可能就是这样的一个尝试。我们在座各位很多这个专家都参与了这本书，包括这个沈老师、周参都，还有台湾的这个王冠雄老师都在这里面做了一个非常大的贡献。所以我就希望因为吴院长想把这本书进一步翻译成英文，我希望就是通过这样的一个方式，一种跨学科、一个多史料、多元化的一个研究方式，为整个国际社会的这样的对南海问题的一个认知提供一个新的参考。同时呢，可能也是我们中国一直强调的自主知识跟话语体系的构建，能够做出一些应有的贡献。谢谢大家。
谢谢徐博士。我注意到现在我们的时间就刚刚是11:40，就是第一个完结。但是呢，我也注意到我们的午饭是11:40到2点钟。我猜我只是猜，可能主办方也让大家有一个机会，万一我们超时了，能不能在这里呢？我看见同意了哈，所以呢，我还是让大家有一个机会，看看有没有什么问题。没有的话，我们就午饭；不然的话，我们还是可以用一点点的时间来做一个讨论。那个现场有没有人有意见或是问题？你好。
Thank you. I have a specific question to Mr. Carty. And I have read some newspapers articles that stated it's U.S. government which provided some warships to the Chinese government to help China recover the South China Sea Islands after the World War II. Some Chinese archives can be found in China's museums. So I want to know whether you found these relevant archives in US or UK. Thank you.
I'm afraid I don't understand your question. I'm sorry.
Can I try and see if I've understood it for Professor Cartier? Correct me if I'm wrong. I think he's trying to verify that the information you have abstracted and relied on in your book came from the US and the UK archives as opposed to Chinese archives.
Well, the answer to that is obvious in the title of my work. My work is based on French and British and American archives, and I don't speak Chinese. And there's plenty of Chinese documents in these archives. But obviously, my contribution is partial. It's an attempt to look at what the French and the British have to say. And everything they have to say is supportive of China. So I don't really understand the point of your question, because the evidence that I produce helps China and can complement Chinese archives. I don't see any opposition there. I am very impressed historically from my work on British archives, and I'm an Irish citizen, and I speak as an Irish citizen here, as you'll be able to see from newspaper reports about what the work that I'm doing. I do see this as the study of colonialism. And what I find remarkable in the French archives, and even more so in the British archives, is the professionalism and objectivity of these archives. The British archives are so pro-Chinese that at a meeting with American international lawyers and American military lawyers, the British lawyers working in the British Foreign Ministry were accused of being panda lovers and Chinese sympathizers. Something which produced a very firm reaction from the Advocate General of the United States Pacific Fleet, who argued that that type of abuse of officials in the British Foreign Ministry was not appropriate and not helpful.
Thank you. I think just also to clarify, I think the question was premised for you to make that clear, because I think there were some rumors or some articles, some writers seems to suggest otherwise.
Yeah.
So I think it's for you to clarify that and confirm that. Mr. O and then Mr. Hoskin.
I think I'm just trying to clarify his question. I think it related more to, he was asking a very specific question about whether did you come across in your archival research, there were American offers of warships to China. I
Yeah.
would presume that was after the Second World War.
Yeah,
in order to recover all those islands.
Well, I have to be frank that I have been asked that question while I was doing the research, and I was not myself able to find any such evidence. But it has been pointed out that I am primarily an international lawyer and only learning how to do history. And it's quite possible that among the American archives, and maybe Mark Hoskin can help us here, among the American archives, there is some evidence of that, but I didn't find any evidence. But I would point out that for President Roosevelt, I mean, the tragedy of history, that President Roosevelt had survived and lived through to the 1950s. And that, I think the history of the South China Sea would have been quite different, because he was quite categorical to Chiang Kai-shek that all of these islands and Taiwan should be handed back to China, including also Okinawa, which he thought was Chinese. So Chiang Kai-shek disagreed with him about that. So that would be my answer there. But no, I have not been able to find about this question.
Thank you for that clarification, Mr. Hoskin.
I believe your question was actually about warships that were supplied and utilized by the expedition in late 1946, early 1947. Three of the ships involved were American. One was former USS Stetson, and the other one was the land tank, which was actually used for the surveys conducted down by the other train. Their names. And the interesting thing about all of those officers concerned was they were all trained by the Royal Navy during the war. Some of them even served in D-Day, at the landings in Normandy. But I have the history of that. When I do my presentation, I'll even show you a photograph.
Yes, please. It's a microphone over there.
Adopted by China in 1923, the Global Security Initiative and the Global Civilization Initiative, which seems to shift the focus on civilizations rather than territorial states as actors and subject of international law, and how these two blueprints would be applied to the South China Sea territorial and maritime disputes, given that the blueprints reject the notion of territorial states as the subject matter or even the subject actors of international law and international relations, and therefore render all this debate about territorial disputes and maritime disputes almost irrelevant within that framework. Thank you.
Any specific offer on who's going to address this question from our panelists?
Well, the notion of sovereignty is indeed an evolving one. It happens that now we are talking about sovereignty on nation states, and as various countries try to shape this notion according to their respective advantage, I would imagine that could sometimes evolve into, as you imply, some sort of civilizational sovereignty. But that's the nature of international affairs. I mean, we try to impose some form of rule of law on an otherwise very chaotic international dealings, and different actors would try to push for what thing is in their best interest. We just have to deal with it as it evolves.
I'm not sure whether I'm qualified to answer this question, but I'll try a bit. Well, if that instead of the GSC and GCI, whatever, China did propose for common security for the shared future. And China also, in terms of maritime affairs, we also, since the year 2019, we proposed building a maritime community with a shared future, 海洋命运共同体. Therefore, I think these initiatives and these proposals are not does not change the maritime claims of both China and we don't want to change. We're not trying to change the maritime claims of other states, but we wanted to stress, well, my interpretation is that we wanted to stress the common security and the common future that we're facing. We wanted to show that the ocean does not separate our blue planet, and we shouldn't be isolated continents and isolated countries. Instead, it links the people of all the countries to form this global community of a shared future, and trying to propose that we should remain bound together especially to enhance ocean governance as a global issue. That's my personal interpretation.
Now, any other questions? I think probably one of the last one or two. Yes, please.
Yeah. 南海的稳定啊，有几百年历史，上千年甚至没产生纠纷，这是一个历史的原因。因为东方体系跟西方体系是不一样的，对吧？它的纷争是从殖民化以后开始，殖民化以后这些国家变成了殖民地时期就变成了被殖民的，你的主权概念的引进，产生了界约而不疆域的概念。这个界约呢，大家划界。 于是才产生了很多分歧，这个分歧一直延续到今天。所以我说，东方体系的西方运理论研究，我们应该值得关注。为什么那个时候能稳定很长很长的时间？这个是一个我在考虑的问题。谢谢。
谢谢沈教授。Any other questions from the floor? If not, then I think we will have a longer lunch. Thank you very much.
Thank you, Mr. Researcher. And now it's for the lunch time. Please move to the canteen and follow our staffs. The afternoon sessions will begin at 2 p.m. Please return on time. Thank you. Political and legal implications of archival records. Please welcome the moderator for this panel, Professor Shen Guchao, Deputy of Collaborative Institute of China at NTU University. Professor, please.
好，各位嘉宾，下午的题目，大家可以看到啊，就是这个南海这个历史档案政治和法律意涵啊，这个题目很有意思。我们常常说啊，这个历史离不开法律的框架支撑啊，法律呢也要历史的这个证据来支持。其实历史和法律，我个人认为啊，后面都有政治影子。啊，所以这个仲裁案嘛，就是明显的一个例子。所以这个像今天下午的6个人呢，恰恰是来自不同的背景的啊，有政治学的，有法学的，啊，有历史学的，有地理学的，那还有2位在线上，所以他们是从各种不同的角度啊，给我们呈现啊这个演讲。那么因为时间关系啊，我们每个人还是跟上午一样，限10分钟，我们留半个小时，还有讨论的时间啊。好，这个第一位是 Mark 啊。这个介绍他们已经有了啊，我就不再去详细讲了。下面请马克来这个给我们发言。
Good afternoon, everyone. I hope you all had a good lunch and time to think about this morning's session. So I want to talk about history and law from an interesting, possibly, perspective, which is below the layer normally considered as a source of international law. So ICJ, of course, looks at treaties, the writings of jurists, and the statements made by politicians, and looks at those in turns as different layers. But then there should be a fourth layer, which is the people beneath the politicians, some of whom later become politicians themselves. And in that respect, there's 2 areas that I think are important in this. The first is the consuls and other representatives of governments, in particular, in my case, the British government that were in China. And the second one is the Royal Navy. And that's because not only were they patrolling the seas, protecting the sea lanes for British trade, but they were also gathering information, communicating it to the consuls and the minister in Beijing. And then also, as well as that, back to London. Some of them would go on to have very senior roles in the Admiralty. Some of them would go on to government. And so what they knew and what they held to be reasonable is really important in this. And so to me, we get a different understanding from that. And I'm going to start with someone who Professor Carty mentioned earlier, Monsieur Briand, Premier of France and an important French statesman. At the 1921 Washington Disarmament Conference, he asked Wellington Koo, "What is China?" Now, that might seem like an odd question. The response was the territory of China was defined by the Constitution. It couldn't be negotiated. And yet, when you look at the Constitution, that's really problematic because it doesn't actually tell you. I think Wellington Koo thought the question was illogical because as a Chinese, and a very highly educated one at that, it was essentially a stupid question. What is China? In territorial terms, you could say, look at a map. But there were no real national maps as we see today. And that brings up another question. If not, why not? It's not due to technological problems by that point. It's due to other issues. But this points to me in terms of perspectives. So how could this question be answered differently at that time? And if we're one of those Royal Navy officers, someone in the British government, a legal advisor, even a judge, because remember at this period the Crown Colony of Hong Kong existed, we start to find answers. For example, in 1900, the Land Court, when it was looking at Chinese claims to land in the new territories, which were part of the 1898 lease, found that the documentation of land included portions of the sea and the seabed, and some of those documents or land deeds went back to the Ming Dynasty, and they were accepted as being lawful. So at that point, it was accepted by an independent court, the Land Court, that Chinese could appropriate the seabed, the waters above it, and register it on a land deed. So the idea today that's mooted by some commentators about the territory of the South China Sea being something new, you can actually go back to the Tang Dynasty and find the same legal framework. The seabed can be appropriated. The interesting thing is you can also find under Chinese law was that you couldn't disturb anyone else's navigation over that area which you had appropriated, registered, and legally owned as a result. So I find that interesting. The other thing that happened in 1921 is the Supreme Court in Beijing held that if land and materials were used to construct a temple or any other religious structure, that is state territory. Now, all you have to do is go back into British navigational records as published, and you will find Chinese temples on all of the island groups in the South China Sea, except Macclesfield Bank, which I'll get to later. And so that land is Chinese territory. It's state territory. So those perceptions would have been things that fueled Wellington Koo's response. A last point before I move on is at this time, Dr. Sun and the government of the South in Guangzhou had representatives at the Washington disarmament talks, and China acceded to the open door, which is, of course, a treaty. And one of the articles in it states that China will not cede or otherwise alienate any Chinese territory. Now, after the British learned that Dr. Sun was thinking of leasing Paracel Islands, Sisha, to a Japanese business contact of his from when he was in exile there, they told him he couldn't do that because that would be alienating Chinese territory and therefore breaking the very treaty that China had just acceded to. In other words, they used an international legal argument. But when you look at that fourth layer that I mentioned, who knew that? Dr. Sun, of course, did. Who else was there at the time? Chiang Kai-shek, Jiang Jieshi, Zhou Enlai, who was the political officer at the Whampoa Military Academy, and Mao Zedong. In other words, everyone important at this point in Chinese history up until their deaths was there and knew this. So it should be no surprise later on that they say, well, this is Chinese territory. We know it from the British. And remember, at this point, Britannia still did pretty much rule the waves. So it's an important reference point from an external source. But so when you look at this, and there's a US historian, old Arnie Westad, it's pointed out that when you look at China, and so therefore to me, when you're answering this question, what is China? You look at the intersection between the internal and the external, and you find some of the most important aspects
of Chinese mental maps, borders, diasporas, ethnicities, trade, and the exchange of ideas. They carry with them concepts of justice, rules of behavior, and views of China's place in the world that have been shaped by practices developed centuries ago. Remember, I said you could go and look at the Tang Dynasty Code and find that you could appropriate the seabed or the waters above it and register on them on a land document. It fits with this idea of how we can think about how these ideas came into practice. But there's something else. So 45 years before the Anglo-Sino War, the First Opium War, was instrumental in the opening of 5 southern Chinese ports to trade. A barrister, Robert Ward, wrote that what is commonly called the law of nations falls very far short of universality, and that, therefore, the law is not the law of all nations, but only of particular classes of them, and thus there may be a different law of nations for different parts of the globe. Now, I look at that, and I won't read the rest of it, you can all do so, and I think, okay, this makes perfect sense to me. When we look at the Treaty of Westphalia, which was mentioned also earlier, it was already too late. There was already an idea of an international law in this part of the world. There were already concepts of appropriation of land, of sovereignty, of what people could do that determined what was a sovereign's territory. And so he has a good point, and he's making it about the same time as the Macartney expedition was heading for Beijing. Why? Because Britain wanted more trade with China and wanted to stop the outflow of silver. But anyway, so if we look at that, what does that tell us? It tells us we need to look further. We don't just say, here's international law, here's the body of it, and apply it. We can't. To this very day, there's disputes over aspects of international law simply because people provide a regional perspective, one based on their own culture and society, which may not be a Western one. So when I talk about that fourth layer, I think this is a good starting point and a good methodology. So Western international law jurists, this was written by a Chinese, wish others to study only the formal sources of international law and not the substance of the sources. It is more important academically to study the origin of a matter in order to trace its substantive sources. That's that fourth layer I'm talking about. The people that knew, that observed, that operated on the basis of what they knew and observed and saw in others on that regional international law, which was not necessarily one of their own country or region. And if we do that in terms of the Royal Navy, which is my particular interest in all of this, we start finding things. But we can go and also look in other countries, and we can find other perspectives that match this. We look at what Prince Gong had to say to the Prussian minister after the ship Gazelle went and captured 3 ships in the Bohai. The various oceans under China's jurisdiction have, as a rule, been specifically stipulated in all her peace treaties with the foreign nations, and in the peace treaty with your nation, Prussia, there is such a term as Chinese Ocean. You know this more clearly than any other country, and how can you say it is beyond your comprehension? In other words, you already know this. The South and East China Seas, the Bohai, the Yellow Sea, those are the Chinese oceans he was talking about. So this gives us a historical perspective, but also one that leans on international law, treaties. So when we look at that and we start thinking about China, what China is, what it became, and how it was portrayed in the late 1940s and early 1950s, as this map shows, we see something that matches very closely what we would see today. When we look at this lovely island of Hainan, we see exactly the same thing in more detail. And you will, of course, note at the bottom right-hand corner, as you face it, nope, I didn't put it here, the dash line. Where did I find this? I found it in the Library of Congress. 1947. So it's really hard for an American to say we didn't know about the dash line in that period when there's a map sitting in their own archives that features it, that has a provenance that's indisputable. And so when we look at these things and we start asking back that central question, what is China, and then direct it at the South China Sea, before many of the disputes of today began, before many of those states had even reached a level of decolonization independence, we already find that people in the West knew about this and they didn't say no to it. So when we look at this, and I go back to Germany, there's something very common that's thought of here in China. I've seen this published in many different volumes. And I won't read it because I'm being told I'm almost, or if not already, out of time. So I'll bear your indulgence for a couple of minutes. So if this is the case, how then could Prince Gong, who was the head of China's foreign relations with Germany, actually have made this protest or even communicated it? He couldn't. It is a very common story. This is the original source of it. No citation, nothing, and it's not true. Why do I say that? Because I've read the treaties, as Prince Gong said. Why do I say it in detail? Because here's the survey results as published by the German Navy after the surveys were completed. What did they find there? Fresh water. They tested it. It was good drinking water. Food, vegetables, sweet potatoes, and of course, the fish in the sea, and links to Chinese fisherfolk who went there regularly. So how did this happen? Why were the Germans allowed to be there? This is, by the way, the memorial to the captain of one of those vessels, because he actually died, and this was on the Bund in Shanghai. So we know they were there. This was created in 1885. And this is why the Treaty of Tianjin. So whenever national vessels of the United States of America and cruising along the coast and among the ports open for trade, for the protection of the commerce of the country, or for the advancement of science, surveys. This is, of course, also a tacit recognition of the fact that the Chinese government could stop national vessels from other countries from sailing in Chinese waters. In other words, freedom of navigation did not apply, didn't actually exist at that point. So when we look at those things, there's a problem and there's a basis. When we look at the things happening out in the Paracel Islands, like this wreck of the Paladin in 1882, about the same time as the Germans were out there, the response didn't come from anyone but the Chinese. Commander Wei in the gunboat Sushing pacification rescued the Paladin crew. 55 passengers and crew were rescued. He got promotion and a monetary reward which the British government requested the Chinese government do. So here we have jurisdiction, here we have an act of sovereignty, and here we have the fact that people, sailors, are being rescued at sea and on those islands by Chinese, and that's been recognized by a foreign government. But who knew that the Paladin was wrecked there? How did that news get back to Guangzhou with the junks of Chinese fishermen? And so when you start looking at the development of the modern Chinese Navy in industrial terms, they were learning all this information as they sailed in the South China Sea. And here's representations of them sailing down to Singapore, Jakarta, in that region. And I have to quickly go through these, but later on in their voyages too, including on the Dingyuan, the Beiyang fleet were down there. I even have the Christmas dinner menu from 1988 on the Pescadores. And so when you look at it and you look at what people in China were able to do, islands are becoming part of the main, and the whole littoral is gradually advancing into the Pacific. And this was the British hydrographer telling Parliament this. You start to see all of the elements that stand today. And this was learned by Chinese naval officers, particularly those who went to Greenwich for advanced staff training, including a young man by the name of Sergeant Bing. Why do I think he's important in this? Because in 1908, he was actually writing to his British counterpart about the fact that he'd been in command of most of the naval vessels of China, and that some of those vessels had gone to Manila, Saigon, Bangkok, Singapore, Java, and Penang. In other words, they had sailed throughout the South China Sea. How, as navigating officers educated in the English language, did they do that without reading British hydrography records, otherwise known as the sailing directions? And what else would they find in them? All of those records we look at today and say the only people sailing there and fishing in there were Chinese. Admiral Sa is important in this because he was, of course, later a premier of China. He also lived to 1952 and fought Japan in 2 wars. And at the same time, when the French went and claimed the parasols as suzerain, not sovereign, they did so because of the Japanese, not for any other reason, just like the Filipinos would say they did as a historical memory in the 1970s. And so when you look at that, and then when you look at what Cloma did in the 1950s, statements made today are often incorrect, like this one. Manila made Cloma return the flag that he took from the islands, using force, by the way, disavowed his actions. In legal terms, I believe that's called estoppel. And then you get what the Vietnamese had to say. Prime Minister Pham accepted the declaration of the territorial sea with its claim to the islands in a speech made by Zhou Enlai, and then later retracted it and said, well, I only did that because it was wartime. Oops. Anyway, I'm now being told, and this is my final point, so at that same year, 1956, as Cloma was out in the islands and then told to return the flag and not do what he did again, look at the bottom, Macclesfield Bank. As this is still submerged, I fail to see that anyone has any right to it as it is part of the high seas. That was the Naval Intelligence Division at the Admiralty. And yet, all you had to do was look back in history to 1930 when the Royal Observatory said at Conference of Directors that there was a great importance due to meteorology in the China Seas, and they liked the one on Dongsha Pratis established by the Chinese government. And then they expressed the hope and voiced the desire that similar stations be established in zones not yet represented, especially on the Macclesfield Bank and the Parasols. But it's in the high seas. How on earth are they going to do that in 1930? And the answer is they could. At 4.5 fathoms, at its highest point, you could build a lighthouse and meteorological station on Macclesfield Bank. And in Chinese perspectives, as you can appropriate the seabed and the waters above it, put them on a land deed, why is this a problem if technology allows you to do so? And so these are the things I look at. And I won't go any further into it because I've run out of time, but think about this. These gentlemen, I call them that because they're naval officers, are photographed here at the Royal Naval College, Greenwich. Some of them would drive landing craft at D-Day on the Normandy beaches. Some of them would go on in 1946 to receive the islands and reclaim them for China from the Japanese. Why would they do that? And the answer is the knowledge that they had gained beforehand. So this is an old picture of Admiral Sa, who lived to 1952 on the mainland, where he died in Fuzhou in his home. What did people like this know, and what did they inform respective governments? That's what I find interesting, and that's what I want to learn more about. Thank you.
好，Hosky Mark 啊，这个你们可以看到他的资料丰富了啊，就是我跟他交往也很长时间，有一些东西我说我在英国档案馆没查到，你怎么查到的？他用的不光是这个国家档案馆啊，所以我在给他解决他这个要求，我找东西的时候不是那么容易的啊，你看到他的资料就是找得很细，这个是啊一直是不容易的一件事情啊。那个我们之前交往很多啊，就是也查了很多。他这里面提到了一个，这个南洋水师这个他很有研究，那很有研究的这一块。其中提到了一个疆域的问题，威斯特伐利亚的和中国的这个问题，这里面确实是里面一个很重要的一个问题，两个大体系不完全一样。这个殖民主义的5种领土获取方式啊。到今天还是让人很有影响，这个我们不完全按照这种方式来，所以这方面，我想我们在以后的沙龙里面还可以再进一步讨论。好，因为其中有一位线上不能来，他这个因为网络的问题，所以时间我们腾出来了啊，所以我稍微放了一点时间。哈哈。下一位是这个王冠雄老师，台湾师大政治学研究所主教授，他的这个题目上面已经讲了啊，我们欢迎。
Thank you, Chairman, Professor Shen. First of all, I would like to express my sincere thankfulness to the co-organizers. That is the National Institute for South China Sea Studies, Huayang Center for Maritime Cooperation and Ocean Governance, and Zhejiang University Center for Ocean Law and Governance. Good afternoon, ladies and gentlemen. The topic that I'm going to present today is the China and the South China Sea, a study from the archive. First of all, I would like to say that for some of the Taiwanese scholars, including me, we had conducted a project of collecting those official archives covering the history of Chinese practices in the South China Sea. In addition, we also paid attention to the studies on the relations between those archives and its political and legal implications. So after that project, we had an exhibition of the Republic of China Southern Frontier Archives in 2014. So it is almost 10 years ago. However, there are still a lot of issues that we could find out from those archives. So what I'm going to present today is to offer some views from Taiwanese scholars' perspective. This is the outlines that I'm going to present today. There will be 3 parts. The first part is the China and the South China Sea Islands or reefs. The second part is about interpretation of the lines. And the lines, of course, that is about the so-called U-shaped lines. And then the third part is the law enforcement that has been done by the Republic of China government. First part is the China and the South China Sea Islands and reefs. For those archives, there are a lot of documents that we can find out, but I think this one is quite interesting because first of all, that we can see that the title Asiatic Pilot, this document is published by the United States government, the government agency called Government Printing Office. So obviously, it is an official publication recognized by the United States government. And second one, it was published in 1925. So we probably we could find out some of the situations, the real situations, and what happened in the South China Sea during that period of time. And the area covered by this Asiatic Pilot is the western shores of the China Sea from Singapore Strait to and including Hong Kong. So that is the region covered by this publication. And in this publication, there are several parts. And actually, it was divided by the exactly the those parts. Just like Chinese mentioned, Dongsha Qundao, that is Macclesfield, and Xisha Qundao, Pratas, and also the Nansha Qundao. So let's take a look at the Pratas issue. I highlight the points that I'm going to raise your attention is, let's look at the highlights one. It offers shelter to the Chinese fishing craft, which came here in the early part of the year. So it means basically that we can see that for those islands or reefs in the Pratas Islands, there are a lot of Chinese fishing craft. They came here and take a rest during that period of time. And second is the Xisha Qundao parasols. It talks about the tree island and especially the anchorage point for the tree island. And I highlight the sentences. It says, it is much frequented by Chinese fishermen, the southwestern side of the island affording shelters anchorage in the northeast mansion period close to it for yunks. And so that this is the another proof that the Chinese fishermen, they traveled to this area for the parasols. Another case about the parasols, for example, the last 3 lines, the Chinese fishing boats anchor on the reef between the 2 islands for those two islands that we can find out from the first paragraph of this page. So let's come to the Spratlys. And I would like to raise your attention to the second paragraph. I also highlight those terms. Basically, now we are in Hainan. Therefore, very interestingly, that we could find out the Hainan fishermen in the Asiatic pilot in 1925. And it says that the Hainan fishermen, they stay there by collecting trypan and tortoise shell, where found upon most of these islands. Some of them remain for years among the reefs. And second part is the Yunks from Hainan annually visit the islands and the reefs of the China Sea with supplies of rice and other necessaries, for which the fishermen give trypan and other articles in exchange. Therefore, it is a kind of way to keep their living and stay in those islands. And the third part is the Yunks leave Hainan in December or January and return with the first of the southwest monsoon. Therefore, this kind of trade happens frequently. And the last sentence is very important. The water found in the well on Itu-Aba Island was better than elsewhere. It is very meaningful because Itu-Aba is the Taiping Dao that we call it from the Chinese side. Taiping Dao or Itu-Aba basically can have much better water. So it means that Taiping Dao can sustain human habitation, can keep people live there. And also, let's comes back a little bit from the previous sentences. It says some of them remain for years among the reefs. So according to UNCLOS 121, paragraph 3, is that a kind of element that could sustain human habitation? And also, for another sentence, it says that they exchange those trypan. Trypan, it is the so-called sea cucumber and also the tortoise shells. So they exchange it. It becomes a kind of economic life. So definitely, Taiping Dao or Itu-Aba can sustain human habitation and its economic lives. So that is the archive that we can find out to support that the Chinese fishermen has already been there for a period for a long time. And secondly is the interpretation of the lines. In the 1946, the Ministry of the Interior of the Republic of China, they made this sketch map of the South China Sea island location. And then what is the purpose for them to make this map? That is because after the end of the Second World War, Chinese government planned to clarify its maritime frontier, especially for what is the islands that they could recover from the Japanese. So another archive that is quite interesting. First of all, I would like to zoom in for certain part. And for example, but just today this is an international conference. So I made an interpretation about this part. On 1946, September 25, meeting for recovering South China Seas. That is the meeting minutes. So for the first resolution is how to define the range for recovering islands in the South China Sea. And then we reach the conclusion. The recovery range is in accordance with the sketch map of the South China Sea islands location made by the Ministry of the Interior. So that is the map that we had seen previously. And then afterwards, the Navy, they copied and reproduced the map produced in 1946 by the Ministry of the Interior. And then after they recovering those islands and the ships came back from the South China Sea, they made this map in 1947. That is the location map of the South China Sea islands. However, there are a lot of questions about what is the lines, what does the lines mean? So I check more detailedly about those maps. For example, if we look at the northwest part of the map, we can see the first line is an extension from the land. It's an extension from the land. And then they use the same symbol. It means, I presume, it means that at that time, the Chinese government has that idea that we would like to extend the boundaries from land to the sea. However, for the sea area, it has to be decided by the negotiation between China and its neighboring countries. Therefore, they made it into 11 segments. And another part is here. Quite interestingly, actually, we should call it not only 11 stroke, but it should be 12 stroke, because we see there is a stroke to the east to divide the Balabac Strait between Philippines and Malaysia. That is another interesting thing. Why did Chinese government to divide the sea areas for Malaysia and the Philippines? And then very possible, this line also means a kind of division of the sphere of the power. And then how come there are 11 stroke to form this U-shaped lines? I put the yes and no. For those stroke, I put the mark, circle mark. It means it is in the middle of two sides. And two sides, we also can find out the length. So this is a very preliminary conclusion for my watch, for my view this kind of map. I would like to say the methodology for making the U-shaped lines is through the median line, and then the claiming islands, reefs, or rocks never claim the sea area. And it will be a kind of boundary line implication, but subject to future negotiation. And the last one is to enjoy and exercise preferential rights over waters. So another issue is about the law enforcement. I would go quickly because I know the time has gone. The first, I have to say something about the background. In 1946, November, China recovered the South China Sea islands that I have been discussed. And then 1956, May, Thomas Cloma, Mark has already mentioned that event. Thomas Cloma and 40 people from the Philippine Maritime Institute announced the occupation of several islands west of Palawan, Philippines. And Cloma said that they are terra nullius, which means no man's land, and no sovereignty belongs to anyone. Therefore, they occupied those islands. And Cloma even declared the establishment of a new country, Free Territory of Freedom Land. So this is the background. Let's look at the another archive. These two photos shows an issue happened in May 1956. Nan Yuan Naval Special Task Force, that is from Taiwan, the Republic of China, the naval fleet intercepted a training boat from the Philippine Maritime Institute in the waters of the Northeast Cape in the Spratlys. And Captain Philemon Cloma, he is the Thomas Cloma's brother, and was invited to the Nanyuan ship, and then to sign and affidavit recognizing illegal entry into the Republic of China's territorial waters. And from this study project, I also, the Taiwan scholars also found out this document. So I zoom in for certain part that we can see the Philemon Cloma said, we will not make further training voyages or landings in the territorial waters of your country. So obviously, at that moment, Philemon Cloma and I also believe Thomas Cloma, they understand that this is the area and which belongs to China, and the either for the land or the territorial sea. Okay, so I will come to the final part. That is, I believe the archives tell history and tell the truth. And the archives are the historical basis for international law claims. And I'm really glad that to be invited into this very important conference, that we could discuss the issues and combine the different evidences, including the archives, including the legal discussion, and including a lot of probably cultural discussions. So I believe that more studies on archives are needed, and I also wish that we could continue this kind of discussion and cooperation. Thank you very much.
感谢王冠雄教授啊，他的这个讲到了这个档案这一块啊，涉及到的是2014年的这个台湾的那个两岸南疆展，王教授负责的，我们这很多人说，他们的原型、记录性、客观性这三大性真实的记录真实的情况，感谢啊，下面呢，我们是来自于印度尼西亚啊，印度尼西亚的，那印度尼西亚的这个叫Ahmad Custom System Wangdi Associate Professor University of Pachadala， 他是这个法律系的一个教授，他在线上给我们这个演讲啊，下面请Ahmad给我们做。
Thank you. Thank you very much for the introduction, Professor Shen. Very good afternoon to you all. First of all, I would like to thank the co-organizers, the National Institute for South China Sea Studies, and also the Wayang Center for Maritime Cooperation and Ocean Governance. I apologize that I cannot be there in person due to other pressing commitments that I have to attend at home. So it's been interesting to follow these discussions on the history and law in the context of the South China Sea. And I would like to share also my views. And in this context, allow me to offer perhaps rather different perspectives in the context of how these implications of the archival records. And I would like to offer my point of view from the development or the formulation of the archipelagic states regime, in which Indonesia was taking part in this formulation under international law. And we have witnessed this very strong interplay or interaction between law and history. So I would like to introduce a little bit about the context further in the first part of my presentation. And then I will move on to the Indonesia's maritime history as an archipelagic state, which is actually, we use this as a basis for us to claim ourselves as an archipelagic state, particularly during the negotiations of the Law of the Sea Convention in the 1970s to 1982. And then I would like to focus more on this interaction between history and law in the formulation of the archipelagic states regime, and how we could perhaps draw some lessons from this experience to the South China Sea context. And at the end, I would like to also deliver some concluding remarks. So, ladies and gentlemen, distinguished participants, allow me to start with a quotation from Dr. John Henrik Clarke, who says that history is not everything, but it is a starting point. I think it is highly relevant in our discussion today that history is important. It is significant to development of international law. But at the end of the day, we also have to realize that there are many other factors that will come across this history or archival records. And we have to deal also with the political and legal implications. So we can start from history. It's a very important starting point, but then other factors must also be taken into account. So allow me to perhaps move further back to this, one of the landmark cases settled by the International Court of Justice back in 1951. And it is also a case which lays some fundamentals for the claims of Indonesia as archipelagic state. If you look at the decision of the court, we can see a number of paragraphs that reveal the interaction or interplay between history and law. So this case was about the dispute between the United Kingdom versus Norway regarding the action of Norway in determining its strait baselines. And in this judgment, the court clearly said that, well, if you want to apply this special method of drawing strait baselines, then you may have to demonstrate the certain economic interests peculiar to a region and evidenced by a long usage. And here also the court looked at the Norwegian government historical records and also the implementation of the law of Norway, that it did have this regulation over the matters on the exclusive privilege to fish and hunt whales for the Norwegians, granted in the 17th century. So the historical archives and the historical point of view of the Norwegian government played a significant part in the decision. And the court decided that Norway did not violate international law by applying these strait baselines, taking into account also the history of Norway. But interestingly, if you look further on the judgment, there is also this separate opinion of one of the judges. His name was Judge Sumo. And in this respect, the Judge Sumo pointed out that, well, yes, Norway has successfully demonstrated the historical part of the action in applying strait baselines. But one of the lacking on this action of Norway is that the lack of precision. So there was no clear evidence about the prescriptive claim to areas of water on which the Norwegian applied its law. So I think it is very interesting to see this separate opinion, because then we can begin to see how this historical claim also needs to be justified. And as Judge Sumo here pointed out, that the precision is one of the keys to justify your historical claim. And it all boils down to, I think, the legacy of the fisheries case in 1951 has been very rich. It then also impacts the progressive and also the current development of international law, in which we have to also take into account the fact that, well, when we determine the maritime boundaries, then the validity of this delimitation with regard to other states depends upon international law. And across these various provisions, especially the Law of the Sea Convention in Article 7, we can see this reflection of how states are entitled to claim their maritime domain or maritime boundaries. But then there are these conditions that they have to fulfill. They have also to take into account this, for instance, general international recognition, and also the evidence of long usage. And it was also applied in a number of cases decided before the International Court of Justice. One of them is, for example, in Qatar versus Bahrain, that when a state is privileged to apply strait baselines, one thing that has to be a caveat is that the method of strait baselines must be applied restrictively. And as we know, the provisions on strait baselines paved the way for archipelagic states to also come up with the concept of the archipelagic baselines. So let me move on to now the Indonesian context. So we also rely on our history as a maritime nation when we develop our arguments before the conferences of on the Law of the Sea, which at the end of the day adopted the Law of the Sea Convention in 1982. So according to our historical evidence and also some archival records that have been there for a number of years, we learned that at least we have this evidence of dominance over the maritime areas during, for instance, the Sriwijaya Empire, which covers the areas surrounding the western part of Indonesia to the Indian Ocean and some parts of the South China Sea. And also moving to the center of the archipelago, there is this Majapahit Empire, which also had the dominance over the land and maritime territories at that time, particularly from the year of 1293 to 1527. And also in the eastern part, according to our historical records, we have these actions and also the voyages of the Bugis Makassar seafarers. And they recognize this notion of free seas. So they consider this also as a way for them to explore seas further out of the Indonesian archipelago. But then, of course, we experienced this Dutch colonization, and the Majapahit and Sriwijaya Empire did not last. Until then, we were colonized by the Dutch. And then we rely also on these archival records of the Dutch government regarding the claim of especially territorial sea, which is reflected in the beginning from the 1918 Maritime Districts Ordinance, which was further revised by the ordinances in 1935 and 1939. So these have also been serving as the evidence of the maritime claims during the Dutch colonization. And we formulated this even further, that we consider the unity of the land and water, which lays down the foundation of our archipelago and Indonesia as an archipelagic state. And after the independence, then we declared this archipelagic outlook in 1957, which was known also as Juanda Declaration. And this declaration was further formalized in the form of legislation, which was the law number 4, year 1960 on Indonesian waters. So based on this historical development, then we built up our arguments, and then we presented, and then we argued before the conferences on the law of the sea, which took part from the 1973 to 1982. And during the negotiations, then we came to recognize that, well, here's where we then, as an archipelagic state, was trying to put forward our claims. We had to deal with the facts and reality that we need to justify these historical claims. So the concept that we brought forward during the negotiations was not only criticized by the maritime powers at that time, but also from the African and Asian states, and also our neighboring states. So in this context, at that time, the Indonesian delegation realized that, well, as I said, as I mentioned at the beginning from the quotation, that well, history is a starting point, but then there are many other factors that need to be taken into account. When we bring up this history of Indonesia, then we also need to deal with the history of our neighboring states. So this, for instance, was resulted in this compromise clause, especially with Singapore and Thailand, and also to some extent with Malaysia. And then we know that now under the Law of the Sea Convention, there is this Part 4, especially Art 51 and Art 52 and 53, where we have also to recognize the rights of especially our adjacent neighboring states to enjoy the rights of passage and also traditional fishing rights. So which are also the historical claims that belong to the neighboring states. So what can we learn from this experience? I hope that I can contribute in this way for the discussion, that we look at our history also when we develop our argument as a starting point when we argue this concept or formulation of archipelagic states. But then during the negotiation, then we had to realize that, well, when we talk about history, when we talk about the archival records, the other delegations may also question their validities. So throughout these very intensive negotiations, then we need to take this compromise approach because of these archival records at the end of the day have caused these political and legal impacts. And well, if we compare with the previous version of Indonesia's archipelagic state concept, it may not be what it looked like, what we see at the convention. So the Law of the Sea Convention did not give Indonesia everything it fought for, but there was the consequence that we had to take, because the justification of historical claims, we realized that it deals with these complexities of history on one hand, law on the other hand, and politics on the other. We need then to realize these complexities, and I think what we were able to manage as an archipelagic state is that we could live with this compromise approach, and we can get what we fought for, although not everything, but now at least it is already there in the convention. So as a conclusion, I hope that I have offered some helpful observations on the interaction between history and law, viewed from the archive-like state regime, because what we experience also this interplay and interaction between history and law was very intensive during the negotiations. And now we need also to implement those compromise as a part of our implementation of the Law Society Convention. And I think when we talk about this historical claims, archival records in claiming maritime areas, or in this case also maritime boundary delimitation, it is interesting to note that I quoted here one of the research from Catalina Garcia and Gupta, which observe about the validity of historical claims in maritime boundary delimitation. So according to international law, when deciding the boundaries, the court can also take into account these relevant circumstances. And it's particularly interesting to note that most of the historical claims have been regarded as invalid. So I think that tells us that they need, I echo other speakers before me, that we need to have more conversation about this legal aspect and also historical aspect, and how we can then find the balance on how especially to justify the historical claims. That also applies in the case of maritime delimitation. And finally, I would also like to add that when we talk about this history and law in this context of the South China Sea, I think it is also important for us to try to look for this important role that history and law could play in achieving the ultimate objective of UNCLOS. So far, I think the discussion has been very much centered on the sovereignty. That's fully understood. But I think what we need to look at also, what is actually the objective of the Law Society Convention, is not only the due regard for the sovereignty of states, but it's also attempts to create this legal order for the seas and oceans, and also the peaceful uses of the seas and oceans. And I really hope that this discourse between history and law could help us to achieve these objectives. With that, I conclude my presentation. Thank you very much for your kind attention.
Hey, thanks for Professor Sitwand. His speech gave us the lessons about understand Indonesia's maritime history as a straight point in the illegal formulation of archipelagical status, especially circumstances. That's very important. Thanks.下面是因为那个丁老师来自上海，丁老师他的网络上有问题，所以这个暂时就不能连线啊。我们接着往下。下面是Lisa 对OK 是这样。梅丽莎罗亚，她是哥本哈根大学博士后研究员，大家欢迎啊。
Thank you for the kind introduction and for this opportunity to present in this forum. I shall be presenting not a scholarly work, but rather a personal account of how I engage in research using archival materials and try to publish those research outputs. So the title is The Political and Legal Significance of International Law Research Using Archival Materials. Okay, I shall just make 3 points within the 10 minutes allotted to me. First, I will mention some difficulties involved in the process of research and publishing using archives. Second, the importance of using archives, notwithstanding the difficulties. And finally, the methodology that I used in publishing those research. So the difficulties are numerous, but the most obstructive of all is the state of legal scholarship today, where you have peer review that is blind, but at the same time woke, in the sense that you have reviewers trying to impose their advocacy on the scholar. And I had this recent experience when we published a blog citing an archival material coming from the US National Archive. This particular memorandum telegram was issued by Kissinger in 1975 to respond to the question coming from the US Embassy in Manila whether the US shall apply the Mutual Defense Treaty in the event of an external armed attack on a feature in the Spratly Islands that's being claimed or occupied by the Philippines, or on forces of the Philippines occupying those features. And here, Kissinger categorically declared that the MDT shall not apply to those instances. And the basis cited by Kissinger in this particular memorandum is that, one, the Philippines is not a claimant to the Spratly Islands because it is barred by the 1951 Japanese Peace Treaty as a critical date. And number two, the US, in its ratification and concurrence to the MDT, never had any conception of the Spratlys being part of Philippine territory. Now, when we tried to publish this, we were subjected to a review coming from all places, my alma mater, University of Hong Kong, where a particular professor tried to impose on us the line of thinking that we should be attacking China rather than exposing this particular archival record. And so this professor tried to make us talk more about the Chinese Coast Guard law rather than clarify the position of the US in the South China Sea. And our response was that the purpose of our blog was to discuss this memorandum rather than to discuss the Coast Guard law of China. And so we refused to follow the bandwagon that we see in current legal scholarship and had the blog published by Asian Journal of International Law. Now, notwithstanding that kind of difficulty, I pursue archival work in international law, principally because I believe in what is known as law in context, and that I learned international law, I teach international law, and I know states formulate and apply international law always in context, particularly historical context. And in my current research on the Global Civilization Initiative of China, the use of history is mandated or is compelled because of the formulation of Global Civilization Initiative and how it will apply to the South China Sea. So in that sense, I am stuck with archival research in my work. Now, my purpose in sharing the methodology that I use is to encourage scholars all over the world to use archives when doing international law research. And I adopted certain personal criteria that, for me, were effective in that my research were published in Western international journals. Therefore, I meet more or less the Western standard, address the point raised earlier by the last speaker. Now, the first criteria that I apply to myself is primacy. Now, this particular archive known as Adam Matthews Database is accessible through wealthy libraries such as the Library of the University of Hong Kong, my library in the University of Copenhagen, and so on.
Now, it contains primary sources. The database would itself indicate which are the primary and which are not. Now, one of the primary sources would be what is known as Foreign Office files. So there are numerous Foreign Office files per category: Japan, China, Africa, and so on. So this is one particular example. Now, why is this primary? Simply because the authors of the record and the actors in the acts being recorded are what I would consider to be performing acts of state. Therefore, there would be memorandum issued by presidents, exchange of notes between presidents, or exchange of letters, or exchange of conversation or memorandum of conversation between foreign ministers. So those are what I consider to be primary records. Now, there is another, what I would call the primary record, which is not essentially considered an act of state, but primary in the sense that the person performing the act which is being recorded has the authority to perform the act in relation to an issue that has international character. And so in this particular instance, for instance, the account is rendered by a consular officer. And the account being rendered is not in relation to a particular political issue, but rather a report about religious events, religious riots, for instance, cultural makeup of the population, economic activities, and so on. So it would depend on the research that you have or the research question that you're trying to address, whether this particular type of document would fit or would suit your purpose. So that's the second criteria that I try to use. Now, the most important for me is verifiability, meaning the archival record has to be verified in terms of the physical copy. And in this particular archive, you will see that the material itself, the repository of the physical material, is the National Library of Scotland. And therefore, any researcher after me can go to that library and verify whether the account I'm making in my article is truthful and factual. And this particular archival material comes from what is known as Gale primary sources. Again, this is a database that can be subscribed to by libraries. And of course, the HKU library is a wealthy library, and it has access to all of the Gale sources, whereas the University of Copenhagen does not. But although I have applied for access to this particular material. Now, I do not simply look for verifiability in terms of the physical material or the physical copy. I try to adopt what I call for myself as triangulation, or sometimes a rectangulation, meaning I verify a primary source and look at a non-primary source, but a source having direct experience, firsthand experience of what happened. So in my current research, I looked into official accounts coming from the US, French, British, etc., about religious riots breaking out in the port cities in China. And then I compare it to the accounts of the Chinese government, and then I compare it to the account of the missionaries and the account of the local officials. So it's a rectangulation, because oftentimes the account rendered by the state officials coming from the UK and so on, making a claim against China for indemnity would oftentimes be bloated. Therefore, the need for triangulation. Again, here you would see that the material is verifiable, and this one can be found in Cornell. Right. Now, earlier there was a mention of the need for more scholars to cite Chinese archives. I would love to do that in my work. The problem is that the Chinese archives are not accessible to people like me who do not speak Chinese and who have no money to go to the museum. But the alternative is for China to to digitalize its archive. And this has been done by a number of governments. One is Qatar Digital Library, which I used extensively in my own dissertation. And let me show you a particular archival entry. Here is the Arabic script of the transaction, and here is the English translation. And I would consider the translation official in the sense that this particular archival record comes from the government itself, in this case, the British government, and it was preserved as a record in the archive of Qatar. Now, it is not just Qatar that has digital copies, which are accessible even without the need of having to go to Qatar. You have the US, UK, but UK is a bit limited. Australia, Middle East in general, you also have that. And Singapore, even Hong Kong has its digital copies of archives in its possession. Now, let me go to the foreign relations of the United States. And I find this very important archival database in the sense that always there would be a translation of a Chinese edict, Chinese letter, etc., embedded in the record or the report of either the consul or the state minister or the State Department or the conversation of the president. Always it is embedded there. And there's always a reference to the earlier communication. And therefore, you can trace back if there has been any changes in the position taken by the officials of the US government in terms of interpretation of a particular treaty, for instance, or its formulation of the norm that should apply to a particular conflict or issue, then you can easily trace. So this, again, is a form of triangulation that you can perform. Of course, I usually always try to compare the archives of the UK and the US in regard to specific issues. And it's very apparent that they would have internal disputes with respect to the interpretation of a situation and how they would address it. So that ends my talk. Thank you very much.
Well, I have some problem using the archives. Yes, in the eyes of legal experts, some of them archives not meet the legal requirements for the evidence. So I have some problems. Thanks. 下面呢是两位啊，还有一位是这个丁彦南老师呢，他现在又可以上线了啊。那么因此呢，我们先请李小璐老师给我们讲解，完了以后呢，最后一个是给我们丁彦南老师啊从线上，这样的话我们还是时间稍微控制一下，谢谢啊。
Thank you. Thank you very much, and good afternoon. And first of all, I'd like to thanks for the organizers to have me here. I really learned a lot today. And first of all, I'd like to say that in this pre, I will use some of the preliminary works of our team on archival materials. I have the honor to participate in some of the works in the early stage on collection and organization, some of the archives. I think it's a very, very big project, and they have the very hard and maybe some monotonous work on the archives. So many thanks to my dean and my colleagues. And I think I would, when I read the books about by Professor Carty, I think several points of view in this book really impressed me. The one is the role of the archives, and the other is the critical thinking on the international rules about occupation. So as I'm a lawyer, although personally I quite agree with some of the points of Professor Carty, but I like to starting from the international jurisprudence on the sovereignty relating to some of these territory, just like Nansha Qundao, very similar to that. Very tiny, have a long history, and a little bit far away from the mainland. We find the cases, I think the most similar case would be like the Petra Branca case between Singapore and Malaysia. And in that case, the ICJ just followed such kind of logic to determine the sovereignty of Petra Branca. First, it determines the original title for long-standing of that island, and then it sees whether there's a legal status have been changed by some of the conducts of the states. And third, it answers the question that title to the territory has passed from the Malaysia to Singapore. And to the Middle Rocks, it says that none of facts enable the passing of the title, then the Malaysia can keep the original title's sovereignty. So it follows that logic. So we'll find that the arguments for both of the parties and the starting point is that whether the Petra Branca is a terra nullius. First of all, I'd like to say, for the Malaysia, it argues that it is not a terra nullius, but for the Singapore, it says that it's a terra nullius, and it will occupy the terra nullius to become the sovereign of that Petra Branca. And in this case, I think ICJ put two preconditions to make that decision. First, examines the Sultan of the Johor is a sovereign state. So when the ICJ makes this kind of decision, it used the nation-centered approach to determine the sovereignty, not the people-centered approach. So it says that it's a sovereign state, and this territorial and maritime domain of the state include the area disputed. So it's the two preconditions for the ICJ as a starting point. So I think the rest of my pre will focus on how the nation-centered regime deal with or consider the people's activity when dealing with the sovereignty issues over the territory, just like tiny and have a long history. So this is the two arguments of the two states. And to ascertain whether there is a original title is founded, the ICJ has focused on two significant factors. The first is whether it is possible for us to unknown or undiscovered about the Petra Branca. It says that because the Petra Branca sits in the mouth of the Straits of Singapore, and it's a very important channel for international navigation. So it can be inferred that it is impossible that the island could have remain unknown or undiscovered by the local community. So that's the that's how the ICJ do. It's not a very definite answer to this question, but it's a reasonable inference on this question. And the second important factor is whether there's a competing claim. The ICJ spends a lot of time on why and there isn't any other competing claim on the Pedra Branca. To make a conclusion, the ICJ believes that because based on these two factors, the Sultanate of Johor has never the possession of those islands by old Sultanate of Johor was never challenged by any other power in this region. So it can, in circumstances, be seen as satisfying the condition of continuous and peaceful display of territorial sovereignty. So in this case, Malaysia will have the original title of that island. And the most interesting thing is that when the Malaysia makes argument, it emphasizes on some of the personal activities around and at the Pedra Branca. It calls Orang Laut, the activities of that people. And how did ICJ consider that kind of activity? I think will shed a light on some of the discussions around today. And the court believes that because Malaysia have some authority and political authority by the Sultan of Johor to qualify him as exercise sovereignty authority over that people. So the court believes that this kind of authority exercise of the Orang Laut who inhabited the islands in the Strait of Singapore and who made this maritime area their habitat confirms the ancient original title of the Malaysia to those islands, including Pedra Branca. So although in the nation-centered approach by the ICJ to deciding the sovereignty over the small islands, it still put a very, very strong weight for the individual's activity around those islands. But it's very different from the original title because in traditional international operational title may be attribute to the community in that land, live on that land. But in this case, the Sudan is considered sovereign, is a sovereign state, not a community at all. So it's a qualified actor to have sovereignty over that islands. So the ICJ just decide the original title of the Pedra Branca. And the most interesting is that when Singapore make a counter claim saying that in this way, it's the Malay traditional concept of sovereignty. I think the answer of the ICJ is more interesting, even more interesting. The ICJ says that the courts observes that sovereignty compromises both elements, personal and territorial. But in this case, the ICJ does not go further on illustration on how the sovereignty on personal could have more benefits or have more important role to deciding that original title. But it says it have made a decision that it have this kind of authority over the personal activities has confirmed the title of the Sultan of Johor exercise authority. So in this case, I would like to just go straight for the Chinese fishermen who habited in the island. They'll make the area as their habitat. How these archives around this issue help us to make a legal arguments. And I think that Professor Carty has mentioned lots of hydrographic reports from UK in his books. And I think I will give some examples from the Japanese archives that published in many articles to establish this issue. In 2025, there is a report in the Japanese archives stating that there is a survey in the Nansha Qundao, and this survey was conducted between November 1920 to July 1921. And in this report, there are two important things that these archives indicate. The first, owning the fishermen from Hainan Dao to travel to the Nansha Qundao to do fishing every year. And there's time is the maybe the January, February every year. And the other thing is very interesting is that it says that between the 1920s to 1921, there are joint patrol between China and the UK Navy in this area. This is two very important things in this Japanese archive. And the other report is in 1933, when the French is going to invade the Chinese island in the Nansha Qundao. And Japan made a report to its Ministry of Foreign Affairs. It says that only the Chinese fishermen will travel to the Nansha Qundao for fishing every year. And this the same thing also reviewed in the Chinese archives, from the Chinese Consul General at Manila to the central government. So we will see that all these kind of archives, I mentioned one thing, they will support each other, and they will indicate just one fact, is that only the Chinese people have lived or used these islands around Nansha Qundao before the France make illegal claims to those islands. And some archives also show that Nansha Qundao is never the Philippines territory, also from the Japanese archives. This is a report in 1927 from the report of the Consul General for Japan at Manila. It noted about several of the reports from the US, and it makes some comments on the US reports on the Nansha Qundao, and then it makes a conclusion that the Nansha Qundao is out of the boundary of the Philippines, has no relationship with the Philippines, and is not under the authority of the Philippines. That's the conclusion about in this report. There's also a letter from the French consulate in Manila to the Ministry of Foreign Affairs to indicate that the Philippines has not established sovereignty over those islands. And there's another piece of a report from the Ministry of Foreign Affairs of Japan. It mentions about the Senate of the former Senate of the Philippines to raise a proposal to raise an investigation about the Nansha Qundao, whether Nansha Qundao is a Philippines territory. And the archives records that although this report has been approved by the Senate, but the House does not make a decision on this issue, and this meeting was adjourned. So it says that there's no result of that proposal. This is all from the Japanese archives in this issue. So if we put all these keys together, I think we can make a very relatively complete chain for the Chinese claims for the South China Sea or Nansha Qundao. First, we can see that China is the original sovereign over the Nansha Qundao first, because the possession of Nansha Qundao by China was never challenged by any other state before 1930s. And then Chinese fishermen inhabited the Nansha Qundao and made this area as their habitat. So it confirms the original title of the China to Nansha Qundao at least. And then when those islands get invaded by any other powers such as France and Japan, Chinese government fought against with them and resumed exercise of authority over these islands after the World War II. And third, the China displayed its authority in accordance with the development of international law aftermath. The People's Republic of China has repeatedly retreated and further upheld the sovereignty of the Nanhai Zhudao and relevant rights and interests in the South China Sea by measures such as the legislations, establishing administration, and making diplomatic representations. So that's my conclusion, and thank you very much.
好，谢谢雷教授的。档案界有一句话啊，叫“孤证不为证”，说明使用档案需要多方面的来源来互相印证，才能完善证据链。好，谢谢啊。最后一位是这个上海大学丁岩老师，在线上了。好，丁岩老师啊，请发言。
各位谢谢申老师，各位老师好。那当然也要谢谢这个华阳海洋研究中心中国南海研究院和浙江大学。好，那么我今天这个简单的报告是对我读这本书的一些思考。非常不巧，因为我现在正在旅途中，所以没法到现场来参会。那么我的报告会很简短。那现在我来分享一下我的屏幕。好的，我要讲的是这个历史地理学与国际法学的互鉴互促。历史地理学是一个比较专门的，也比较小众的一个学科我们在历史和地理两个学科的这个交叉点上，而国际法学现在是一个非常可以说非常热门的这样一个学科。那么这个一冷一热之间怎么样才有可能来互鉴互促呢？我想结合一下我阅读南海的历史与主权这本书的几个笔记来讨论一下。那么这本书的主要的组成部分是安东尼卡蒂教授的2篇论文。那么这2篇论文我在差不多2020年的时候也就是疫情刚刚开始不久的时候已经获知，并且也先后去读过这2篇文章。那当然非常高兴能够看到他们被翻译成中文。但是这个书的这个译文中间读下来有很多的问题。首先一个事实层面的这个问题那这里我已经列出来，就是比如说这个208页，那这个翻译的过程中直接使用音译。那这个洪孟熙是这个洪茂熙不是这个译文里面的洪孟熙。他是丹阳人，是这个著名的这个地图学家，出版过不少这个地图集。232页的这个邵雄不是邵汉卿，那邵雄这个邵雄是著名的历史学家，在北大和清华2个高校都曾经任教过。这个出现这样的这个问题是蛮可惜的。第二个是翻译的这个方式方法层面的问题。第8页是这个女王陛下的舰艇，是这个安东尼卡蒂书中的 Her Majesty's Ships。这个稍微有一点历史常识也知道，这是指英国海军的这个舰艇，不是什么女王陛下的舰艇，是英国海军。第239页短短的一句话里面有2个前后这个矛盾的这个翻译，这实际上都是指的 Pattern Island， 就是指珊瑚岛。怎么会出现这样的错误？第107页的时候，引用了美国国务院会议决定摘要，然后这个翻译这译文在这里，它这个原文所表达这个意思跟这个翻译这个意思之间是差别很大。这个翻译的最后一句实际上是这个完全逻辑不通的。 如果说前两个呢是比较这个具体的一个问题呢，后面这个我想结合历史地理学这个研究来谈一下，可能稍微专门一点这个问题。因为谈到南海的历史地理，不能不回顾到1979年的时候，在厦门大学举办的一次研讨会。那这次研讨会也邀请了复旦大学历史地理研究所的这个谭其香教授参会。那么这次这个会议之后，他有一个论文集在81年出版，由韩正华先生编辑的。那么前两篇文章的时候，就是谭其香先生谈这个七州洋。在这里摘引一下，这个谭其香先生说了，不论是明以前的七州洋就也好，清代的七州洋、广峡二夷也好，七州洋都不专指西沙群岛洋面，更不等于就是西沙群岛。那从79年到现在，过了将近50年，我们有很多新发现的档案，有很多被公开的这个地图。我想，50年过去45年过去，这个谭先生的这个论断仍然是站得比较。那么我想来讨论一下这个南海的历史与主权里面的一个问题。第11页这个角度11，这里面提到普鲁斯塞的泰，就是普鲁斯塞的大特瑞，为牛角及旧帕拉塞的岛屿之一，为越南东南部的沿海岛屿，为中国西沙群岛无涉译者注。这里面所提到的这个牛角和这个旧帕拉塞，是对于熟悉南海历史地理研究的这个专家们。这都很熟悉，因为这个反复的在这些文献里面出现。关于这个已经将近10年前，2015年7月份的时候，我已经在一篇论文的草稿里面指出，这个所谓的旧帕拉塞是一个没有历史和地理，更不用说历史地理学根据的这样一个概念。在2015年上半年到夏天的时候，我从南京大学学报编辑多次通信审稿专家坚持认为，从最新的研究的发现看，古帕拉塞的确存在。只不过地理位置更靠近越南海岸。因为今天在座的参会的都是南海研究的这个专家，里面呢就大家很清楚这个就古帕拉塞尔是什么，牛角指什么，所以我就不展开解释。那么我想说的是，过去几年时间，我一直在这方面进行补充的，是进一步的这个研究，包括2018年发表在安徽史学上的这篇文章，第一次就对这个展开来讨论，古帕拉塞尔的提法不符合地图学史，是对古地图地理信息的一个误读。2020年的时候发表于这个云南大学学报的这个文章里面，用大量的17世纪的荷兰东印度公司的地图来讨论古地图上对南海的这个表现。同一年，在这个南海学刊上发表这个文章，提到说是2个帕拉塞尔之谜，所谓的古帕拉塞尔和新帕拉塞尔，牛角帕拉塞尔跟那个帕拉塞尔之间的这个区别。那这个意图它的核心观点，但是核心的要点在一个地图学史的理论和对地图资料的这个解读方向。这个理论是有变化的，这个资料是逐渐充分的。如果说半个世纪之前有很多认识是有局限的话，今天我们应该能够更正这个当时的这个看法。那么关于西沙群岛，它的地理位置的认知会不断的有一个演化的这个过程，是一个动态的过程，或者是一成不变的。那么古帕尔这个概念是对地图史和其相关的地理知识普及的目的。那我想强调的是，在这个《南海的历史与主权》这本书里面的这个角度11，这是译者擅自添加的，不是安东尼卡蒂的这个原文。那么这个中译本显然存在着非常多的问题，这个中译本应该如何改进？我想提2点。第一，我在这本书呢有3位译者，但是没有1位校订者。一般这是非常让人震惊的，因为这个新兴出版社是个外文群的这个出版社。那一般的这个翻译的这个著作，严肃的著作，应该既有译又有校，为什么这本书没有请人来校订呢？第2点，要认真的检讨历史地理的这个问题，这个问题存在遗址，不能视而不见，尤其是在已经讨论的这个过程中，因为我们历史地理学是一个很边缘的、很冷门的一个交叉的一个学科，我们需要更多的主动的站出来，跟向这个国际法学来学习，希望更多的交流。最后简单总结一下，就是南海问题的研究必然是跨学科的，将是长期的，但是这个打通这个学科之间的这个翻译并不简单。国际法学者需要什么样的历史地理知识？历史地理学者又怎样从国际法的视角审视自己所处理的档案资料，都需要更多的沟通和合作。近年来，从事南海研究的学者群体里 运用国外档案资料展开南海研究的越来越多，其中又主要集中在外交史，尤其是利用各国的外交档案，比如说这个安东尼·卡蒂教授这本书和历史地理两个方向的历史地理里面，主要是包括利用古旧地图、航海日志等等。前面的多位的发言人都已经做了非常好的这个示例。那对于国际法学者来说，应当以谨慎的态度审视历史资料，不能急于求成，简到筐里都是菜。对我们历史地理学来说，我们的研究应该更多的考虑到国际法学的规范和需求。我简单的汇报就到这里，谢谢大家。
好，谢谢丁一南老师啊，这个他提出来的有些观点呢，就是历史资料需要多方面的来论证，这个我很赞成啊。这里面呢以前也讨论过，因为古普拉塞尔的问题呢，有不同的观点啊，这方面的地图也很多，牛角的地图很多，后来又消失了。那么为什么会消失啊？我当时曾经主张要有更多的参与，因为什么呢？这个古普拉塞尔的那个地方的和那个菲律宾的三岛，几乎是在同一个时代、同一个纬度都消失了。所以呢，我当时跟地质学家讲，看看地质学有没有这方面的研究资料，因为地层的变动有可能会造成所以呢，这个可能更需要有更多的资料来验证。包括七州洋啊，七州洋争论也很厉害所以我想这个咱们再多收集一些资料，多征求一些专家的意见这是我个人的观点。谢谢啊，丁一南老师。现在这样，时间呢是到了，但是呢有讨论的环节这是一个我的矛盾的地方。那么呢，吴院长呢也希望在茶歇的过程当中呢，到对面去看一看，因为还有几张地图。大家可以，因为上午谈到的地图正好展在那个地方但是呢又不能影响下面的这个因为我们这个时间已经到了嘛。你要看，如果你们有问题的话，有比较重要的问题，我们可以提出1、2个来看看有没有要提出来要讨论的如果没有呢，我们就赶快茶歇，看看对面的地图完了以后呢，再回到现场上来。好。这个南京大学国际关系学院的年轻学者，
我就是有一个技术性的问题想提问一下。那么对于这个研究国际法的学者来讲的话呢，我们在这个历史资料的这个方面，包括历史的研究成果这个方面呢，说句实在话是没有甄别能力的。那么就是在座我们也有这个档案学的专家，也有历史学的专家，能不能给我们提供一个简单的方法？比如说我看到的所有的，就是从我自己的这个认知来讲的话，只要是我能找到的公开发表的有 peer review 过的这种论文，我觉得我可能就都能信它。但是我们历史学家内部针对这些论文，他自己有不同的见解，然后有些时候我拿到的这个资料，我得出了一个法律的结论，法学专家没有意见，历史学家对我引用资料本身有意见，对我这个得出的法学结论不关心，就出现了这样一种情况，就有可能非常影响这个历史学界和法学界的这样合作。所以就是最简单的一个，也是最懒人的一个问题，就是那么在座的历史学者能不能给我们一个非常相对比较实用的一个方式，去甄别哪些资料我们可以信，哪些资料相对可信度更低一点？谢谢。
卡蒂还有，请，
我说。
This is a major issue that we have discussed in the United Kingdom when I was producing with an archival historian a book called Sir Gerard Fitzmaurice, The World Crisis, from 1932 to 45, a legal advisor in the Foreign Office. And there is a view that lawyers cannot study the history of the development of a legal concept, because that is a historical exercise. So there Lord Arnold McNair, for instance, produced 4 volumes of legal opinions given in the context of the Foreign Ministry and Foreign Affairs, but he would consider it the task of a historian to determine whether or not and to what extent these legal opinions had any influence, and whether or not they became law. Now, I don't agree with him. And when I was in Derby University, I had an archival assistant who could explain how, well, when we didn't have electronic communication, emails and WhatsApp, but we actually worked with documents, the way the British archives are constructed, it is possible to tell why somebody has written a legal opinion, who requested it, and it's possible to trace what happens to it afterwards. So it's possible to trace whether the legal opinion became the policy of the government or whether the legal opinion went astray and was ignored. And so I don't think it's beyond the intelligence of a lawyer to be able to learn how to trace the historical significance of a document. Nonetheless, I think it is, when I'm writing this book, as I explain in the preface, my ambition is to present all of the archives in such a way that a general reader, whether a historian or a lawyer, will feel he's not being tricked and manipulated by me, that I'm selecting some documents which suit me and leave out other documents which don't suit me. And that is essentially a historian's exercise, in my view, not a legal exercise. So the text, the book is not a kind of screaming and shouting for China type of book. I mean, there are bits and pieces in the book that do support China. But I mean, if you take particularly the example of the French foreign minister not listening to the advice of his legal counsel, but actually acting directly opposite to it. All of that said, I mean, a lawyer's task is simply to determine what a legal authority regards as the content of a legal norm, and then to study to what extent that norm is applied to the facts for which it is designed. So it's essentially a syllogistic exercise of logic, where grammar and capacity to analyze concepts is what's predominant. And there can be an argument, it hasn't been discussed today at any length, can be an argument about whether or not archives of the type that I use for this book would count before the International Court of Justice. And it would not be particularly difficult to argue that they don't, because when Britain decides to take up a formal public legal position, it goes beyond its legal advisors and asks the so-called law officers of the Crown what they think. And then there's a cabinet meeting to follow the opinion of the Attorney General and the Solicitor General, even though they may not be. So one mixes law and politics. The law officers of the Crown are actually lawyers, but they're politicians. So there's a special procedure that Britain would follow where you reach that conclusion. So in my view, that would not take away from the force of the material that I presented, because they do represent the internal conscience, particularly of Britain, and the prestige of the persons involved in France is such that politically this would be very significant. And I think one can challenge and embarrass British and French governments with the material that is in my book. But it is a fact that none of my colleagues, international law colleagues, will follow me into the archives in London. I mean, I have tried to persuade them to do this, and they come up with every kind of excuse and no excuse at all. So there is a mental blockage on the part of the lawyers. They will not go to these archives, even though they're open, very comfortable, and you can get there in a simple train journey. On the other hand, the historians, because there is a history department in the Foreign Ministry in London. My own archivist, as a young man, the man who trained me in doing this work, he's now the head of the history department in the Foreign Ministry in London. they produce vast narratives of archival documents explaining historical events, but they almost invariably leave out any legal document. Maybe because they think it's not important, but I think also because they don't understand it. So there is basically a real problem there. Historians don't understand the importance of law. They're not used to the whole kind of essentially chase the criminal attitude that a lawyer inevitably has, pin down the slippery figure. That's what law is about, pinning down slippery people. That doesn't interest them, and they tend to. So I have noticed again and again when I've compared archives that I'm preparing on some piece of international legal history and then compare with published documents, that all the legal documents I'm interested in are just not in the published historical record. So there is a deep difference in mindset between a historian and a lawyer, in my view. I mean, you can say a very great deal more. You can say the common law and customary law is essentially, and the law of precedent that dominates the Anglo-American way of thinking is inherently historical and so on. One can go on and on about that, but definitely there's no willingness, as far as I can see, among my colleagues in international law to get mixed up in history. Yeah.
谢谢。
Teresa wants to say something.
No, thank you very much, Professor. No, I want to further on to ask some questions from perhaps a practical point of view. Looking at historical records or archival records, if I say I look at them as evidence, then there are two types in terms of international law. You look at the acts of the states, which is the expressed position of the states that became part of the history, as it were. And of course, also what you've been looking at, which is the internal records, legal opinions of the AGs or the Solicitor Generals in England, etc. Now, the two types of evidence, if I call it that, would have different weight, would it not, when it comes to dealing with, for example, whether an international tribunal, be it the ICJ or an arbitral tribunal, would accept them in order to accept them as some evidence of sovereignty, for example, original sovereignty, for example. So how should one deal with these two types of archival records? The internal ones within the government, because the lawyer may have advised something, but the head of state, for example, may decide otherwise. And then, of course, the open position, which will be very much the position of the state. How should one apply them?
This issue comes up several times, and we have had discussions with Melissa when she was partially my research assistant on this project on a number of aspects. I think that basically, if we take, I present the history and then I leave people to make up their own minds, even though there's an introduction which is more finger pointing and didactics than the text itself. An introduction I added for the Chinese version of the book. Take the instance of Aristide Briand, the most distinguished French foreign minister of the interwar period. And I passed I live also in Paris, and I went to, there's Friends of the Archive meetings every fortnight in the French Foreign Ministry. And as I passed to go into the ministry, I could see a huge big placard about Aristide Briand and this man's wonderful contribution to world peace and so on. And he was the co-author of the Briand Pact. Now, Jules Bastidon is the most distinguished French international lawyer probably of the 20th century, not academic, practitioner. He was a judge of the International Court of Justice, I think, for an eternity from 1945 to the 60s. He told Aristide Briand that the Paracels Shisas were French. Aristide Briand agreed with him. He said that that had been the advice that he had got at the beginning of the 1920s. But then he proceeded. This was for me, from a legal historian point of view, the greatest, one of the few really amusing and entertaining parts of the whole research. He then proceeded to debate the issue with the French minister or ambassador in Nanjing or Peking. I couldn't figure out where he was exactly. And they decided to calculate the advantages of simply ignoring the legal advice and going ahead. And the way they would calculate it is that as the English were actually protesting, China was very weak and confused at this time in 1931 and the summer and autumn of 1931. Would the Chinese object? How strongly would they object? If they rejected reasonably strongly, then we would offer them arbitration. If the Chinese simply went berserk, as they did over the May the 4th question in Shandong, and that threatened all French interest in China, then we would give them back the island. So I would think that if that type of incident came before a reasonable international tribunal, and I think most international tribunals are not reasonable and are not to be trusted, but if one had a reasonable international tribunal, it would be very impressed that Bastevon, the legal opinion of Bastevon and Briand was what they should take to be the French legal conviction about the matter. But so that's my view. But the World Court is the World Court consists of judges appointed by states, and so I think there will be a very strong prejudice in favor of really considering legal opinions as simply opinions, and that the will of the state is what counts. And the will of the state is expressed by a formal decision of designated authorities, whether it's the president or the prime minister or the foreign minister. The will of the state is then expressly affirmed that we, the United Kingdom, or we, France, we commit ourselves to the view that such and such is what we consider law, because states, according to positive international law, the states create the law. So if they decide that something is legal, then whatever the legal advisors have been saying, you know, it becomes legally binding on the state. So I would say that those are the different parameters. But international law is extremely confusing as a subject, and they have two different theories about the nature of the law. The one is that it's the product of the will of the state, and the other is that it's much more a customary law, which actually you read through the practice of the state, you get a sense of what the legal conscience of the state is. And I think the type of evidence that I'm producing does point more, I'm more favorably disposed to the second view about international law. So, all right.
OK， 我们还有最后一位啊，就是 briefly。
I have a point to make on that, referring to Monsieur Briand's conversation at that period in the early 1930s. The British were asking the French for basically proof. And so the French went digging in the archives and then claimed they had a certificate from, I believe it was a Hui king, going back into the early 1800s. And so the British said, okay, we'd like to see a copy of it. If you've got this evidence, then it supports what you're saying, no problem. They couldn't produce a certificate. And there was actually a British opinion at that time that said it didn't actually exist. And so you have this problem when you're looking at such things as to what was said and why, and then what was said to others as well. And in particular, in this case, because of the position of Hong Kong, what the British wanted to know and what the British determined was important. So were the French responses to the British when they were being asked questions. But in all of this, and I think it goes back to your question, that there's something else in this. So Viscount Slim, his British Army general, made the comment that when you're looking at a history, and particularly when you're looking at the history written by people, And so diaries, things of that nature, which the courts and particularly the ICJ have taken recognition of. For example, in the Venezuela boundary case and in the case of Mauritius, then they have an aspect that you have to believe, but they also have one that's a little shady in terms of not the truth, but the way that facts are described, because they are individual people's observations, but they're important people because they're government officials. And so that should be taken into account. But that means we're looking at history. And as it's often said, law is everywhere, even in the air that we breathe. That being the case, history embodies areas of law, and we have to look at the subject at hand and decide if the history can help us or not.
好，因为时间关系啊，我就不能再继续了。这一两句话，稍微带一下，把我自己的观点利用主持人的这个优势啊。这个历史是消失了的过去，要重现它几乎不可能。因此呢，我们要追求相对的完整性呢，就要尽可能的多的去收集历史遗留下来的碎片，不管是政府的、民间的、各种载体上的，越多越可以加以相互的印证、相互的比较，相对完整的来反映历史的情况。这是我的个人的看法。谢谢啊。好了，我们茶歇吧。吴院长希望大家都利用这个时间去对面看一下啊，然后我再回答。抱歉，我这个拖的时间比较久了。
Yes, now it's time for coffee break and please take a short rest. We will resume at 4:30 p.m. with the discussion of the third panel. 4:30, please.
您现在可以去打开摄像头和您的音频，我们可以试一下。张欣志，哦，张老师，我看到您了，有声音吗？但是好像没有声音。
啊，声音这样行吗？
现在开麦了，
这个声音可以吗？
但是没声音啊，是吧？
现在有没有？
张老师，您再说两句。
现在行吗？
Our panel 3 is about to start, and please take your seats. Put your mobile phone on
现
silent.
在现在可不
Thank
可
you.
以？
他的麦没跳。你让张老师说的话有点吵，你让他随便说。
声音行吗？这个，喂，
Now we will start with the third panel of the day, Re-evaluation of the South China Sea Arbitration Award. First, let's please welcome the moderator for this panel, Ambassador Yi Xian of China to Norway. Ambassador Yi, please.
我们现在还有1个半小时时间，咱有7位发言人。那么，在这个给你们这 floor 之前呢，我先说说我个人的观点。尽管我不是专家，但是发言的我都认识哈。这是一个敏感的话题，当然也是一个专业性非常强的话题，是吧？据我的统计，从18世纪到现在，全球已经解决和正在解决的涉及到领土和海洋划界的争端有870项。那么其中通过谈判和协商方式解决的占了90%。第二点，通过司法途径解决的，包括仲裁和法院的这个审理解决争端的，这个是20世纪以后的事情。特别是1899年和1907年海洋两公约产生以后，是吧？就和平解决国际争端两公约。即便如此，从1900年到现在，双边谈判解决领土和海洋划界争端仍然占绝对多数。司法途径包括仲裁解决的屈指可数。第三点，涉及到领土海洋划界的争端，是所有国际司法机构，也还包括所有国家，都是非常慎重的，要提出司法解决的话。第四点，对于涉及到领土和海洋划界的争端，这个司法机构是吧，在一方完全反对的情况下，另一方强行将这个涉及领土主权和海洋权益争端，或者海洋划界争端提交给司法机构的，是非常罕见的。我不知道你们能不能举出第二个例子，是吧？就强行推动这种情况，是吧？第五点，2014年是吧？2013年这个仲裁案是吧？这个过程和结果都非常清楚，是吧？它的实质就是将领土和海洋权益争端包装成为公约下面的一些条文的解释，这个实际上就是说，在海洋法学界、在国际法学界，甚至在外交界，它就是个政治符号，也成了一个政治笑话。我这个过去几年一直在欧洲工作，是吧？仲裁案启动以后，我在海外工作了7年， 也跟了很多国际法界的朋友交流这个问题，是吧？他们公开不说，但是底下非议非常多，是吧？那么回过头来就是说，我们要问，就是它的缺陷到底是什么？那么它为什么是一个笑话？那么这种缺陷和笑话会不会重演？怎么防止它重演？那么有几个问题，我希望我们这个组发言的时候能够结合你们的发言，认真考虑。第一个问题，岛礁争议和海洋划界是否是南海争端的首要问题？因为我们现在南海争什么？真的是公约解释，还是真的是岛礁主权和海洋划界？第二个问题，在国际法上，我们有个叫群郡双边手段，以及海洋法公约283条规定的沟通的义务，也就是交换议案的义务。那么它的基本要求是什么？因为根据这个仲裁庭的这个裁决是群尽了双边手段，也群尽了这个是吧？完成了这个所谓交换义务。因为我本人是参与交换意见的，我曾经多次去菲律宾。第三个是吧？单边法律行为是吧？对抗和否定历史事实，它的效力怎么来界定？第四个，限制性的原则、同意的原则、排除的原则，也就是我们公约附件第9条是吧？和公约的第15部分，还有公约的281条、298条，以及是吧？中国政府的2006年排除声明。那么这些在仲裁庭是否是吧履行了应该尽的查明的义务？接下来第5个问题，也就是说整个仲裁庭是否履行了是吧查明的义务，包括事实、实体部分和管辖权部分。因为这是一个非常技术的这个一个 topic 是吧？大家都有很多话说，我这个说了4分钟5分钟是吧？这个下面呢，我想把这个 floor 第一个给周克渊教授，大连海事大学的周老师，您好，欢迎。
先生好，thank you for your kind introduction. And as we know that the South China Sea Arbitral Award was released in 2019. Now it's the 8th year of this award. And due to the time limit, I only focus one of the points or issues raised by this award. And that is the concept of historical rights. And as we know, in the Philippine submissions, the first submission and the second submission in its memorial, it reads, I quote, China's maritime entitlements in the South China Sea, like those of the Philippines, may not extend beyond those permitted by the United Nations Convention on the Law of the Sea. Second, China's claims to sovereign rights and jurisdiction and to historical rights with respect to the maritime areas of the South China Sea encompassed by the so-called 9-dash line are contrary to the convention and which without lawful effect to the extent that they exceed the geographic and the substantive limits of China's maritime entitlements and UNCLOS, end quote. In these two submissions, there are several important concepts involved for discussion, such as maritime entitlements, sovereign rights, jurisdiction, land-dash line, and historical rights. It is recorded that in the arbitral award on jurisdiction and admissibility, the tribunal held that it had jurisdiction over the dispute arising from the above two submissions, based on the evidence that the Philippines did not ask the tribunal to adjudge sovereignty issues in the South China Sea, and it neither asked the tribunal to decide maritime delimitation between the Philippines and China, but left it combined with the merits of the Philippines' claims due to Article 298 of the UNCLOS and China's 2006 corresponding declaration based on Article 298. That is, China excludes some disputes from the UNCLOS, the compulsory jurisdiction. Thus, the final award of the tribunal contributes its Chapter 5 to the deliberations on the issues of historical rights. The brief conclusion made by the tribunal is that China does not enjoy historical rights to marine resources in the South China Sea, and such rights, if ever existed, had been repressed by the relevant provisions of the UNCLOS. There are considerable points in this part of the award which warrant very careful examination. And the first point I would like to make is that the tribunal acknowledged that China had not explained the nature of its claimed rights, but took the duty to ascertain on the basis of conduct whether China's claim amounts to historical title. The tribunal cited 3 examples in China's practice to demonstrate that China's claim was not historical title, but historical rights short of sovereignty. The 3 examples include the 2012 notice of open blocks for petroleum exploration issued by the China National Offshore Oil Corporation, the CNOOC. The 2011 Chinese note verbal protesting the Philippines' award of petroleum blocks in the Spratly Islands, and the 2012 fishing ban declared by China. These three examples that the tribunal cited to support its jurisdiction. It is to be noted that the tribunal intentionally selected the above 3 examples because all these selected examples occurred after the year of 2009, when the tribunal determined as the year when China started to make its historical claims to the South China Sea. Second, the tribunal disregarded, or at least played down considerably, the fact that the 2 examples relating to petroleum exploration that occurred within the limit of the Spratly Islands, over which China has enjoyed sovereignty and sovereignty-related rights. Third, concerning the CNOOC notice, the tribunal disregarded or even did not know the fact that the dispute between China and Vietnam over the Vanguard Bank, which is part of the Spratly Islands, has been lingering on for years, and there were incidents in the 1990s. Fourth, the fishing ban simply served the purpose to conserve the fishery stocks and there was nothing to do with any historical claim. In addition, the fishing ban is not new, and China implemented this conservative measure in the South China Sea as early as 1998. It is clear that the tribunal deliberately used these post-2009 examples to support its argument that China does claim rights to petroleum resources and fisheries within the 9-dash line on the basis of historical rights existing independently of the convention. However, it is unfortunate that in law and in fact, the tribunal failed its duty due to its bias, ignorance, maybe something else beyond the law and justice. Second, the tribunal differentiated historical title from historical rights. The tribunal, by following existing juris doctrines, even including my article published in 2001, described the term historical rights. Of course, it's rightly described as, quote, any rights that a state may possess that would not normally arise under general rules of international law, absent particular circumstances. Historical rights may include sovereignty, but may equally include those limited rights, such as fishing rights or rights of access that fall well short of a claim of sovereignty, end quote. However, the tribunal continues to say, with the arbitrary tone, that the term historical title is used specifically to refer to historical sovereignty to land or maritime areas. Here, the tribunal created the term historical sovereignty, which is very rare in the literature of international law for historical rights. On the other hand, the tribunal did not explain why historical title is historical sovereignty. And on the other, such assertion receives no support from existing doctrines and learned works concerning the international law for historical rights. More confusion arises in the circumstances that historical title can be interpreted as one form of historical rights. Third, in the award, the tribunal ignored or even negated existing international jurisprudence, particularly concerned shared historical rights. It is recalled that in the case of Australia and Yemen in 1998, the two states both claimed historical rights in the Red Sea. Eritrea claimed its rights of islands in the Red Sea based on a certain of time over more than 100 years. Yemen based its claim to the disputed islands on original historical or traditional title, and the Red Sea Tribunal confirmed and supported this kind of shared rights. And it is clear that both parties concerned have enjoyed historical rights in the Red Sea. However, the South China Sea Arbitral Tribunal utterly denies such shared rights and disagrees to the above legal reasoning without unfounded explanations. Shared historical rights also confirmed by the Gulf of Fonseca case among solely Latin American countries, that is El Salvador, Honduras, and Nicaragua. In the context that the Gulf of Fonseca is a crude sea, we have to bear in mind that the South China Sea is a semi-unclosed sea. And in addition, we must bear in mind that in UNCLOS, in UNCLOS, there's a provision treats the unclosed sea and the semi-unclosed sea equally. It is to be noted that while the South China Sea Tribunal negated the jurisprudence of the Red Sea case, it did not mention the significant Gulf of Fonseca case at all. It is apparent that anything which might be possibly favorable for China must be negated or ignored by the tribunal for some untold reasons. Fourth, the tribunal claimed that after the adoption of the UNCLOS, the historical rights to marine resources have been superseded by the relevant provisions of the UNCLOS. That is another fallacy the tribunal has developed, in particular when it held that the Philippines enjoy the traditional rights, fishing rights in China's territorial sea. As the tribunal holds, quote, the convention does not include any express provisions preserving or protecting historical rights that are at variance with the convention. On the contrary, the convention supersedes earlier rights and agreements to the extent of any incompatibility. The convention is comprehensive in setting out the nature of the EEZ and the continental shelf and the rights of other states within those zones. China's claim to historical rights is not compatible with these provisions, end quote. There are 7 points that warrant attention. First, the tribunal treats the UNCLOS as a super treaty, repressing the historical rights which should be otherwise governed by another international legal regime. Second, the tribunal linked historical rights to EEZ continental shelf rights, and according to it, the latter should repress the former. This argument is simply nonsense in that the EEZ historical rights are different concepts and subject to two different legal regimes under international law. Third, acquired rights, such as historical rights, even according to the tribunal when addressing the Philippine traditional fishing rights, should be preserved. The argument of the tribunal are conflicting in the 2 parts of the award. And also, according to the tribunal, China's historical rights, even if they exist as superseded by the relevant legal regime and the UNCLOS, and the tribunal states that upon China's accession to the convention at its entry into force, any historical rights that China may have had to living or non-living resources within the non-dash line was superseded. That is wrong. And also we can see that the existing historical rights never been repressed by the relevant provisions of the UNCLOS. And but existing historical rights can be removed, but must be through the state practice, such as the agreement between China and Vietnam regarding to the Gulf of Tonkin. And originally, 2 countries enjoyed their historical fishing rights in the Gulf. Then after 2000, when they concluded agreements on fisheries, also on maritime boundary delimitation, all these historical rights can be repressed, but not by the court or even by the treaty. In summary, the South China Sea Arbitral Tribunal could have made more accurate observations if it had closely reviewed general literature on the international law of historical rights. The tribunal's award deviates from general practice of international law and draws illogical conclusions, particularly when it discusses China's historical rights in the South China Sea. It is apparent that tribunal members did not fully comprehend the concept of historical rights and audaciously rush into its conclusion for some self-serving purposes. I just stop here. Maybe we can discuss later. Thank you, Ambassador Yi.
谢谢周老师。我们下一个是张新军教授，清华大学。这个我想提醒一下后面的这个 speaks。Everyone has 8 minutes。因为我们的时间非常有限，我必须要留我们在座的好几十号人，可能大家都有不同的看法，有观点，所以下面发言的每个人8分钟，谢谢。新军 ，you have the floor.
Thank you, Ambassador Yi. Since the majority of the audience here is Chinese, I think I will talk in Chinese. 所以今天我这个报告呢，也是呼应刚刚易大使的这个问题啊，这还是考虑这个仲裁庭在
我的建议是，你们就说出你们的观点和立场，提出问题就可以了，没有必要这个 background 说太多。background 我们都知道。
是在不出庭的情况之下，这个论点在很多场合也曾经谈论过啊。在不出庭的情况之下的话，有一个条约上的一个规定仲裁庭的义务，就是说他必须要保证自己要确定他自己要有管辖权。这个怎么去理解这样的一个义务？这个义务并不是意味着在出庭的双方出庭的话就没有这样的义务，双方出庭的情况之下的话，法院和仲裁庭仍然有这个义务。所以这样的一个条约规定呢，如果你反对的解释来看的话，看起来他们要比在出庭情况之下，仲裁庭有更进一步的义务啊。但是问题就是说，违反这个义务的法律后果，在现行的国际法里面好像看不到啊。起码对这个仲裁员个人来说，没有责任的问题啊。甚至在这个裁决结果的无效的这个评价里面，好像也没有因为没有这个去确定他的这个管辖权就会产生这个无效的后果，在无效的这个原因里面并没有提到。但是我认为这是个自然的结果，就是如果他不去真正的履行这样的一个义务的话，会有一些自然发生的情况导致无效的原因出现。所以我们看一下这个案子里面，它的主要问题是什么啊？就是中国的这个管辖抗辩是有3点，对吧？这个我想大家肯定很熟悉，一个是主权的抗辩，一个是281的抗辩，一个是298的抗辩。我们要知道这3个抗辩是针对菲律宾所有的15个这个 submission 的，并不是针对某一个。但是我们看仲裁庭是怎么处理的啊？仲裁庭的话是在他的这个判决主文里面，实际上只处理了一个，就281的抗辩。对于主权抗辩的话，判决主文里面没出现；对于这个 delimitation 的抗辩也没有出现啊。但是主权抗辩呢，是在他的这个判决理由里面有一段153那段啊。结果呢，他反倒做了一个就是很有意思的一个这个管辖裁决。他认为菲律宾有7个诉求呢，它是有管辖的。对于其他的8个的话，它是放在这个实体问题里面看。所以我们来考虑一下，在这个阶段啊，这个仲裁庭是不是履行了相应的这个义务啊？一个从形式上来看啊，这个形式是非常诡异的一个形式啊。我引那个杰斯法官在这个过去的这个West Africa 的 case 里面在讲，他说在这个第1阶段里面，在先决抗辩这个里面，实际上原被告是倒过来的，这时候被告实际上提出他的问题，法院这时候只是在对于被告的这个先决抗辩来进行处理啊，而不处理原告的问题。但是这个我们看在本案里面的话，这个仲裁庭完全是倒过来的啊。所以这里面会导致一个什么样的副产物呢？就是在他实质问题里面可以看出来啊，他对他的这个所谓的有部分管辖的这个决定啊，他没有给出理由啊，所以他对那个7个管辖呢，只用一段啊，只有一段来说所谓的理由啊，特别是对那个，比方说在主权抗辩里面啊，这个他仅用了一段来处理啊。你如果是看他那个整体的判决一共有413段啊，或者做比较，没有比较就没有伤害嘛，那个你可以明显看出来他是在敷衍这个抗辩啊。那么在下一个阶段，就是在实体阶段，是不是他履行了相应的职责呢？看来也不是啊。所以从通常的这个诉讼程序来看的话，如果是有一个这个所谓 affirmative jurisdiction 啊，这个它大概呢会产生什么情况呢？会产生呢，因为它是个 judgment， 所以在第2阶段的话可能会产生既判力的问题，就是它对之前的一个肯定性的所有 jurisdiction 这样的一个先决问题的判决呢，它可能会将这个既判力赋予其后。但实际上，这个国际法院在处理这个问题时还是挺谨慎的。双方出庭的情况之下，我引这个之前的anyway，那么如果是在不出庭情况之下，不出庭情况的话，我们可以看这个冰岛渔案和这个美国和尼加拉瓜的这个军事和准军事活动案。 在这两个案子里面，法院在试题问题阶段仍然强调啊，它基于这个规约的53条，必须满足自己有管辖这样的一个义务性规定，所以它在实体阶段它仍然有一个 special care 啊。那我们这个南海仲裁是怎么处理的呢？它也强调啊，有所谓的special responsibility， 但是你要看它在另一方面对它的所谓那个就是7个肯定性的有管辖的那个判决，它仍然强调认为这个之前的这个判决呢，之前的这个先决问题判决呢是有既判力的，就把这个问题就结束了。那么对于另外的，他认为仍然需要再处理的这几个问题啊，这个主要是涉及到这个南海的这个有没有岛礁的问题。如果是有岛的话，如果是有一个这个具有200海里的这个岛的话，它所保留的其他问题它是审不下去了啊。但是恰恰在这个问题上啊，我们也可以看到这个仲裁庭实际上是做出了一个明显的违反这个条约解释规则的这样的一个解释。我想这一点的话，在学界里或者在国家实践里面，我想都是对这一点是质疑的。这一点的问题呢，实际上并没有出现在菲律宾的这个诉求里面，而是法院作为一个管辖问题来单独处理的。我认为他是必须要处理这个问题，但他恰恰在处理这个问题的时候，不仅是没有去 satisfy 他有这个决定管辖的这样的义务，相反呢，在试题问题里面是明显违反条约解释规则啊，达到了这样的一个指鹿为马的这样的一个结果。所以不管怎么样，就是法院在这个案子里面，不仅没有在条约的义务上，他要有一个明文的履行这个要确认自己确保管辖权的这样的一个义务，相反的，这个在整个审理过程里面，由于这个判决不给原因，在管辖的决定上面，以及在管辖决定问题里面明显违反规则，所以这将导致当然作为这个缔约作为这个国家一方来说的话，当然有可能出现就是所谓的判决无效的这样的主张啊。这个可能是唯一一个在仲裁庭没有履行他的条约上的义务的情况之下，可能这个给予当事国一方的可能的救济啊。所以这样的问题呢，可能不仅是在那个案子里面会出现，今后南海的仲裁案如果还有再次发生的话，法院仍然要考虑到，不管这个一方出庭还是不出庭，仍然要考虑到他必须还是要决定这样同样的这个管辖问题。所以这样的问题可能永远就是起码在现阶段来看的话对于这个南海仲裁的这个对于南海争端的话可能很难认为这个像菲律宾所指证的那样，就通过这个裁决解决了中菲之间在南海之间争端我简单汇报就到这儿，谢谢。
谢谢先生，谢谢，你的时间刚好。下一位，next speaker is Professor Warwick Bullets from the Australia Wollongong University. Mr. Bullock, you have the floor, please.
谢谢大家好，我的中文
说中文太好了。
等一下，一点点我的中文名字是翁大海，谢谢吴世谦教授你的邀请。对不起，今天我不在海口，但是我可以看到我像5个老朋友在那。OK， 现在英文，等一下share screen， 稍等一下。看到吗？Okay, so I've really enjoyed the talks today, going through the importance of history and trying to understand the application to the South China Sea and the resolution of the legal issues. And I'm going to try and take the discussion a little bit further and a bit controversially. So we've had a lot of discussion, really fascinating discussion about the rich historical material that is useful for China's position in the South China Sea. And I want to sort of pose a question, well, so what? What's the next step? So it is one thing to be convincing for the Chinese evidence for the Chinese. It's also important to be convincing to the other states would be, and that's the best way to try to work out a resolution to the sovereignty issues. Now we've had, it's great. There's a topic here is the reflections now, this time after 2016 on the 2016 award, and we know that almost the entirety of the award was negative for China. We've already heard a little bit about that from Zhou Keyan and Zhang Xiaojing, and I'm going to talk about something a little nugget, a little diamond in there in the 2016 award that I think is positive for China, and it ties in with some of the historical discussion we've had just before. So there are many sort of legal disputes, legal issues in the South China Sea, and I'm going to focus on the one that's the focus really for today of sovereignty, and the most difficult, and it underlies all the issues that we are looking at. Now, we know that the tribunal, Philippines in its pleadings was very careful to plead its case to not touch on issues of sovereignty. That's what it tried to do, and the tribunal accepted that and proceeded on that basis. We know there can be disputes of interpretation about that, but nonetheless, the tribunal was clear in its decision that nothing that it did, nothing that it said, even the maps it depicted, in no way is to reflect on issues of sovereignty, because that was clearly outside its jurisdiction. Nonetheless, there were some things in the work of the tribunal that discussed historical evidence that would be the same type of historical evidence that would go to an issue of sovereignty when it considered the completely separate issue of the status of the island features in the South China Sea. So the question I'm posing here is the tribunal's discussion of the historical evidence about the Nansha Islands helpful to China for the way the tribunal examined the evidence that would be used if we ever get to the stage there's going to be international judicial determination of sovereignty, which of course has to be by consent of the states? And should the path to peaceful judicial resolution of sovereignty be considered? I don't think the timing is right for that, but maybe later, maybe decades from now, maybe another generation, this will be a path that needs to be considered. So what happened in the award? Well, we've already heard from previous speakers, such as Professor Wong from Taiwan Shifan and Yang, about one of the aspects of the award was determining whether the islands there are fully fledged islands in accordance with UNCLOS Article 121, Part 3. Now, the methodology the tribunal adopted to determine that was to consider islands when it wasn't absolutely obvious they could sustain human habitation, to then inquire further and look at historical use and whether the historical record showed that those islands had been inhabited or not. So that historical evidence was considered for that purpose. I think perhaps incorrectly, especially typing Dal, but nonetheless, they looked at some of the historical evidence, and our previous speakers have gone through some of this, but not so much in the context of the award. Now, that historical evidence would be part of the picture of all the historical material that we needed if one day this goes to international judicial resolution, right? There's a whole range of other types of evidence, such as naval hydrographic surveys, naval patrols, maps, and so on. But historical use by people, especially fishers, is part of that story that can help build the case for sovereignty. So the tribunal, when you read these parts of it, it's actually on the positive side for China. A bit like the previous speakers had said, outside the context of this award, there's actually quite a lot of evidence that the people using the islands in, well over 100 years ago were predominantly Chinese fishers. In fact, Hainan Yuming, fishers from Hainan Dao. And so I've got some excerpts here. And of course, there's reliance on contemporary European records. And we've had an interesting discussion earlier by Professor Xu Xiaodong that we should also be considering more detailed records from Asia. So there's a number of little bits in the tribunal's award where it is documenting or it is commenting on the record that it had available to it And the majority of that, with the use of those islands, although in its opinion not being sufficient for habitation, but nonetheless, the majority of the use from a reading of the award was by Chinese fishers. Predominantly that from the British, also recorded by the French, although there are some other bits of pieces recorded by the French looking at fishers from other places. But it seems a predominant amount of information is that the where people came from who were using those islands the most was actually Zhongguo and Hainan specifically. So therefore, it seems that the record the tribunal considered here, if in a completely separate litigation that's eventually agreed to by the parties to go down that path, if that ever happens, there's more confidence that this would be resolved in a way that's satisfactory to China. So, of course, a lot of other evidence needs to be looked at. We've had early discussion about effectivities, but fishing practice would be one thing that would feature in any detailed examination to determine the vital question of sovereignty, if we ever get to that. So I would suggest this is a little nugget of gold in there in the award that actually supports China's position, but it was considered for a different purpose. So let's get to the hard part about sovereignty. And the way I see it, there's only 3 ways to deal with this most important issue in the South China Sea. One pathway that's been adopted by most states is largely trying to shelve the sovereignty dispute and to think, let's get past that because the actual island features are tiny. It's the resources around that are important. Let's put that aside and cooperate and manage resources that way peacefully. So that's great, but we know there are situations where that's not working and it's a hot issue. The only 2 options then are other claimant states to voluntarily agree to relinquish their claim. And that's also almost impossible to imagine for any state to willingly give up its claim, unless perhaps there's detailed diplomatic negotiations by officials that eventually persuade countries to do so. That would be wonderful, but I don't know how optimistic we can be about that in the short term. So then the only other pathway to finally resolve everything would be a judicial determination. And we've had a previous speaker talk about this pathway, and you might not be sure what you get, and there'll be a lot of issues to consider. All countries would have to agree on which islands would be the subject for a resolution. But I think with the award, we've got a little bit of indication that this path should be something that is considered seriously when the record builds up, whether one day this is done. So what small steps can be taken on this path? And we can consider this one example of great Chinese wisdom. 不计回顾，无以知真理；不计交流，无以长江海。谢谢。
谢谢，非常好。下一位是丁铎研究员，南海研究院法律政策研究所副所长，8分钟。
Thank you, Chair, and thank you for the organizers for having me to share my views on the South China Sea issue. My presentation will focus on the treaty interpretation and the judicial lawmaking approach, as well as the judicial activism of the South China Sea Arbitration Tribunal. So, in the past few years, the Academia of International Law has witnessed lots of hot controversies on whether there is a clear differentiations and boundary between the treaty interpretation and the judicial lawmaking. Although the rules and the customary international law for treaty interpretation has been provided in the Vienna Convention on the Law of the Treaty, International Court or Tribunal has a big discretion in interpreting treaties, which is an important reason for the difficulty in distinguishing the boundary between the treaty interpretation and the judicial lawmaking. Actually the function of the treaty interpretation can be divided into two aspects. So the first one is to clarify the meaning of the treaty text so that the rules can be properly applied. And the second aspect is to resolve conflicts between the different norms when clarifying the meaning of the text. Although sometimes the text of a treaty is clear and specific, there may be some ambiguities and controversies on how to apply the treaty in specific cases, due to which the court or tribunal often bridge the gap between treaty interpretation and the application through judicial activism. Since international courts or tribunals cannot refuse to hear cases on the ground of no legal basis, they may also proceed driven by the judicial activism and try to find some specific basis. So, for example, a judge or arbitrator may, at the stage of jurisdiction, shows a clear tendency to expand jurisdictions by ignoring the substance of the party's claim or by establishing a jurisdiction over the disputes without proper involvement of the interpretation of the treaty. And another example is that the arbitrator may, in the process of treaty interpretation, gradually exceed the boundaries and consciously or unconsciously enters the field of judicial lawmaking. So as we know, the predictability and the certainty of the rules of international law are important aspects of international legal order. So if an international judicial or arbitral body develops and deduces new rules for international law beyond the boundaries, it may harm the confidence of the states to the dispute settlement and break the expectation of the parties on the stability of international law. Some scholars pointed out that no matter how legitimate or inevitable, and even if the application of existing law is not satisfactory from the perspective of justice and common sense, judicial lawmaking should not be the normal way to improve the international law. So the core disputes, as we know, between China and some claimant states in the South China Sea are territorial sovereignty and maritime delimitation. The former is beyond the scope of UNCLOS and does not concern the interpretation and the application of the convention, and the latter has been excluded from the compulsory procedures by China's 26 declaration. So the tribunal of the South China Sea's ground in the award are questionable in fact and in law. And the most fundamental error in this arbitration is that the tribunal's exercise of its jurisdiction ultra vires and improper treaty interpretation, which will deepen the concern about the judicial activism. And in the process of interpreting the relevant norms of the UNCLOS, the tribunal did not proceed from the principle and as required for treaty interpretation, but to some extent play a role of judicial lawmaking. I would like to take 4 examples. The one of the is the in the jurisdiction award. The tribunal was the view that the dispute concerning the existence of the entitlement to maritime zones is distinct and independent from the disputes concerning the maritime delimitation. And they believe that by the 26th declaration, China only excludes disputes over maritime delimitation itself from compulsory procedures. So I won't go to the detail, but the tribunal's interpretation of relevant norms, especially in Article 298 of the clause, however, does not conform to the ordinary meaning of it. And another example is that the tribunal's rule in award on the merits, Article 311, should be applied to handling the interaction between the convention and the general international law. But if we look at the text of the Article 311 is about relation to other conventions and international agreements. So it's true that international agreements may assume a variety of forms, but whatever form it may be in, an international agreement contains only conventional norms, which cannot be taken as general international law, including the customary international law. So from this view, I think the boundaries for the interpretation and application are that the interpretation is not to modification or rewriting of a treaty. The fact of judicial activism by international tribunal body is in disregard of or even in violation of the basic principle of treaty interpretation does not help the settlement of the relevant dispute, but also harms the stability, integrity, and the predictability of the corresponding treaty system. When interpreting and applying relevant provision of the convention, the tribunal did so out of the true meaning of the text, so the context of the articles, and rewrote some provisions. This lawmaking activity will negatively affect the state's confidence to the Annex 7's arbitration and even the whole dispute settlement mechanism under the UNCLOS. So in the South China Sea arbitration, 4 out of the 5 members of the tribunal are from European, and none of from Asia, and the one from Africa has spent his better part of his life in Europe. So if we look at the 20 cases involving Annex 7 arbitration since 1977 and 1997, we will find that some people take the post of the arbitrator and the president of the arbitral tribunal frequently. So, and the authority of the treaty interpretation has been de facto concentrated in the hands of the few people. So in this sense, from the perspective of evolution of international law, much more attention should be paid to avoid the potential risk of judicial activism decided by the few people, since it's very easy for the practice to derogate the stability of the relevant treaty system and the authority of judicial means in dispute settlement mechanism. Okay, thank you, Chair. I stop here.
谢谢。下一位是高胜替教授，武汉大学国际法研究所，高老师。
好，谢谢易大使，谢谢吴院长的邀请，也看到很多老朋友线上相见，蛮高兴的。可惜有事情忙，没办法过来。好。Now I will present my presentation. Well, from first page, I will start from the first page and then jump to the page 6. Please, first page. Okay. Please, first page. So my topic is on the China claimed historical rights in the South China Sea, revisiting the South China Sea arbitration awards after 8 years. Okay, please turn to page 6. Because Professor Zhou Keyuan has been talking about 3 examples raised by the tribunal to negate the existence of China's, okay, here, the tribunal's review of China's conduct. As said by the tribunal, China does not have specific claim to historic title within the U-shaped line, apart from claiming relevant rights in the South China Sea formed in the long historical course. The tribunal deemed it necessary to look at 3 kinds of conduct for ascertaining whether China's claim amounted to historical title as follows. First, petroleum blocks away from West Philippine Sea. Second, China's protest against the Philippines petroleum blocks. Third, China's summer fishing ban. Next page. 下一页 OK. The first conduct was the notice of open blocks for petroleum exploration adjacent to the western edge of the U-shaped line issued by China's National Offshore Oil Corporation in June 2012. As said by the tribunal, the locations are beyond the maximum possible maritime entitlements China can claim under UNCLOS. The tribunal then concluded that China must have relied on some extra UNCLOS legal basis. Now, questions arise after reading other maps in the award. Located in the EZ from Vietnam's mainland coast, the CNOOC blocks are far away from the eastern part of the South China Sea, as the very disputed area of the South China Sea arbitration. Assuming China claims historical rights in Vietnam's EZ, such claim does not necessarily exist in the eastern part. Why then should the situation in Vietnam's EZ matter to what happens in the eastern part, or WPS? The tribunal gave no explanation. Next page. You see, the disputed area is the eastern part. Now, next page. 下一页. Figure 2 demonstrated the capability of China claimed EZ and continental shelf from the Spratly Islands as a single unit. Putting figures 1 and 2 together, one would see that the southern, if not major, part of the CNOOC open blocks could be covered by China claimed EZ generated from the Spratly Islands. Next page, 下一页. The tribunal cannot be absolutely certain that the locations of these blocks are beyond the maximum possible maritime entitlements China can claim under UNCLOS without determining the maximum maritime entitlements, including outer continental shelf China can claim from the Paracel Islands. See figure 3. The western part. This job was neither submitted to nor done by the tribunal. Next page. 下一页. You see, this is a Paracel Island. Reading figures 1 with figure 3, one would notice that the northern part of the open blocks is actually situated in the China claimed EZ from the Paracel Islands as a single unit. Next page. 下一页. An overall picture can also be offered by figure 4, which shows the locations of China claimed 4 islands group in the South China Sea, including the Paracel Islands or Xisha Qundao. So you can see the location of the open blocks is surrounded by the Paracel and the Spratlys, and could be covered by the EZ generated by Spratlys and Paracel. Next page, 下一页. Now, so no need for China to invoke historical rights to justify the open blocks. Figures 1, 2, 3, 4 are available from the 2015 and 2016 awards. It is very strange that the tribunal examined the figure 1 but ignored figures 2, 3, and 4. Next page. 下一页. Now, second example, China's protest against the Philippines petroleum blocks. The second kind of conduct identified by the tribunal for clarifying whether China claimed historical titles concern Chinese diplomats' objections to the Philippines award of petroleum blocks in the West Philippine Sea as follows. Only part of the blocks are indicated in figure 5. Now, there are 3 diplomatic protests made by Chinese diplomats. Now, next page. 下一页. With these in mind, the tribunal concluded that the framing of China's objections strongly indicates that China considers its rights with respect to petroleum resources to stem from historical rights. The tribunal considered the English version of China's note verbal invoking historical titles as a translation error or an imprecise drafting, because China claimed historical titles is at odds with the vast majority of China's other statements which invoked historical rights. Now, the question is, the tribunal's observation, that is translation error and imprecise drafting, is unfair and disrespectful because it deviated from the actual language. The actual language is historical titles used by Chinese diplomat. The tribunal once said it is a fundamental principle of international law that bad faith is not presumed. If every state must be presumed to have acted in good faith, it would be puzzling that the tribunal made light of China's own choosing of justification and words. It may well be that for all the years, only 1 or 2 incidents have occurred in the areas where China considered itself having historical title with which to protest. Next page, 下一页. The tribunal also said that much of the area encompassed by the 9-dash line would also fall within the claim to an EEZ or continental shelf drawn from the various features of the Spratly Islands. It is likely that the remarks of the adjacent waters of the Nansha Islands and deep within China's 9-dash line by Chinese diplomat actually denote China's maritime claims of territorial waters, internal waters, EEZ, or continental shelf. Just look at those nearby maritime features of Spratly Islands located in figures 5 and 6. Next page, 下一页. Looking at figures 5 and 2 together, one gets more curious about the award. China's diplomat invoked historical titles to justify their protests against areas 3 and 4 petroleum blocks. Service contract 58 block is to the east of areas 3 and 4, and thus farther from the big maritime features of the Spratly Islands. It seems reasonable that Chinese diplomats' invocation of deep within China's deep 9-dash line justifying protests against number 58 blocks actually meant historical titles as legal basis for protest. Next page, 下一页. The third example given by the tribunal is the 2012 summer fishing ban. Announced on May 10th, 2012, the ban applied to the South China Sea from 12-degree north latitude up to the common boundary line of Fujian, Guangdong Sea areas, including the Gulf of Tonkin under the PRC jurisdiction. The tribunal admitted that such a description is unclear concerning the source of China claimed rights to impose the ban for 2 reasons. First, it applied ultimately only to areas under the jurisdiction.
高老师，你还有2分钟。
Okay. First, it applied ultimately only to areas under the jurisdiction of the PRC, which is in most parts of the South China Sea, including Huangyan Island, Scarborough Shoal. Second, again, the area north of 12-degree could be almost entirely covered by China-claimed UNCLOS maritime entitlements if China were understood to claim an EEZ from Scarborough Shoal. Still, the tribunal concluded that instead of historical titles, China does claim rights to petroleum resources and fisheries within the 9-dash line on the basis of historical rights existing independently of the convention. Next page. Several problems surfaced after reading the same maps from the 2015 award. The eastern part of figure 3 and 2 provides the locations of Scarborough Shoal and the maritime features of the Spratly Islands respectively. These circumstances support the tribunal's own observation that China claimed EEZ generated by the Spratly Islands and Scarborough Shoal could cover almost entirely the banned area. On the other hand, the award provides no proof that China invoked historical rights to underpin the ban. It is unreasonable why China prefers using historical rights to the justification under UNCLOS legal regime. As China claimed nothing historical to justify the ban, in reality, how could the tribunal satisfy itself with the finding that China invoked historical rights? Okay, I hereby conclude my presentation. Thank you for your attention.
谢谢高老师。下一位是中美研究中心的研究员，是 Rabi Gupta。
Thank you, Ambassador, and thank you for the invitation for the organizers for the invitation to speak. I just wanted to right from the get-go back what Michael just said in his presentation right now, that many of those sea areas don't necessarily have, China is not necessarily claiming exclusive historic rights out there. Many of those areas could have been framed within the context of China's EEZ-based rights, and at that point of time, there was a dispute to be had. And the tribunal incorrectly made that assumption, and that's important because that comes into my presentation out here. What I'm trying to do out here is trying to merge a little of the South China Sea award along with the current politics of what's happening right now in that area, and therefore the title of my topic is the legal implications of the arbitration award on the current situation at Second Thomas Shoal and Scarborough Shoal. So it's merging a little bit of law and politics out here. There's no doubt, first of all, that in my view, I mean, blinker justice was delivered at The Hague in the name of, under the guise of judicial fair play. We've heard before in terms of that the court should not have found jurisdiction, but did find so because of its hocus pocus ruling in terms of Article 121, as a result of which it found jurisdiction to rule on a number of issues which it should not have had and should not have ruled. And among those issues include Second Thomas Shoal. That said, what I do want to say is that as flawed as the award was, there are elements in the award in terms of its ruling on Second Thomas Shoal and Scarborough Shoal that stand to benefit China, and that China should seek to build on those provisions and exercise law-bound management of the in-claim situation currently. And I'll come to those sort of proposed solutions.
Sorry, could you a little bit more approach to the mic?
Oh, okay. Oh, am I not? Okay, sure. Let me take the volume up a little bit out here. Are you hearing me a little more clearly now?
It's okay.
Okay, let me bring this a little closer to me. Okay, fair enough. I'll try to speak a little louder. It's just in the middle of the night right now, so I don't want to speak too loudly, and fair enough. There are two underlying premises of my talk, and that being that A, China is better off trying to come into compliance with certain aspects of the ruling as much as is practically possible. Because at the end of the day, forget what the US says or the West says, most of the ASEAN states go by the South China Sea ruling, and the ASEAN states are important parties. I'm not talking of just the claimant states, the ASEAN as a body, and therefore China has an interest in having that relationship go on good lines. And secondly, that there are elements that can benefit China out here. Let's come to Second Thomas Shoal. The primary finding at Second Thomas Shoal of the court was A, that it was a low tide elevation, therefore it did not have maritime zones of its own. There had been no fisheries interference by China in Second Thomas Shoal. There was no evidence that the Philippines provided, etc., etc. But the most important point, which I think supports China currently, is that the court ruled that the matter at Second Thomas Shoal was a dispute concerning military activities, and that had been excerpted out by China as part of its optional exclusions, Article 298 exclusions with regard to military activities. The Philippines had argued that China had interfered with navigation, etc., out there. But the court said it is not a case of whether China has employed the military, as so long as it concerns military activities, and there were Chinese military vessels in the outer periphery of Second Thomas Shoal, that this was a issue which fell under Article 298 and therefore should not be. Therefore, the award. Therefore, the court did not render what the Philippines wanted in terms of declaring it to be illegal activities, etc., etc. Now, here's what a proposed solution could be. Now, this is a low tide elevation for Second Thomas Shoal. Now, it's true in treaty law, and this challenges China's interpretation of low tide elevations to some extent. In treaty law is silent on the question whether a low tide elevation can be appropriated, whether it is a territory or not. As such, typically in jurisprudence, it is governed by rules and principles of that particular maritime zone in which it falls. Now, Second Thomas Shoal does not fall within the territorial sea or 12 nautical miles of any appropriatable feature. And that's why it therefore falls under the EEZ regime. And the EEZ regime itself is a derivative of rules that govern the seabed and the subsoil. And this goes back to codification starting from 1930 onwards by the League of Nations. And therefore, this effectively turns out to be a feature which is not appropriatable per se by anybody. So it's not territory. It cannot be anybody's territory. I know this runs up against China's view that low tide elevations could be appropriated. But this, what I would submit is that if it cannot be territory because it's in the EEZ and the EEZ is governed by the concepts related to seabed and its codification related to the EEZ, that if it's not territory, then this creates a basis for all the parties currently at Second Thomas Shoal to move out. And what would be the outlines of a deal? China gives a kind of an undertaking that it will not occupy Second Thomas Shoal, and China has not occupied anything since definitely since the arbitration award. The Philippines removes its warship, as it did at Scarborough Shoal in 2019, where it had grounded a ship out there. So the Philippines removes the ship, and that this understanding is guaranteed by key ASEAN states who are non-claimants, essentially Thailand, Indonesia. I know Indonesia says it's a non-claimant state, and Singapore. And that these countries, that these important countries in ASEAN serve as guarantors. Of course, one would say, why not the US being a guarantor? But we know in 2012 what happened at Scarborough Shoal, and I don't think the US, with its ties to Philippines, is in a position to serve as a guarantor. But this could be a solution that could be thought of. China says we will not occupy the shoal, Philippines moves the ship, and that this undertaking is guaranteed by those parties. And therefore, whoever violates this undertaking will also has to think in terms of its own relations with Singapore, Indonesia, and Thailand, 3 non-claimant states, but important ASEAN states. Let's leave Second Thomas Shoal aside. Let's come to Scarborough Shoal. Now, Scarborough Shoal was designated to be a rock, which means it is appropriatable, has a 12 nautical mile territorial sea. It is interesting as to how the panel arrived at the issue of traditional fishing rights. And it came to the point and essentially what it says, if one reads between the lines, is traditional fishing rights is a historic right. It is an acquired right which devolves to individuals and communities, not states, but is vested in the state. It can override conceptions of sovereignty and sovereign rights, but it can be exercised non-exclusively within the territorial sea of a coastal state. Now, the basic point they were trying to make is that this is something like like an easement, where easement is on somebody else's property, but one has a right on that property for certain activities. And in that regard, their traditional fishing rights for traditional fishermen, it continues to hold in the territorial sea of the Scarborough Shoal, which is in the effective control and jurisdiction of China. And what the arbitrator said was, China continues to maintain not just effective control, but can regulate, as long as it's reasonable regulation, fishing activities, traditional fishing activities in the Scarborough Shoal. Now, here is the solution thereafter. Why not extend what is there just in the territorial sea of the Scarborough Shoal for traditional fishermen to the entire South China Sea? I mean, the arbitrators themselves said that it would be commendable if that sort of an arrangement were worked out. The arbitrators said that in their view, historic rights were limited to just the territorial sea, and that with the coming into 1982 UNCLOS, that in the exclusive economic zone, that they could not exist. because there were specific provisions in the archipelagic.
Last 2 minutes for your conclusion.
Yes, I will end in a minute. Archipelagic regime and in the EEZs with regard to habitual fishing, so that there were specific provisions, and therefore traditional rights were now were extinguished in the EEZ. But the fact of the matter is, and we've heard this before at this meeting here, at the workshop here, in Eritrea, Yemen, the arbitrator said traditional fishing rights supersede all maritime zones. They can can be traditional fishermen have rights in all maritime zones. In the Chagos award in 2014, the arbitrator said that these rights, which are part of general international law, if they are available in the territorial sea, that they are that much more available in places like the EEZ. So there's enough international jurisprudence to suggest that a historic right, which is traditional fishing rights, can be extended out beyond the territorial sea to the EEZ. And therefore, I think one of the things that could be done and should be done is that same basis of jurisprudence at Scarborough Shoal, that there are traditional fishing rights which derive from other rules of international law, can be extended out to all fishermen of all claimant states in the South China Sea. And I think that would be one way forward, which will also give, frankly, by the back door, legitimacy to the 9-dash line as both a parameter of where China's land territorial claims are enclosed, and at the same time as a line serving as a de facto line for traditional fishing rights for Chinese fishermen. So I just wanted to leave it as that, just some ideas, and thank you again for the opportunity.
Thank you so much. 我们这个7位发言人哈，从不同的角度把这个政策啊 ，last one, anyone? Oh yeah, sorry. We have sorry. 你把它给对，然后就夹住就夹好。5分钟 ，5 minutes。王家人，说观点啊。
对，还没放大。
说短话很难。
Thank you, Your Excellency. My topic is on the determination of natural status of low tide elevations in the South China Sea arbitration.
Monday.
I will divide my presentation into 2 sections. The first is importance of natural status of low tide elevations in the South China Sea arbitration. We know that Philippines submission number 4 and number 6 are directly related to the issue of the determination of the natural status of the low tide elevations. And submission number 5, number 8, number 9, and number 12, number 14, these 5 submissions are derivative of the findings of the submission number 4 and number 6. To be more specific, if Mischief Reef is a low tide elevation, then submission number 5 will be true. And also the same case for submissions number 8, number 9, and number 12. On the other hand, if Mischief Reef is a rock instead of a low tide elevation, then China will have territorial sovereignty on the Mischief Reef. And then submission number 4 and number 5 will be failed, and the tribunal will also have no jurisdiction over submissions number 8, number 9, and number 12. This is the same case as to the second Thomas show. So we can see that out of the 15 submissions submitted by the Philippines, 7 of the submissions are directly or indirectly related to the status of low tide elevations. So it's a fairly important issue. Unfortunately, the tribunal in its final award only spent very limited paragraph on this issue. So unsurprisingly, the final awards on the determination of the status of low tide elevations have a lot of flaws. I will just point out 3 flaws. The first is the tribunal is ignorant of the fact that different tidal datum could lead to different results of the status of maritime features. As Professor Yoshifumi Tanaka of the University of Copenhagen points out, as the legal status of maritime features may be changeable depending on the tidal datum in borderline cases, the selection of tidal datum is of central importance. and there is no uniform practice of the choice of tidal datum in the world. We can see from this graph, a maritime feature will become a low tide elevation if a state choose HAT, that is the highest astronomical tide, but it will become a rock if the state choose mean high water. So it's quite directly, we can see from this graph. And we can see from this diagram that the choice of tidal datum in the North Sea area is totally different. For example, the choice of tidal datum of Germany is totally different from that of France. So let's see what the tribunal decide in the South China Sea Arbitration Final Award. It says that China used mean high water spring and mean high water, but the Philippines use a totally different tidal datum, which is mean high water. So what's the difference? The tribunal decides that ultimately, however, the tidal range in the South China Sea is comparatively small, and the selection of a vertical datum will, in most instances, make no differences regarding the status of the feature. But is that true? We see from this paragraph, cited from the International Hydrographic Organization's regulations, we see that if the tidal range is less than 0.3 meter, then the tidal range will be negligible. But in the arbitral award, we see that the Chinese tidal data in the South China Sea maritime area is ranging from 0.5 to 1.2 meter. And the British record shows that the tidal range in some part of the South China Sea is ranging from 1.4 meter to 1.6 meter. Similar as the Japanese records. So we see all these tidal range differences are much more than 0.3 meter. So the different choices of tidal datum cannot be neglected. And the second flaw is that the tribunal had used same material but produced contradictory results with regard to different maritime features. For example, the tribunal used the records, the survey reports from the HMS Herald during the 1930s, which shows that there is a 1.5 meter rock in the Mischief Reef. But the tribunal, for some unknown reason, disregard this material and says that it's not convincing. But you see, with regard to the Johnson Reef, the tribunal used the same record survey report from HMS Herald and decide that Johnson Reef is a rock instead of a low tide elevation. This is the same methodology used by the tribunal to tackle with the Chinese chart. Also, the tribunal used the Chinese Navy Sailing Direction, the 2011 edition, and they decided that the Johnson Reef is a rock, but the Mischief Reef is a low tide elevation. So we can see the tribunal had consulted to three same material, but produced different contradictory results with the Mischief Reef and the Johnson Reef. The third one is the ignorance of key Chinese contemporary materials, because we know that in the final arbitral award, the tribunal claims that it's impossible to determine the status of low tide elevations and other maritime features because the Chinese had already used land reclamation activities in this area. But the tribunal consulted to the materials such as the 1930s survey reports published decades ago by the British Navy or the US Navy or the Imperial Japanese Navy. So it seems that the tribunal cannot find any more contemporary, more recent records of those survey data. But I actually found the abundant evidence such as these two boxes. You see, these two boxes are, the first monograph on the physical geography of our country's Nansha Islands and its adjacent water based on the large amount of data obtained by the Nansha Comprehensive Scientific Expedition Team of the Chinese Academy of Science over the past 12 years from 1984 to 1995. And the other book is the first-hand data from years of investigation. So they should be more reliable than those reports, survey reports published by the British Navy decades ago. So they should be more reliable. But I don't know, for some unknown reason, the tribunal has not consulted with this kind of more recent, more contemporary, more reliable materials. I don't know why, because I only spent 4 Chinese yuan to purchase these 2 PDF versions from online book dealers days ago. And inside these 2 books, I found some clues to the determination of the status of Subi Reef, which is a low tide elevation determined by the tribunal, which I seriously doubt the result is true or is true. Because you see here, definition of reef submerged at high tide may have individual parts of reef not submerged even at high tide, which indicate some kind of reef can be determined as a rock instead of a low tide elevation. And here, joint reefs 1 to 2 meters high can be seen on the reef flats of Quaternion Reef, Subi Reef, Johnson Reef, and Gavin Reef. And interestingly, the other 3 reefs, that is the Quaternion Reef, Johnson Reef, and Gavin Reef, are all determined by the tribunal as rock, that is high tide elevation. Only the Subi Reef is a low tide elevation. So I seriously doubt the conclusion, the findings of the tribunal, because you see these 4 reefs are in the same description in this book, but the tribunal made totally different conclusions. I also consult the new edition of the China Sailing Directions. The most updated one is the 2022 version. Of course, the Philippines submission, it have the descriptions of the 2011 version, and you see many of the maritime features are described as low tide elevations. But you see, if in the 2022 edition, most of the text descriptions are revised. Some of you may challenge that all these revisions are post-arbitration. But if we look at the second Thomas Shoal, we see that there is a exposed reef at the southern end of the reef, which is 1.2 meters high, which will be high enough to indicate that the second Thomas Shoal is not a low tide elevation. And why? We know that over the past 25 years, second Thomas Shoal has been occupied by the Philippines. There's nothing to do with any Chinese land reclamation activity. So in my opinion, I fully trust the Chinese Navy's official publication, and we should interpret the new revision in good faith. So my conclusion is that the tribunal's conclusions, the findings that Mischief Reef, second Thomas Shoal, and Subi Reef are low tide elevations are highly questionable and could be subject to serious challenges. That's all for my presentation. Thank you.
差点没给你足够时间。我们刚才7位发言人啊，从不同的角度，草案的一些这个问题是吧？包括规则解释问题，特别是丁舵讲到311条，刚才我们包研究员提到低潮高力是吧？关于它到底有多高的问题，的确很少有人提这个问题，是吧？因为仲裁判决里面、裁决里面讲那个0.3米，是吧？我们都信了，但实际上不是这么回事，是吧？大量数据证明了这个问题，这也是个技术问题，是科学问题、自然的问题。时间很短，非常感谢我们7位发言者。看看大家有什么问题，10分钟。 是吧？我本来说6点钟准时结束，但是呢，考虑到我们在座的对这个问题都非常了解，可能还能贡献一些新的东西。大家有什么问题，或者有什么需要评论的？ The floor is open. 哟，都没有啊？是吧？
那个意思，
哎，
我讲一点，我也不是提问，我就是有一个评论，就是从今天上午从历史还有主权的那个观点看，包括下午很多老师们讲的这个呢，就是说这些历史档案呢，它包括这个包老师讲的这些，它不光是能够佐证主权的问题，不光是解决这个主权归属这个事情。如果只从这一个角度看，可能这些历史证据、历史资料的价值还没有得到最大程度的发掘。主权是一方面，但是不管是英法的档案，还是日本的档案，包括美国2战时期的一些档案，我觉得它在一定程度上也能够反映出这种群岛的整体性。就是不管是中国还是其他国家在看待这个南沙岛礁的时候，它从来至少在民国开始之后，从来没有说是从哪个单独的岛礁来看待这个问题，它一定都是从南沙群岛、西沙群岛这个方面来论述的，是把它作为一个整体。虽然可能范围上有一定的区别，有一定的差异，但是在对于至少是从主权方面的群岛整体性的认知这方面是有一致的，即便是在有一些争端当事国看来，它这个群岛整体性的立场或者说是看法也是一致的，所以这个可能也是这个历史档案或者是法律磋商过程中资料能够显示出来的一种佐证的价值。对。
大家有什么问题？没有了是吧？没有了，我说2句啊，最后做一个总结。这个吴院长最后要做一个，因为这个问题呢，既敏感又复杂，涉及到方方面面，历史问题、法律问题、政治问题、外交问题，是吧？但是核心问题，因为我们谈的还是一个，依法办事，就法弄法，是吧？那么这里面硬伤很多，是吧？硬伤很多，我们这个过去也找了很多，那么今天又发现了一些，我坦率来讲，就南海政治案这个裁决的评判也好，研究也好，不仅仅对中国有利，不仅仅对中国有利。我跟一些国际法学界，交流过，包括跟拼妥，是吧？问你怎么看这个问题？这个问题绝对不仅仅说，在中国或者在南海开了一个坏的先例，很可能被移植到其他地区去，是吧？因为全世界现在海上划界也好，这个岛礁争议也好，还有60多起，就是目前没解决的。南海这个案子，实际上就是说，很多人都在看，是吧？很多人都在看。如果就是这个案子成为先例的话，那可能整个把我们海洋法体系做颠覆，是吧？我讲的就是我们这个在座的，是吧？有这个义务把这个事情厘清，跟国际社会一个交代，这个坏案子不能再 repeat 了。这就是我的观点，谢谢大家。
Thank you. Now let's welcome Mr. Xi Jinsong, Vice President of the National Institute for South China Sea Studies, to deliver the closing remarks. Please.
谢谢。我呢就代表主办方中国南海研究院啊，这个简单说几句吧。待会儿还请我们老院长，我们创始院长吴世纯博士，他在做一个全面的、深入的一个总结啊。首先呢，我代表研讨会主办方中国南海研究院以及华阳海洋研究中心，对各位专家学者表示诚挚的感谢，感谢各位对我们工作支持理解，感谢各位今天对我们研讨会的积极的贡献。 今天研讨会上，国内外知名专家学者汇聚一堂，围绕南海诸岛的主权、南海历史档案的政治法律意涵、南海仲裁案裁决再评判等议题进行了专题研讨。通过挖掘历朝历代和国内外关于南海的史料，用无可辩驳的事实，从历史、法律的角度，再次证明了南海诸岛自古以来就是中国的领土。讨论还涉及了南海历史档案背后的政策思考和法律意涵，以及对南海仲裁案裁决等现实问题的再评判，其中不乏新的角度、新的观点和极具参考价值与借鉴意义的新的方案。许多内容值得我们今后进一步研究和探讨。今天的这些学术讨论和交流，不仅为我们南海研究工作提供了更加多维的思考方式，对与会学者也提出下一阶段的工作任务和学术挑战，也对推动南海地区的和平与合作具有建设性的意义。当今世界进入新的动荡变革期，南海也并非风平浪静。面对世界之变、时代之变、历史之变，我们南海研究工作者也需要在今后的工作中继续加强涉南海的历史、法律、安全、政策研究，努力推动南海问题重回对话协商解决的正确轨道，为各方凝聚共识、增进互信、推动合作，谋求南海的长治久安做出应有的贡献。再次感谢今天会议的各位嘉宾的精彩发言，特别感谢今天3个 panel 的3位主持人，郑若华大律师、沈顾潮老师以及易先良大使，他们的专业、职业、敬业的主持。最后呢，我也代表主办方也要感谢一下这个我们南海研究院和华阳研究中心的会议保障团队的辛勤付出和他们的专业的保障，谢谢。我现在把时间交给老院长吴世纯博士。
Last but not least, welcome Dr. Wu to deliver the final closing remarks.
Okay.
Thank you.
谢谢池雪啊，池雪表现很好，今天这个翻波登场，专门从香港赶回来帮我们来做这个事情。我首先表示歉意，我觉得我今天不是一个好的参会者，大家可能注意到我一会出去一会离开，其实这也不是我自己愿意看到的，我一般还是愿意坐在这听会的。这个媒体，这个怪我的同事老在给我自己也心肠比较软，一喊就出去了。有的从香港来，你像德国电视2台，这早上4个人从北京专门来，刚刚采访完了又回去了，当天往返，所以确实没有静下心来听会。但是，有一些欢愉的观点总结，事先拿到的一些 PPT， 我也有所了解，所以我还是要感谢大家，专门参加这一次会议，对本次会议做出的特殊贡献。我在想，因为今天，接受了几家媒体的采访，尤其是这个德国电视2台的采访，他说所有的采访对象都拒绝了，我是唯一的一个采访是接受他采访的。因为有关方面说他可能会不客观，我说不客观，他还能怎么不客观？我说我还是愿意接受采访。所以为了接受这次采访，因为他一定要中国展示出地图，中国你要拿出地图证明南海诸岛就属于中国的我说不需要地图证明，这些南海诸岛、西沙、南沙上面的这些庙宇、水井，甚至于坟墓都是中国渔民的。这就是证明，地图可能是事后来确认而已，但是我还是找到了一些地图，这个在沈顾潮老师还有徐晓东的帮助之下，我们一会大家可以看一看，就在隔壁图书馆里边，最早追溯到明代的1602年的利玛窦和中国的一个学者李之钊 河边的一个地图，还有1767年的清朝的地图，再有民国的，还有一些西方地图，还有一些照片，大家可以一会去顺便看一看。从这里面给我一个启示，我觉得今天因为我们的主题是研究南海的历史和法律，所以历史我觉得我们还有提升和改进的空间。怎么样我们的叙事能够为西方和整个国际社会所接受，包括周边国家，所以这是需要，因为可以从这德国电视2台，它有10几个题目，大家也可以去分享一下，就是他们的关系，他们的视角，我们感兴趣的，我们聚焦的研究问题，未必是他感兴趣的，未必是他能听得进去的，他媒体也不感兴趣，报道了也不会有人看，所以我觉得我们，你既然想让中国的历史叙事让西方人接受，让整个国际社会接受，甚至周边国家能够认可，哎，你这个好像说的还有一定道理，我觉得我们需要调整我们的研究方法，我们的叙事方式，我们的语境，这是我第一个启发。第二个，我觉得搞南海的历史，搞法律，有没有国际合作的空间？所以这次我们开会，我们也邀请了日本学者，不是这个越南学者，也邀请了菲律宾学者，最后越南学者以身体健康原因婉拒了啊。其实我认为他可能不太愿意到中国这个地方来给你大谈南海历史这个主权，这个我们追溯到几千年前就可以找到相关证据，不愿意来给你站台。我觉得这是可能是个主要原因。菲律宾也有其他学者，这个玛丽莎还是来了，但是他也不是代表菲律宾来，他是一个人学者，在荷兰的一个博士后他来的。但是我们邀请了其他菲律宾学者，他也以某种方式婉拒了，我觉得也可能是这个考量，不愿意给中国来大谈南海的历史，来给我们站台。所以这就给我一个启发，伸索国之间在历史问题上面有没有合作的空间？我觉得是可以的啊。13，你说是不是？你从马来西亚，你在看水有没有合作空间？我觉得是可以交流意见的啊。你可以这个我愿意假设啊，你说我这个好像
计划可能可以多一点这种 interdisciplinary research，
对，
历史啊或者地理啊这些这样的方面，
我觉得是可以交换看法的。假设越南他要搞一个越南拥有什么长沙、黄沙历史主权的历史为主题的学术会议，邀请我觉得我愿意去的。是可以去的，也是那我知道他的这些历史证据从何而来，这之间有没有真伪的地方，需要可以交流意见的。菲律宾也同样，我记得2012年黄岩岛事件之后，我在香格里拉对话曾经给菲律宾的当时的国防部长有一个 session， 就是讨论黄岩岛问题。我当时就收集了一些地图去看，我给他的国防部长看，我说这是你自己出版的地图啊，好像黄岩岛不在你的国界线以内啊。我认为是可以，就是在历史问题上面，南海的法律问题上，伸索国之间也是有合作的空间的。所以这是给我的第二点启示。另外，我想南海问题现在麻烦越来越多，尤其是中国面临的挑战越来越多。我上个礼拜还在美国，那么菲律宾提起新的仲裁应该是一个大概率事件。仲裁裁决8周年7月12号又很快又到了，我估计国际社会美国、菲律宾、日本肯定会借这个机会要发声。再加上菲律宾前不久又提交的外岛拉教主张，这个覆盖了大半个南海。所以中国在这些问题上面临挑战会越来越严峻。另外，南海现在博弈已经从外交政治到了军事安全领域。所以从二轨交流的视角来看，我觉得我们需要学者要聚在一起今天有一些周边国家的，也有域外国家的，我觉得需要更多的这种二轨对话。我和美国人之间2014年搞了一个中美，这是1大使，第一次是他牵头的，和美中关系委员会主席欧仁士，后来交给我来牵头，但这个机制我一直维持下来了。 现在我们约定，因为美国学者不太愿意来中国，中国学者去美国签证也不是那么容易办。但是呢，确实中美之间在南海问题有很多事情需要沟通和交流。我们约定在7月底要搞一次中美线上的阿轨对话。另外，我觉得其他方式的中国和东盟国家的类似这样的一些对话，我们需要更多的来沟通。至少我认为可以彼此了解各自的立场和主张，我们的分歧在哪？在问题解决不了前，我们能不能像中非之间有没有办法把两家的对峙把它降温降下去？那么防止冲突升级，防止引发更大的危机。我觉得这是可以从阿轨先谈起的。一轨他说不了太多话，一轨念稿子讲完了口诀以后没有太多话，但是学者我认为有很多说话的空间，讨论的空间，了解各自的立场。另外，学者我们通过对话以后，可以向有关军事部门提出我们的建议来管控危机。所以从这个意义上讲，后面南海研究院也好，我这个牵头的华阳海洋研究中心也好，我们会有更多的各种形式的阿轨对话和交流。今天在座的各位，我相信都是未来我们邀请合作的对象。所以最后再次感谢各位的贡献和耐心，坐在这里一天也是不容易的。一会我们晚上吃饭给大家稍微放松补偿一下。再一个，我们还有一个翻译老师团队啊，这个他们是在这次是在线上翻译的，我也听了很多，他们也是一听在线上，但是的工作量是一样的，也感谢线上的2位翻译老师。再一个，我们的工作团队陈萍萍率领的，再次感谢啊，谢谢大家。
好，谢谢大家参加此次会议正式结束。Thank you for everyone participating in the conference, and today's conference is officially ended now. Thank you. 晚餐还是在与中午一样的餐厅用餐。The dinner will be the same location as the lunch.